Okay, we live.
Okay, thank you. Good morning, everyone. I'd like to call to order this public hearing meeting of the Judiciary Committee for March 31st, 2021. Is there any comment before we begin? Is there any comment from Co-Chair Stafstrom or Ranking Member Fishbein?
I just want to be the first to publicly embarrass Representative O'Day and wish him a happy 65th birthday.
Thank you, Chairman Stafstrom. Representative Fishbein, anything?
No, thank you, other than to share those comments, and happy birthday, Tom.
Thank you, and I'll add in happy birthday, Representative O'Day. Okay, we're going to start with the Commissioner of Corrections, and I believe he has some of his staff with him, so I'll let him introduce those individuals when he begins. Commissioner, you have your time. You may begin.
Good morning, Senator Winfield. I do have with me, I have School Superintendent Veron Bueller, Warden Derek Molden at MYI, and Derek Trina Sexton out of York CI. I will be the one speaking and have them just in case I can't answer any of your questions at the end of the questions session.
Thank you.
So good morning, Representative Stafstrom and Fishbein, Senator Winfield, Kissel, and members of the Judicial Committee. I am Angel Quiroz, Commissioner of the Department of Corrections, and I'm here today to speak concerning House Bill 6667. As member of the committee may know, I serve on the Juvenile Justice Policy Oversight Committee, JJPOC, along with other members of my staff. DOC opposes Section 16 of the bill, which will prohibit the use of chemical agents for the youth population who have committed crimes that resulted in a period of incarceration in adult correctional system. The chemical agent is only utilized after all measures of verbal interventions have been exhausted and have failed. It is considered a tool to avoid using authorized physical restraints to diffuse a violent encounter, protect individuals under our supervision, or minimize force. As a reminder to the committee, chemical agents were originally introduced to correctional settings to avoid having to engage with physical contact. There are limited numbers of DOC staff authorized to carry and use chemical agent, both at Manson Youth and York Correctional Institution. This is typically reserved for supervisor and a small number of key correctional posts, which have been carefully identified as first responder, likely to be first on the scene at any emergency. Our policies and procedures associated with chemical agents include a decontamination process as soon as the control of the incident is achieved. All such use are reviewed by the warden, and I want to be clear that I only support use of chemical agent in a very specific scenario, and I monitor the data on a weekly basis. For example, the most recent use of chemical agent at Manson Youth occurred a month ago in late February during a melee involving 8 youth. The significant incident resulted in 3 of my staff seeking medical attention to an outside hospital. I must caution that losing this option altogether during a significant incident will increase injuries to the youth and to our staff. It will also likely result in more of my staff being out on workers' comp due to injuries which could have been avoided. In a recent survey by Correctional Leaders Association revealed that several states function like Connecticut, authorizing use of chemical agent in appropriate situations when managing the youth population serving a court-imposed sentence in an adult prison, including Georgia, Ohio, Pennsylvania, Rhode Island, South Carolina, and others. I would also like to flag to the committee that prohibiting the use of chemical agent will be a significant change in the working conditions of 2 of my collective bargaining units, which are currently under contract negotiation with the state. I anticipate that either or both unions will file a prohibited practice complaint with the state labor board or sue in Superior Court for an unilateral change of their working conditions. I want to stress that the Department of Correction continues to focus on training opportunity to enhance employee interpersonal communication skill. Newly developed de-escalation training is being rolled out with our parole and community service staff, with plans to expand those working inside correctional institutions. These efforts are aimed at diffusing the incident.
Commissioner, for 1 second, how much more do you have?
Just 1 paragraph.
Okay, go ahead.
Yeah. These efforts are aimed at diffusing an incident at the front end before a decision related to the options such as chemical agent even have to be considered. As a voting member of the JJPOC, I look forward to continuing our collaborative work to improve outcomes for the justice-involved youth in our state. Thank you for your time, and I'm happy to answer any of the committee's questions.
Thank you, Commissioner. Comment or questions from members of the committee? Comment or question, Representative Fishbach?
Thank you, Mr. Chairman. Good morning, Commissioner Quiros. Nice to see you again.
Good morning, Representative.
You being a voting member on the JJPOC, can you just, the procedure by which this 54 pages of proposed legislation came before this committee, were you part of that process?
I was not part of the process, but Warden Molden, who's my designee, was in one of the work groups that in this process. So we were part of the process with the chemical agent, and that was Warden Derek Molden out of MY.
Okay, so your designee was just part of Section 16? Is that
The work group.
yeah, the
Correct.
work group? Okay. And
Can I interrupt for a second, Representative Fishbach, just to clarify? So the JJPOC functions with several work groups, which not everyone is a part of. Then they bring those recommendations back to the full committee where it's discussed and then ultimately voted on. Proceed.
yes, thank you for that. And that, yes. And ultimately, the work of the work group that had to do with Section 16 submitted the doings of their group, as well as the other work groups, which collectively became the documents before us. Is that's fair to say that's the process?
Correct.
That's good. Yeah.
Okay. And then the group in its entirety votes upon the 54 pages. Is that the procedure?
That's correct. Recommendation.
Okay. Well, recommendation to whom?
As a voting member in the JJPOC, I get the opportunity to vote on all the recommendations that have been brought forward in this bill.
Okay, so I guess the characterization of recommendation, recommending to this body to adopt the 54 pages as legislation. Is that what you're saying?
Correct.
Okay.
Correct, Representative.
And were all of the members supportive of this language in its entirety?
I'm trying to recollect. I must say Section 16, I voted against it. There were other members that voted against it, but the majority of the body voted in favor.
Okay, when
Section
you
16.
say, okay, so what I had envisioned was it comes together, it's one document, and then there's one vote on the entire package. Is that what happened, or was there votes on individual sections?
Individual sections.
Okay, that comprise the document before us.
Correct.
Okay, so
Yes,
that's
sir.
a little bit different procedure. I don't really intend to drill down about procedure. I'm just trying to get to how we get here. So each work group submits their product to the committee, and then the committee votes on that work product to become part of the ultimate document.
Yes.
Okay. And then is the ultimate document, is there another vote to say, okay, this is the package that we've come up with together, and we're going to have one vote on the entire package? Does that happen?
I am not sure about that portion of the question.
Okay. Is that because your designee was part of that process?
No, I'm just trying to recollect the times that we met with the JJPOC and the times that I have voted. And I have remember voting individually for the recommendations, not together as the entire package.
Okay. Are there any other portions of 6667 that you are not comfortable with, or you don't think should be adopted by the legislature?
We support everything except Section 16.
Okay. All right, that's all I had. Thank you, Mr. Chairman.
Thank you, Representative Fishbach. Comment or question from members of the committee? Comment or question? I want to ask Commissioner, same question I asked in the JJPOC. You obviously stated your opposition to Section 16. and you stated that several states function like Connecticut, that my understanding is it's a minority of states, 15 or less, and that most states.
Frozen.
Let me jump in. We appear to have lost Senator Winfield's video connection.
Don't. Can you hear me?
Now we can. We lost you there. We lost you at the point. I think you were going to say that a minority of states allow for the use of chemical agents.
Yeah, that was what I was going to suggest. And I asked the question, given that and what was represented at the JPOC, which to my mind, and please correct me if I'm incorrect, was that we would not be able to function if we followed along with the majority of states. Why is Connecticut different? And have you looked at the states that, which are the majority, that do not use these chemical agents, about what they do in place of having chemical agents?
So you are correct that there's probably 15 states that does utilize a chemical agent with juvenile offenders. The majority of states that I talk with are agency that have dual status, meaning they have sentence and accused, and they're under their custody. Some states do function without them. My position has been, as I testified before in the JJPOC, that you take a look at Connecticut. CSSD does not utilize chemical agent with their juvenile offenders in the detention centers. My position is that the individuals, the kids that are coming under my custody jurisdiction, their charges are more severe, and they have the potential for continuing to commit harm and victimize people inside our correctional facilities. And I also testify at the JJPOC and recently that recently I had a staff member that was sexually assaulted at NYI that I'm still trying to work with the individual to bring that individual back. So these individuals, they are kids, they are 15 to 17, but based on the charges of the crime, there's more potential for violence.
Thank you for that, Commissioner. And I think that conversation you just engaged in was as compared to CSSD, correct?
Yes.
Yeah, but as compared to other states, they have, if we are to take your point, they have individuals who are using your language equally as violent, but they don't use chemical agents. And my question is, how are they able to operate dealing with those equally violent individuals in a way that Connecticut seems to not be able to? Have you researched that, and do you know?
I would have to take a bigger dive and reach out to those commissioners. The information I got was based on SurveyMonkey out of the Correctional Leadership Association. We asked the questions to all 50 states of if you have juvenile offenders, and these are the ages of juvenile offenders, 15 to 17, incarcerated inside an adult prison, do you utilize chemical agent? And those are the answers we came back. I'll have to take a bigger dive. It'd be interesting for me. If they don't use chemical agent, what are the workers' comp numbers? Are they skyrocket? Because besides training and trying to de-escalate a situation and providing these kids an opportunity to meet in a circle and discuss their issues and try to resolve their issues without physical force. Once we get on scene and the verbal intervention stops, then the next step, if we don't have chemical agent, is to use force. Now take the incident that I just had in February with 8 offenders, 3 of them were youth for offender, walking up to the school area in the hallway, decided they were going to start a fight. It was a beef between them kids, 1 kid from Bridgeport, 1 kid from New Haven. Now I have 8 youthful offenders fighting in the hallway. And what brought that situation to quickly under control was the use of chemical agent. And I still resulted in 3 staff members being injured and going out to outside hospital. But that's a bigger dive for me to take, because I'm more interested to see those workers' comp numbers and the injury sustained not only by the staff but also by the kids that are under the custody of those jurisdiction and other DOC.
And thank you for that, Commissioner. And let me just state, because I know sometimes I come across as not friendly, but I think you and I have a very good working relationship. So if that's how I come across, I don't want to come across that way. But I will repeat what I said at the JJPOC when we had an exchange very similar, that if you are going to hold a position that you're in opposition, and largely it's because of the danger that is inherent in not operating under this policy, it would be my hope that the department would, and even before you were there, would know the answer to the question I just asked, right? Because that's important to figuring out whether your opposition actually makes the level of sense it seems to make, right? Because given that these juveniles are, as per your testimony, so dangerous, they're equally as dangerous in other places, and they're figuring out how to operate. And so if they can figure out how to operate, and it's the majority, and let's talk about the way that the criminal justice system is operating in our country. It's not like we're just saying, well, writ large, we're going to let the most dangerous people do anything, right? So likely if they were as dangerous and causing the number of workers' comp cases that you're suggesting they may, there would be something moving us in the opposite direction. And so it's just my hope that the next time I ask this question, we've at least begun the process of looking into what those other states are actually doing, because I think that informs us in a way that we need to be informed. And I see that Representative Fishbein has a comment or question. So if you want to respond, you may. If not, we'll move to Representative Fishbein.
Point well taken. I think that we have a great working relationship, and I understand where you're coming from. I understand where your heart is on. I understand the purpose that you serve as a senator representing the city of New Haven. I just come with my expertise with correction. I'm responsible to maintain a safe environment for the individuals under my custody. I've always indicated I want to be at the table with criminal justice reform and make changes, but I need to make changes that are going to be good changes that are going to maintain the safety and security of the individuals under my custody and staff. Because if not, and I end up like New York City, I'm going to be in front of another panel. And this time, the commissioner is going to be explaining why is there some uptick in violence inside a correctional, Connecticut Correctional DOC. And if you're monitoring what's going on in across the DOC systems, and just in the last 2 weeks, we had two deaths in Iowa where a nurse and a correctional officer were killed. You just had a hostage situation over the weekend at Oklahoma. You know, as a commissioner, I need to prepare for the worst case scenario. And all I'm asking is for the necessary tools so that I can maintain a safe environment. I want to make changes. I want to move away and get to that point where we're at zero with chemical agent. The warden knows that any chemical agent used to force, and I'm asking questions, that he's asking questions. The staff knows that, you know, so well. But I will take that deeper dive into those other states.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. A different topic. I appreciate the discussion here. Commissioner, I had asked you if you were okay with the rest of the billets before us. And do you have it in front of you?
Yes, sir.
Okay, if I bring your attention to line 1088, which is on page 36.
Yes.
Now, this section 12, has to do with when a juvenile who's arrested for a crime, that matter can be transferred automatically to the adult docket. Is that fair to say?
Yes.
And by virtue of section 12, we are reducing the amount of crimes for which one can be arrested and go to adult court. Is that fair to say?
Yes,
And specifically in line 1094, presently a Class B felony, there's an automatic transfer, but that's being removed. Is that fair to say?
correct.
And why are you in support of that?
So being a product of growing up in the inner city, witnessing the poverty, the crime, the violence, is my belief as a citizen of the state of Connecticut and as a commissioner that many of these youthful offenders that are coming into my system to serve time on these type of sentence, within 20 years, they're going to be back out in the community at the early age of 30, 35. They're going to be back out into the community. It's my job as a commissioner to work with these individuals so that when they go back out, they're productive citizens of in the state of Connecticut. With that true program that we have at Cheshire with the brain development from the age of I believe it's 18 to 24. These are kids making adult crimes, and I do want to see these kids coming into my system, serving their time, and back out in the community and being productive. So that's the reason that that as a commissioner and growing up in the inner city, if I want to make change to the system, language like this is being introduced is something that I need to support, so that these kids have a second opportunity when they get back out into the community.
Okay, so, taking B felonies out, for instance, manslaughter in the second degree with a motor vehicle is a Class C felony, which is, presently, if a juvenile is charged with that, there's no automatic transfer. But you are in support of, even on, it appears, multiple arrests, to lower the bar on the automatic transfer of these cases.
Yes.
And just to be, manslaughter in the first degree with a firearm is a Class B felony, which, I think is a serious situation, quite frankly. I guess it's a comment about society that somebody would be charged with something like that. I mean, manslaughter in the first degree is a Class B felony. So, the legislature sets public policy, and public policy says that somebody who's charged with manslaughter in the first degree is going to be tried as a juvenile. I have some issues with that. I understand your intent, and I share that intent, that incarceration has some rehabilitative aspects to it, and it should be. And I can tell you that I've personally experienced that, where a young man went into prison, and I didn't find him to be very trustworthy prior thereto. And he's been out for a year, and I've had the opportunity to speak with him, and he looks me straight in the eye and shakes my hand, and a nice, a firm handshake. He's grown. I think he's gotten skills, and that's through the prison system, actually. So I do understand both sides of this, but lowering the bar here, I've got a lot of problems with. So I don't know if I'm the only one, but thank you, Commissioner. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question for members of the committee? Comment or question, Senator Champagne.
Thank you. And this is to the commissioner. You know, I think I'm on the same path here. The lowering of the standards for automatic to the courts. Corrections does a pretty good job of training some departments in regards to gangs. Is that correct?
Yes.
And do the gangs take advantage of laws like this in determining who actually goes out and commits these crimes?
It could.
Yeah. And if all of a sudden we're not going to transfer these cases and they stay in juvenile court, and would the gangs take these younger people and have them go commit the most serious crimes?
There's a possibility, yes.
Well, you say possibility, but I've been around law enforcement for a long time, and I know this is basically standard. And you know, I have a problem with that. Can you tell me how difficult is it? And I know you're with corrections, but how difficult is it for a juvenile to actually end up in prison?
Oh wow, how difficult it is there's a lot of prevention programs, diversionary programs that individual will go through. If they end up in my front door, I can guarantee you that there's been multiple arrests. There's been multiple interventions. There's probably been some DCF involvement. There's probably been CSSD interaction and even detention in CSSD. And then they end up in the Department of Correction with the most serious charges.
Right. You know, I want people to understand in the state of Connecticut, it is very difficult to get into prison. And as a juvenile, it's even more difficult. But when we take these serious crimes and we start talking about gangs, and gangs use our laws, and they'll use our young people to go out and commit these serious crimes. And if we allow them to go in and out of the system, they will be used again, because you know the gangs don't care. And you know, as far as the chemical agents in the prison, I mean, sometimes when you're controlling a situation, that is the best use of force, because it is one of the minimals. And, you know, we're talking about use of force across the state of Connecticut, and, you know, taking away one of those tools is just wrong. You know, we want to use the least amount of force necessary to take and control a situation. And when we start taking those tools off the tool belt, you know, it makes it so that we're using tools that can cause more injury. So I support you on that. And I'm going to leave it at that. Thank you.
Thank you, Senator.
Thank you, Senator Champagne. Comment or question from members of the committee? Comment or question? I do not see any. Commissioner, thank you for joining us again and offering your testimony. Hope you enjoy the rest of the day.
Thank you, Senator. Thank you. Goodbye.
All right. Have a great day. Next, we have Natasha Pierre, followed by Joe Fetcher, followed by Bill Tattleman. Is Natasha Pierre in? Natasha Pierre.
Yes, I am here.
All right. Good morning.
I thought I was number 5, so.
You are.
Okay.
But the commissioner and his people were 1 through 4. So.
Oh, okay.
You are up.
Okay, so I actually submitted written testimony on 6667, opposing section 12 and not particularly in favor of section 21, but offering some alternative language to make sure victims' rights are fully addressed in that if you continue with that section. But I'm here primarily to speak to House Joint Resolution number 366. November of 2021 will mark 25 years since the overwhelming support, passage, and adoption of the Victim Rights Amendment to the Constitution of the State of Connecticut. The VRA was a promise to crime victims that they would have a meaningful role in the criminal justice process. While that promise has been realized for many crime victims, many other crime victims have experienced violations of their state constitutional rights. As currently written, the prevents crime victims from seeking redress through the courts to address a violation of their rights. House Joint Resolution number 366 is the first step to rectify this barrier for the enforcement of crime victims' state constitutional rights. The Office of the Victim Advocate has assisted hundreds of crime victims to exercise their rights and have represented and advocated for many more when alleged violation occurs. Although a successful outcome has been achieved for some victims, for example, the post-conviction issuance of an order of protection or order of restitution, many victims are faced with a hollow apology and no further recourse for the violation of their rights. The lack of enforcement of crime victim rights often leads to frustration, lack of confidence in the criminal justice process, and ultimately re-victimization. Some crime victims have attempted to hold prosecuting officials accountable for the violation of their rights with the filing of formal complaints with the statewide grievance committee, the Office of the Chief State's Attorney, District State's Attorney, and the Judicial Review Council. The OVA is not aware of a single complaint by a crime victim that has led to disciplinary or any other action by these entities. Crime victims have gone to the highest court in the state, in State v. Skipwith, and the Supreme Court acknowledged that a crime victim's rights had been violated. However, it could not address the issue due to the barring language within the Victim Rights Amendment and recommended the legislature address this issue. It has been said that a right without a remedy is no right at all. Crime victims face constant barriers to exercising their rights, and if their rights are violated, crime victims have no recourse to address this violation. As I said, this will be the first step in opening the door to victims being to address violations. And many are concerned it would hinge on defendants' rights. It will not. The federal government and several states have ways to address crime victims' rights violations without changing the defendant's sentence or any negative or violating any of the defendant's rights. And that's, so I urge your support of this. Again, this is the first step. How, what enforcement will be made is up to the legislature. But until this is taken out, there will never be an enforcement mechanism. Thank you.
Thank you, Senator Champagne.
Thank you. Natasha, thank you for coming in today. And a question that I do want to ask in relation to a lot of the bills, actually. But specifically, do you see that the victims are losing more rights as we continue on through the process with these different laws?
Absolutely. They're losing rights because the whole victims only have rights through the criminal justice process. So if a crime is committed to them, they can go to the adult court where the crime is held or juvenile court. They have different rights, less rights in juvenile courts, but they still have rights, the essential rights. But once you start diverting these outside and saying we're not going to arrest them for or put them within the any criminal justice system, you take away that right. And some of these offenses in like in section 12 of 6667 are speed felonies, that's sex assault. That's rape. And you want to say no going to jail at all, no court case, no anything. If the person needs restitution, no restitution. So yes, by diverting it, you do. And the alternatives for crime victims in these diversion efforts have been, oh, they'll address victims' impact and concerns. We don't know what that is. They'll come up with some plan to address it. We have a plan. We have the rights right here. Make those work. But then, even if you do that, even if you try to, victims have no rights at all because it's not within the criminal sector. So they're based on the goodwill of whatever organization this case goes to treat them fairly, to somehow deal with restitution and enforce that, to somehow make sure they're protected from harm if they need a restraining order. All those things can't happen unless we are in court. So just by diverting them, you're taking away crime victims' rights, and the solutions offered are not suitable.
I agree with you, and you know, through a lot of this process that I'm watching happening this year, I'm really concerned about the victims because I feel their rights are second class to everything else that goes on, and I think it's forgotten throughout this process. And we're making it worse as legislators as we continue to pass more and more laws. Continue your fight for these victims, please.
Let me say this.
Go ahead.
Legislators are doing a great job on providing services to crime victims, and I think that's why we miss what happens with the court process piece of it. We provide services to fix the harm done. We might provide restitution. We provide them the ability to file a sexual assault case years after the fact, but then we want to exclude them from the courts or belittle or say that assault now is not a felony. So we don't even want to address the courts. So, you know, it's a balance. Crime victims' rights need to be looked at in the criminal justice reform too, as to how to maintain them and keep them better, not exclude them. That is not reforming a system. Thank you.
And I agree with you on that. And I'm hoping that more victims step up and get involved in the process on the legislative side too. Thank you. Have a good day.
You too.
Thank you. Thank you, Senator Champagne. Comment or questions from members of the committee? Comment or questions? Representative Fishbaum.
Thank you, Mr. Chairman. Hi, Natasha.
Hello.
Natasha, I've had experience working with your office through the court system, and I have to say that, very reassuring many times to victims, and, very worthy aspect of our court process, especially in domestic violence cases. We just need a shoulder to lean on. But the aspect of removing the Class B felonies from automatic transfer, can you speak? I mean, you mentioned some of the sex crimes, and that's very disconcerting to me that the body that created this legislation and voted in favor of it is apparently okay with those sex crimes not being automatically transferred. Do you have, by any chance, a list of the sex crimes that fall under felony B status? It would be by section.
Yeah, in my written testimony, I list them, but they include serious manslaughter first, assault first. I don't have all the list of sexual assault offenses, but there are several. Burglary first, robbery first, and robbery first.
Okay. All right. Thank you. I just didn't know if you had that handy. So thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from members of the committee? Comment or questions? If not, Ms. Pierre, thank you for joining us again. I hope you have a great day.
You too.
Joe Fetcher, Bill Tattleman, and Barry Chasen. Joe Fetcher.
Good morning. Thank you. I'm here today as a victim. On February 20th, I found two in my garage trying to steal motorcycles and stuff. Ended up with a gun to my head in my driveway. As I was interviewed by both the troopers, they reiterated numerous times that they know they're going to get away. They're going to get away with this. There's not going to be any repercussions. I just wanted to voice my opinion that current legislation needs to be firmed up for these kids. Two of them were adults. Their trial is still pending, and I just wanted to voice my opinion as a victim. Thank you.
Thank you, Mr. Fetcher. Comment or questions from members of the committee? Comment or question, Representative Fishbein?
Oh, I'm sorry. Hi, Joe. Thank you for coming here today. Can you just tell me, do you know more about the situation involving, I expect they were, when were they arrested? After the incident?
Right after they actually intentionally rammed the trooper. So they were quickly apprehended by Troop C. This was in Tallinn.
So they rammed the trooper with their vehicle?
Yes, there was 5 of them in the vehicle. They fled. The troopers apprehended them within probably a half hour of the crime. They had been up on the parallel road to mine trying to steal a car. They were unsuccessful there, so they came around and saw my door open. So they were basically going shopping for places to go steal stuff.
And what time of day did this happen?
This was 2:30 in the afternoon.
Okay.
On a sunny Saturday.
And do you know what, children are arrested, brought to the station. Do you know what happened? Were they released to their parents? Do you have any information for us about that?
I don't have information on the 2 juveniles. One was 17, but they released his name. He's already out on bail, and the other 2 are being held right now.
Okay.
And
the
I
other
believe
two
they're 18 and 19. They're adults.
Okay, so it's a mixture. There was 5 in total. They couldn't
Yes.
find the other 2.
They found them. I don't know the names. They're juveniles. I don't know their names. I don't know their status.
So of the 5, to your information, there was 2 adults and 3 youths.
Yes,
Okay.
correct.
Okay, thank you. Thank you, Mr. Chairman.
Welcome. Thank you.
Thank you, Representative Fishbein. Senator Champagne.
Thank you, Joe. Thank you for coming in today. How has this affected you?
It's been tough, especially on my wife. We have 2 teenagers. One was at home during this ordeal. I can say we don't feel safe. We've definitely had to change some plans. It's changed our outlook. So I've lived in Connecticut my whole life, and this is very disconcerting to us.
Right. And sadly, the troopers were kind of telling you the truth, and this is a point that I've been making about the victims. It is very tough to go to get yourself in jail in the state of Connecticut, and for somebody to use a gun to try and steal from you. And I remember the story because, I'm from the area and you're one of my constituents. And, in the state of Connecticut, if you do the crime, you don't do the time. It takes quite a bit. And, I've made this point over and over again about the fact that when I first became a policeman many years ago, I'd find somebody with 18 arrests and I was surprised that they were actually out on the street. And when I left as a policeman, we're seeing people with 70, 80 arrests. And, that's a problem. And I don't think we're addressing something correctly. And I only see it getting worse. But I'm hoping that your case will go to trial, and I'm hoping that justice will prevail in this. So
I'd like to point out
go ahead.
One of them was just released 3 weeks prior for the same offenses. Just FYI.
Yeah,
Not weapons, just larceny, not use of weapons. But he was just released.
Okay. Well,
That's where we're at now.
all right. Well, like I said, keep an eye on the trial, and hopefully you'll get if it does go to trial, you'll get a chance to speak and express how you and your family are feeling right now. Thank you, Joe.
Thank you.
Senator Lust.
Yes, thank you, Mr. Chair, and thank you, Mr. Fetcher, for your testimony. I'm sorry for what you've gone through. That sounds awful and traumatic, and I imagine it would be a terrible experience for any family. You said in your testimony that you believe that the juvenile offenders believe that there was no consequence for using a firearm or assaulting police officers. Did I understand that correctly?
No, the troopers told me that they know that they've had so many charges that have been dismissed in the court system, and they're fed up with it. They're at a loss. They don't know what to do now. They're wasting their time, and that these kids or even these adults just know that there's not going to be repercussions, and that they're emboldened. I mean, look at this. This was 2:30 in the afternoon. That's how emboldened they are.
So I just for the record, you're saying that the troopers were expressing their frustration that they feel that in general people are emboldened. They weren't saying that in the specific case that you mentioned, where there was a use of firearms, there was sounded like an assault on police officers, that was something that the criminal justice system was unable to handle, the juvenile justice system.
Well, it's still pending. They were just quoting in general of their feelings and the way the court system is working at this time. Not only just the legislation, but the fact that they're getting let off for pretty serious charges. I think the expectation from these guys is that they're probably not going to get so much of a punishment and they'll be back out on the street. That's my impression.
And I'm sorry. Because I think I mean, a larceny is a serious offense, but it's not in the same league in my sense, right, with use of a firearm or an assault on a police officer, which is an extremely serious case. And so I'm just trying to understand, as far as I can tell, the statutes are pretty pretty harsh when it comes to the latter two. And I just want to make sure that the justice system is taking that appropriately seriously, because it's it's obviously what you went through is a very concerning situation, and I want to make sure that we have the appropriate remedies.
To that point, I think the officers were talking about cases in general. I think mine's probably an escalation with the use of the firearm, for all the motor vehicle thefts. This is a little bit different. So I don't think that they were talking about that when they're sensing their frustration as much. But I think it just in general, that's the feeling that I got from the officers.
Got it. Thank you very much for your testimony. And thank you, Mr.
Thank you, Senator Lesser. Comment or question from members of the committee? Comment or questions? Representative Fishbein for the second time.
Thank you, Mr. Chairman. Joe, when I heard your story, actually, I had to look up and look at your name because I thought you might be my neighbor. Because I'm going to tell you that something just like that situation, although at a different time of day, happened right around the corner from my house. Firearm, trying to steal stuff out of the garage and youths. So, I share your concern. So, thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from members of the committee? Comment or question? Seeing none, Mr. Fetcher, thank you very much for joining us this
Thank you.
Enjoy the rest of your day.
You too.
Next, we'll hear from since we're still in the first hour and I didn't realize we went so fast with the Department of Corrections, we'll hear from the Children's Advocate, Sarah Egan, followed by Bill Tattleman, and then Barry Chasen.
Good morning to the committee members and chairs. My name is Sarah Egan. I run the state's Office of the Child Advocate, and I'm here to testify largely about Bill 667, an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee. I'll testify in a few sections specifically. Section 1 of the bill proposes a critically important reform of raising the age of juvenile court delinquency jurisdiction to 12. Currently, children as young as 7 can be arrested and detained in Connecticut. A report from the Connecticut Voices for Children showed that in 2018, 141 children under the age of 12 were referred to Connecticut court. The vast majority of these were for misdemeanor offenses and were almost all disposed of. The Office of the Child Advocate conducted an investigation regarding calls to police in Waterbury Public Schools regarding children in pre-K through grade 8. And we found that in 2018-19 school year, district employees called police more than 200 times in a 6-month period of time, resulting in the arrest of 18% of those students, including 9 students age 11 and under. Almost all of these calls were coded by police dispatchers as calls about mental health or suicide concerns involving very young children. The median age of a child subject to a police call during that 6-month period of time was 8 years old. Both California and Massachusetts have raised their minimum age of juvenile court jurisdiction to 12 after finding that children do not meet standards of capacity and competency under state law. OCA supports Section 2 of the bill, which calls for analysis of various school districts' utilization of 911 and 211. Also, from a cost perspective, utilization of first responders like police to respond to the mental health crisis of children is expensive and ineffective for connecting schools and children and families with mental health supports that will help them. Section 10 of the bill calls for eliminating school suspension for children 3, 4, 5, 6, and 7 years of age. In 2015, in response to data that thousands of children in this age bracket were being suspended from school, legislators passed what they thought would be a near ban on the practice for young children, accepting only the most, quote, violent behavior. Then Chairman of the Education Committee, Andy Fleischman, stated that he expected suspension of little children to be very rare, and that instead children would receive intensive supports and interventions. Instead, while suspensions have declined for this age group since the bill passed, there remains an astonishing number of children in preschool through 2nd grade that are suspended from school. SDE's most recent report shows that there were still almost 2,000 suspensions of children in pre-K through 2nd grade during the 18-19 school year, including almost 900 out-of-school suspensions, and more than 70% of suspended young children are Black, Hispanic, or multiracial. As the U.S. Department of Health and Human Services has cautioned, if administered in a discriminatory manner, suspension and expulsion of children may violate federal civil rights laws. It's critical that we commit to ending this practice for young children in Connecticut. OCA also supports Section 16 of the bill, banning chemical agents for minors, which would phase in a ban on any person under age 18 who's detained or incarcerated. OCA has
Ms. Egan?
found that while DOC, I'm sorry?
Your time's elapsed, if you could summarize.
Yes, just my last comment, that OCA finds that while DOC has reduced the number of children who have been subjected to chemical agent is still utilized with youth, including youth who have respiratory conditions and or psychiatric disabilities. The use of chemical agent with minors runs afoul to recommendations from the National Institute of Corrections, which published a desktop guide to working with youth in confinement that says the chemical agent should not be used with youth. As the committee chair has pointed out, other jurisdictions have found alternatives to those practices. Our testimony is respectfully submitted, and I can answer any questions that you may have.
Thank you very much. Representative Fishbein.
Thank you, Mr. Chairman. Would you agree with me that children today are brighter than children of 20 years ago, let's say?
Are brighter?
Yeah, more, I mean, children can access their parents' bank account by their computer. That's something that 20 years ago more than likely didn't happen. Didn't have the acumen, didn't have the computer skills, but today they do, by way of example.
Representative, children certainly do live in a different world with different tools at their disposal than they did 20 years ago. Yes, I would agree with that.
Okay. So I'm really trying to figure out in section 1. I mean, I guess what you're in support of is that if an 11-year-old commits a crime, that nothing happens?
No, Representative. I think
Okay.
what we would want to have happen, if an 11-year-old engages in an act of concern, right? I think what we want is the system to be able to respond in a way that competently understands what drove the child's behavior, what unmet needs that child may have, and connects that child to supports and services that are more optimally designed to intervene successfully with that child. Because what we know is that most of these cases that get to court get disposed of, and almost all of them are for misdemeanor offenses. So the referral of a child that age to juvenile court has not been shown to be effective at addressing the root cause of the child's behavior, which may be it may be things going on at home, it may be other unmet needs that the child has. So we have to find another way to more effectively support that child.
I recently recall a case, and I think it was a West Hartford attorney, I believe. It was a lobbyist who was stabbed by her child about 3 years ago. And the child was in early teens, if I recall correctly. So an 11-year-old who stabs their parent, and I forgot what happened to mom. What process are you proposing would happen to that child under this bill?
So I don't believe, I think you're correct, Representative Fishbein, that child was not 11, right? That was still a young child, but it's not a child that this bill would have pertained to because of that person's age. But are you hypothesizing that if the child had been younger than 12?
Yes.
So if the child was younger than 12 and engaged in a violent act, a couple of things could happen. One is the Department of Children and Families would likely investigate the circumstances leading to that violent act to determine if there were things going on at home that the child was a victim of. The department would have the ability to take steps necessary and appropriate to securing the safety of that child and the safety of other children in the home. The bill in its entirety also calls for strengthening Connecticut's diversion system that connects children to community-based services should they be needed. There's also, we still have provisions regarding involuntary provision of mental health care to children who have significant psychiatric needs and who need that level of intervention as well.
Okay, the psychiatric aspect can be dealt with through the juvenile court process. that does happen, but am I to understand that the 11-year-old stabs their parent or a stranger? That case does not go to court.
It would not go to delinquency court, no.
What court would it go? What court would it go to?
The circumstances surrounding that could still potentially be brought to juvenile court on the child protection side.
Okay, when you say potentially,
Right.
where is the gatekeeper function? It's not in law enforcement, correct?
Well, law enforcement would certainly investigate, obviously, the circumstances surrounding what happened. And the Department of Children and Families would also likely investigate the circumstances surrounding what happened, potentially resulting in the child's removal from that home as well.
Okay. Now, if a 12-year-old creates the same bad act, that goes to, well, more than likely that gets to adult court under our present law, but it would go to some court.
It doesn't,
No.
actually, Representative
Okay.
Fishbein, because the minimum age for adult criminal court jurisdiction is 15 in Connecticut.
Oh, that's right. Yes. Okay. So and there's no exception for murder
There is
or
not.
anything like that.
There is not.
Um,
Not for
okay,
that
well,
charge. Yeah.
Moving on to the suspension situation. So you have under this law, the suspension of a child from school is limited to what age? Up to what age cannot be suspended?
Well, under our current law, Representative, a child of any age can be suspended under certain circumstances. So this bill, and I know I moved really quickly, I was just trying to get through the content in the 3-minute period of time, but under a law passed by this legislature in 2015, that sought to narrow the circumstances considerably under which a child age 3, 4, 5, 6, or 7 could be subjected to an out-of-school suspension, right? So it limited that to situations primarily where a child was considered to have violent behavior. That was the exception. And at the time, the Education Committee chair said, okay, well, that's going to take care of the vast majority of any suspensions for children this age, because but prior to the passage of that bill, there have been thousands. I think, if I recall correctly, almost 5,000 suspensions of children in that age range. So it was contended to be a near ban on out-of-school suspension for children of that age. But what we have found is that though the State Department of Education has paid considerable attention to try and reduce school districts' reliance on suspension for children that age bracket, we still have a significant number of very young children in pre-K, kindergarten, first and second grade who are suspended from school. And the impact of that has been felt most significantly on children of color. Persistently, we have 70+% of children who are suspended from school are Black or Hispanic.
Understood, that's the representation. Can you give me a fact pattern where a child was suspended under the present system and you feel that suspension was not appropriate?
Sure. So I think some of it, Representative, comes down to how we characterize children's behavior, right? So that the exception that was left in the statute uses the word violent, right? And I do think that we have heard often from educators about their concern about children, very young children who engage in major tantrum behavior, very dysregulated behavior. They throw things in class. They may push the desk at the teacher. They may hit the teacher. We have seen that. That certainly does happen. And educators are rightfully concerned about how to deal with that in their classroom, particularly classrooms in lower income districts where the number of children that they have in their classrooms is higher, right? I think that in almost every conversation that I'm in, Representative, educators and child advocates and parents alike agree that suspension is a suboptimal solution for dealing with a child with very young age who likely has very little control over the behavior. And the children who engage in the worst of that, right? The children who's most likely to lash out in class and run and scream and try to hit the teacher in the shoulder or the stomach or go after them in some way is likely a child who is struggling with unmet needs of their own, right? But to give you a concrete example of a case that my office dealt with directly following the passage of this law was a 5-year-old who threw some kind of like trains or blocks or something at the teacher. And the teacher was frustrated and felt like this kept happening. So the child was suspended for a week from school. And the report from the school was, well, the child has been talked to and the child knew what they were doing. So I think developmentally, certainly we can understand the frustration of the classroom teacher who may not have the supports, interventions available to him or her to, keep the class going while one or more children are struggling with their behavior. But I think from a developmental standpoint, it is very unlikely that a 5-year-old has the kind of concentrated intent behind their behavior or understands the purpose or benefits from being involuntarily suspended from school for a week.
And under this language that you support, how would the school system deal with that child that is perhaps endangering other students in the classroom?
Yeah, I think that's the crux of it, right, Representative, which is that the child, the teacher, and the other children in the class need and deserve and require the supports and interventions available to have somebody come into the classroom to support, somebody to coach the teacher about what may be causing some of these eruptions, a safe place in the school for the child to be supported and calm down and de-escalated and coached about how to return to the classroom. And some schools have all of those tools and some don't. The investigation that I referenced in my testimony about Waterbury Public Schools, where the police were called on very young children between the ages of 4, starting at age 4 and up, median age of 8, none of those elementary schools, none had a dedicated school social worker, none. So the schools were forced to rely on first responders, or felt that they were forced to rely on first responders, which is both expensive and highly ineffective at dealing with what the root cause of the child's behavior is. So I do think that you're right. In order to implement that kind of a change, which I think is consistent with good child development, good educational practice, and the racial justice practices that the legislature is rightfully concerned about, we need to make sure that those interventions and supports, like school social workers, like school counselors, are available to the schools that need them.
Okay, I think you and I come from different places, but okay. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative Howard.
Thank you, Mr. Chairman. Good morning, Ms. Egan. How are you?
I'm well, Representative. How are you?
I'm well, thanks. In all your work with kids, I'm interested in something, and perhaps you may not be able to answer this, and if you can't, that's okay. But if you can, would you say that prior to a kid doing something like stealing a car, robbing a convenience store, whatever, there was warning signs along the way where perhaps somebody made a statement to the effect, this kid's headed down a bad path, whether that be in school, the most likely place. Do we have enough, have we been at this long enough with juvenile delinquency that we know what those warning signs are?
Well, I think you're absolutely right, Representative.
I often am, yeah.
Yeah. So kids, especially now, some folks have pointed out today, kids are most likely to be incarcerated, or kids who have touched the system multiple times. My office, which has access to child-specific records across system, has found that for kids, particularly the deepest end of our system, most of those kids have touched all of our systems, including child welfare, multiple times. Just to give you one example, Representative, for the kids right now, the 15, 16, and 17-year-olds that are in MYI and at York in the adult criminal justice system, we found that for the boys, the vast majority lived in families that had been involved with DCF due to concerns of abuse or neglect. And a significant number, I believe off the top of my head, it was about 1/3, lived in families that had been investigated more than 10 times for concerns of child abuse or neglect. Most also had a history of psychiatric impairment and mental health needs, and most were assessed at functioning academically at the 4th grade level. So there's a host of unmet needs by the time a child winds up at the deep end of our system.
So thank you for that. So what are we doing now, and can we do more? Because let me give you a background on this, and you can tell me if I'm wrong, okay? But I'm happy to hear that. I'm a dad, and I've been a policeman for 19 years, and I often get compliments on my children, and I confess to people that I had a cheat sheet, okay? Because before I had my kids, I've been a policeman for, I don't know, 6, 7 years, something like that. So I sort of got to see the results of good and bad parenting all along the way in the way that most people don't get to see. I hope I'm saying that the right way. And one of the frustrations that I've had, one of the frustrations that my school administrators have had, and one of the frustrations that our juvenile officers have had, is that when the parents are either unwilling or incapable of redirecting the path of their kid, they're at a dead end. Do you say that's an accurate statement? You find that?
I think that, Representative, your question points to I think a complexity in our system, yes, which is that I think one of the things we see in common for children that have come into the most contact with the juvenile or adult criminal justice system is that many, not all, but many lack access to a consistent nurturing guardian. I think that's definitely true for a lot of our kids in the adult system. And we know that children they all need that. It's critically important for children to be connected to a consistent, positive adult in the community. I think one of the things our system can do better with earlier is providing, even on the prevention side, Representative, right? Recognizing that children exist in the context of their family and relationships, and providing the supports and services at an earlier age that strengthen the whole family and that get at some of the unmet needs that family may be having that are tearing down that family system a bit. The more we can do on the prevention side, the more we, alter and improve the trajectory of that child going forward. For children that are deeper into our system, I think one of the things we have to do much better is, even for kids who are incarcerated, is identifying those positive and consistent adults who, even if it's not part of their biological family, who can be a consistent, stabilizing, supportive force for that child. Most of the kids who are incarcerated get very few visits, right? Many kids, not all, but many kids who are incarcerated do not have that kind of relationship waiting for them when they return. Some do, but many do not. And that is something we have to be better at for kids.
Yeah, I think so. And the last question that I'll pose to you is, and again, I'm thinking of my community where I work and live. Often, and myself for that matter, I spent a fair amount of time in the assistant principal's office because I didn't want to be in school. I wasn't destined for college. It wasn't what I wanted to do. I didn't want to be a doctor. I definitely didn't want to be a lawyer, and I didn't want to be a teacher. And oftentimes I feel kids that are there are, I don't want to call them left behind or cast aside. That's not the right way of saying it. But I think that there's something to be said for the manner in which our educational system is hyper-focused on higher education, and the fact that we have an increasing number of juvenile delinquency and a decreasing number of tradesmen. So I think those things kind of go together. And I think that perhaps this system and our school system collectively could, redirect the focus to an individual child and say, the confines of institutional learning are not good for him. He gets out of here after 7 hours and he's full of the wigglies and he goes out and gets in trouble. Would you agree with that? I see you're nodding your head, but.
Yeah, I kids want productive things to do. There's no question about it. And the more we can keep kids engaged with things they can be good at, whether it's giving them the help they need to succeed academically, giving them the help they need to identify a trade, earn money. There's no question that a lot of kids do. They wind up in criminal behavior, part because of time and lack of support, and often because of money. Kids want money. They may worry about their own families. They may worry about, not being able to have a job. So I think the more we can do, you're right, to engage children productively, both academically, vocationally, pro-socially. I know you're a coach too, because I watch your testimony in the Children's Committee. These are the things that all kids need, right?
I agree with you. I think, I'm sorry.
No, I'm done.
Okay, I'm sorry, Zoom world. I'm not sure that we're necessarily aligned on the kids that have gone maybe too far down that path and how we should handle that as a society. But I think definitely, and I'll speak to my work as a coach. I know for sure that I am, and my coaching staff and the fellows that work with me have tremendous impact on these kids for exactly what I lined out. It's how I came to this. But I do think that I think we need to address the issue that's going on, but I think we also need to take a look at what's going on inside of our public school system to make sure it works for every kid. And it took a lot of time. I thank you for your time, and thank you, Mr. Chairman.
Thank you, Representative.
Thank you, Representative. Comment or question from members of the committee? Comment or question? Seeing none, Ms. Egan, thank you very much for joining us again. I hope you enjoy the rest of your day. Next, we'll have Bill Tatelman, Barry Chasen, and then Representative Turco. Is Bill Tatelman in?
Yes. Committee.
You have 3 minutes.
Committee Chairman, committee members, good morning. My name is Bill Tatelman. I'm from South Windsor. Thank you for the opportunity to testify at this public hearing in support of proposed bill number 1088, an act concerning assault of a sports official. I started umpiring Little League Baseball at the age of 14. I'm now in my 46th year as a member of the Connecticut Board of Approved Baseball Umpires. For the past 45 years, I have umpired organized amateur baseball. Additionally, for the past 24 years, I have officiated high school basketball with the International Association of Approved Basketball Officials, Board number 6, as well as a youth and adult leagues. If you were to ask most objectively minded people about officials, they would tell you that they would never want to be one. Why would someone want to subject themselves to such abuse? Officials of all sports are a unique group who perform a thankless job for minimal compensation. We are often underappreciated, and if there were no officials, the game or the event would likely not be played. I can honestly say that most officials I know strive to do a quality job. They seek to ensure that the game is played fairly according to the rules. They don't care who wins or loses. Amateur sports officials do so as a part-time avocation in addition to their full-time employment and family commitments. High school basketball games generally have a police presence to assist officials as needed, while most outdoor sports such as baseball do not. For non-scholastic youth and adult sporting events, essentially officials are on their own. It is rare to have police or league representatives on hand to assist game officials. Officials do have the ability within the playing rules to remove players and coaches from a game for unsporting behavior. It's much more difficult to deal with unruly fans, or officials are trained to not engage with fans. Regardless of penalties imposed by the CIAC or non-scholastic leagues, such penalties would not provide adequate punishment for an assault before, during, or after the game. Proposed Bill 1088 creates an enhanced penalty if a person guilty of assault does so while an official is performing his or her duties. I would recommend modifying the bill to cover officials from the time they arrive at the game site until the time that they leave the game site. In recent years, the National Federation of High Schools and state associations, such as the CIAC, have emphasized good sportsmanship. I have gone to some gyms where there are posters outlining expectations for those attending the games. One expectation always causes me to pause. It says, "Be a fan, not a fanatic." This is the problem, because there are still fanatics. There is a shortage of officials both in Connecticut and countrywide. The primary reason cited in national surveys for officials leaving officiating was poor sportsmanship by game participants and spectators. This has led to difficulty in recruiting and retaining officials. Fortunately, I have not been personally physically assaulted while officiating basketball or umpiring a baseball game, but I have been verbally threatened by spectators and players. I have been followed and verbally abused at my car after umpiring a game. I have been threatened by a player in an adult league basketball game who said to me, "I'll see you in the parking lot after the game." I do understand that verbal disagreement with some decisions made by game officials is part of the game, but personal attacks, both verbal and physical, are not. As a society, we must act on the belief that respect for authority, whether you agree with the decisions made by sports officials or not, is critical to living and playing together. Those who give their time to officiate not only deserve our respect, but they must have complete confidence that they will be able to carry out their responsibilities in a safe environment. I believe this legislation can help reduce the possibility of verbal and physical assaults against sports officials. I'm not naive enough to believe that legislation alone can change behavior, but this bill can serve as a deterrent. People need to be held accountable for their actions. Those of us who have been involved with officiating and still enjoy what is good in amateur sports need the support of our legislators. Let us not wait until something terrible happens. And then look back. I'll be almost done. Let us not wait.
Mr. Tatelman, I'm going to ask you to stop for a second. You're well outside of the 3 minutes. I'm going to ask you to wrap it up.
Okay. Let us not wait until something terrible happens, and then we are back together saying we should have had the necessary protections on the books. I guess I'm old enough to remember the movie starring William Bendix, Kill the Umpire. I thought it was funny at one time, but let us not wait until someone really tries to kill the umpire. Just because someone chooses to officiate sports, it does not justify abuse or assault. 22 states have already passed similar
Sir.
legislation to protect.
Sir, Mr. Titleman, I asked you to wrap it up, and I'm going to ask you to end it there and see if there are any questions for you. Representative Gilchrist.
Thank you, Mr. Chair. Thank you for being here, Mr. Titleman. I am saddened and kind of disgusted that we even need this policy, but not surprised. And I thank you for continuing to, I do recognize there's a small payment, but volunteer your time so that our children can play sports. My son plays flag football, Little League, and travel basketball. And I am oftentimes trying to hide beneath the bleachers because I'm mortified by the behavior of the parents that I'm with. So could you, at the end of your testimony, you were talking about the other states. How many other states have passed the legislation we're considering?
My understanding, Representative, it's I believe 22 and varying degrees. I think some are more detailed, and but generally speaking, 22, I believe, have assault legislation.
Okay, thank you. And I'm sorry that you've been followed to your car and had all those things happen, but thank you again for continuing to help us so our kids can play sports.
Thank you, Representative.
Thank you, Mr. Chair.
Thank you, Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Mr. Titleman.
Good morning.
Just trying to figure out, are our laws against physical contact, threatening, those kinds of things not working for you? I mean, if somebody says something like, I'm going to get you in the parking lot, I'm going to come to your house, they follow you to your car in a threatening manner, I think those are all actionable under our present law. So I'm trying to figure out why we need this carve out.
I think it has basically it's more tied to kind of what we're doing in terms of this avocation. I think, you know, there are, like I said, within the playing rules, we have certain jurisdiction that we can deal with activities, let's say during the game with the participants and so forth. A lot of it occurs with people behind the fence or people in the stands and things of that nature, where you may not, you know, sort of have that additional protection, if you will. Because I think we sort of do a unique, we have a unique role. It's certainly not our primary job, if you will. This is something that we try to do to promote amateur sports, youth sports, and so forth. And I just think that we're sort of a forgotten group. We sort of are out there saying, okay, well, they'll be there, you know, the officials will show up and, you know, we can say what we want and do what we want. But I think there needs to be a specific legislation out there that addresses a sports official.
Okay, and I'm trying to figure out, you know, so if a spectator in the stands is yelling at you, that would not be actionable under this law as proposed. But if they threw a bottle at your head from the stands, that is already actionable under the law. You know, if I was the umpire, I would recess the activity, call the police, or sometimes these facilities have police officers right there. I'm just trying to figure out why this is necessary to protect you. And I have from time to time refereed ice hockey. So, you know, I've been in that position. Just trying to figure out why this law, why our current laws are not working for you.
like I say, Representative, I do believe that officials are in a unique group that are trying to perform a certain function within a game situation. And these extraneous things that happen, we can't be thinking about, well, is this person going to come over the fence or a person going to come after me after the game? Again, there's not necessarily protections there currently. Yeah, I mean, I'm sure that if someone attacked you, you could, go to the police and so forth. But I'm talking about in the context of performing these specific duties.
Okay. I understand your position. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative Fishbein. Comment or question from members of the committee? Comment or question? I do not see any. I want to thank you very much, excuse me, Mr. Titleman, for joining us. Excuse me, joining us this morning.
Thank you, Senator.
Thank you. I hope you enjoy the rest of your day. Next, we'll hear from Barry Chasen, followed by Representative Perko, and then Anthony Giusto. And I'm going to turn it back over to Representative Stastrom as Mr. Chasen lines up to provide his testimony.
Good morning.
Good morning, Mr.
Hello, Representative. My name is Barry Chasen. I live in Simsbury, and I am speaking in support of SB 1088 AAC, assault of a sports official. I thank you for holding this hearing, as we have seen an increase in the number of verbal threats and physical assaults against sports officials in the past few years. This bill sends a strong message to those who attend amateur sporting events in Connecticut. With the various platforms we have access to, sports officials will work together to ensure that this proposed bill will be well publicized if it becomes law. One of the main reasons we need a law regarding assaults on sports officials is because we are losing present officials and learning that prospective officials, hearing and reading about assaults on officials, choose not to pursue this avocation. I can speak to the loss of baseball umpires, having been one now for 55 years. In the past 7 years in Connecticut, we have lost 155 umpires from the ranks of the Connecticut Board of Approved Baseball Umpires. If we keep losing officials in the various sports, there will not be enough people to officiate games from the youth leagues to the adult leagues, including high school and college games. I doubt anyone wants to see that occur, because without officials, there are no games. The emotional toll on an assaulted individual is oftentimes greater than the physical damage inflicted. You have an opportunity to help us retain our present officials and inform prospective officials that our state legislators are concerned about their health, safety, and well-being, which has been jeopardized too often, whether physically or verbally, over a game. I find it hard to believe that anyone would argue against a bill that promotes those three items. A few weeks ago in Connecticut, some young people in a stolen car rammed a police cruiser. I noticed that one of the charges against the driver was assault on a safety officer. I would like to say that safety officers and sports officials have much in common. Safety officials enforce the laws and are the protectors of society. Sports officials enforce the rules, promote good sportsmanship, and maintain the integrity of the games they officiate. Safety officers have items on their person that they can use to defend themselves if attacked. Sports officials do not. But if you'll vote this bill out of committee and send it to the General Assembly, we will be on the road to having the legal protection we need and deserve. Your support will help to mitigate these assaults and help us retain and increase our ranks of officials so that the games from youth to adult leagues can continue to be played. And finally, Hawaii was the 22nd state to pass an assault on officials law. As one of the top ranking officials in Hawaii stated, with the ongoing challenge of recruiting and retaining officials at all levels, this legislation says our legislators care about our officials and support the sacrifices of officials, from training to traveling to games to doing the best job possible for the athletes. Knowing this, our different sports officiating groups can pass this message along to present and prospective new members that our state legislators support our efforts. Please support our efforts in Connecticut so we can pass on that same message to our present and prospective members, making Connecticut the 23rd state to have a law regarding assault of a sports official. Thank you very much for your time. It's my sincere hope you will vote in the affirmative for SB 1088.
Thank you, sir. Senator Champagne.
Thank you. And Barry, I want to thank you for coming in today. Can you tell me, were you ever assaulted?
It came close. I was working a tournament game in Summers some years ago, and I made a call on a rule that most people probably don't realize. When a guy is running back to a base he was on to tag up and move to the next base, if you throw the ball out of play, he gets that base and the next base after that. These guys thought that the first base was second and then he'd only get third. And they're standing over by first base going, I think we better tar and feather this guy after the game. So they followed me to my car. I had other people with me, and then I opened up my trunk and I reached and grabbed a tire iron and I said, I don't really think you want to come any closer. And they left. I was physically contacted by a player in a game in the Hartford Twilight League, called him out on strikes, and he ran at me and banged into me and so forth. I've been threatened in other instances. When you do it for 55 years, you're probably going to run into that. But thankfully, no, I was not beaten up or anything like that. But the mere threat is enough to take your mind off what, you're trying to focus on. And I think I sent you people stuff at the end of January. I sent you about 7 or 8 examples of what I know to be assaults. And we don't want to lose people, because I don't think anyone here wants kids not to be able to play.
I agree with you. And I do support this law. And I want to thank you for coming in today.
Thank you very much, sir.
Thank you. Representative Gilchrist.
Thank you, Mr. Chair, and thank you, Mr. Chasen, for being here. In my community, in addition to the umpires, we have young people who also, are, I guess the referee in the field. Would this law protect them as well? Because unfortunately, I've witnessed adults screaming at teenagers who are refereeing.
Yeah, ma'am. Let me say this. This law is designed to protect amateur officials from youth all the way up to people my age. So if you have young people, and I know Bill Tatelman started there. I started roughly around that same time. I just don't count the years from 14 to 18 until we started getting paid, because in those days, 14 to 18, I got paid with hamburgers, hot dogs, and ice popsicles. So, but no, it would protect those kids. And I noticed that a couple people in their written testimony wanted to amend it to include coaches. So I don't know if that will be considered, but no, this bill is designed to protect amateur officials from, like I said, Little League on up, whether they're umpiring behind the plate, on the bases, refereeing basketball, football, whatever.
Thank you. Thank you,
You're
Mr.
welcome.
Chair.
Thank you. Mr. Chasen, a couple quick questions for you.
Yep.
These instances you referenced with Senator Champagne where you were threatened, did you report those to law enforcement?
No, no, I did not. I was very young, a young person at the time. I was not contacted by those people after that game, so it never would have crossed my mind. Who I did report it to was the director of that entire district. And I know there was action taken against that league. I believe they might have been put on probation, but I did not go to the police. It didn't come to that. But I was threatened at a game in the playoffs of the Hartford Twilight League, where one of the players who had been ejected from games in that league 11 times was still in the league, okay? He threw a bat or kicked a bat up on the backstop at a game that had begun at 10:30 at night. So this was around midnight or later. The plate umpire told him, when that bat lands, you're gone from this game. So when you get ejected in a Hartford Twilight League, because they play by major league rules, you have to go and sit and you have to leave the park, out of sight, out of mind. This gentleman went and sat in the first base bleachers. I was umpiring third base in this game because in the first game that began around 8 o'clock, I had been behind the plate. So consequently, I told his coach, who was standing in the third base coach's box, he's got to go. He's got to leave the ballpark, okay? So he went and told him he had to leave the park. And as he came out of the bleachers, instead of leaving the park, he came out onto the field and he was going for the home plate umpire when his teammates intercepted him and said, no, Dave didn't throw you out of the game. Out of here, Barry did. So he stood over there and said, I'll be waiting for you in the parking lot, and started threatening me, etc. Told his coach, if he's in that parking lot, the East Hartford police are going to be here in a flash. So he went over and made sure that this guy left. But what nobody could believe was that he was still in this league. And then later that year, he started a brawl when he got picked off of a base. And so we had to go and break that up to him. Finally, he was suspended for life. He got a lifetime suspension from the league. But that was a harrowing experience.
Mr. Chasen, I guess my point was, though, that these instances were not reported, which kind of leads me to my second question. You started off by saying that there's been an increase in physical assaults on,
yes.
I'm wondering if you have
yes.
statistics on that for the committee.
I think you'll hear that from Mr. Mano from the National Association of Sports Officials, okay? In a survey he did of 17,000 responses, and it's in the written article that he sent to you. What I will say to you is that this past fall, and this is what triggered it for me after 55 years of pursuing this, we had a gentleman who was assaulted on the field after making a call down in the Waterbury area. The gentleman was transported, I believe, by ambulance to St. Mary's Hospital. He suffered a concussion. I don't know what the emotional toll on him was. The gentleman who assaulted him left the ballpark, ultimately turned himself into the Naugatuck Police. And at our last state board meeting 2 weeks ago, we were told that, and this happened, I believe, in September, the case is, quote unquote, still pending. But, you know, the thing about us is, I think judges, prosecutors and that realize that we are providing a service which is a little different from being a member of the general populace. And somebody gets whacked in the, in a general population, they call the police, whatever the case may be, and they get treated however they get treated. Plea bargain take place, people may get off, and so forth. We are losing people because of the threats verbally that sometimes turn into physical, and
right.
that's that.
Thank you, Mr. Chasen. All right, seeing no further questions, I appreciate you being with us. Next up will be Representative Turco.
Thank you, Chairman Stafstrom and Chairman Winfield, ranking members Fishbein and Kissel, and honorable members of the Judiciary Committee. I am State Representative Gary Turco. I represent the 27th House District, which comprises most of the town of Newington. And I'm here today testifying in support of House Bill 6669, an act concerning juveniles and motor vehicle theft, investigations of certain pending juvenile matters, and reporting of requests to detain arrested juveniles. I have submitted written testimony, so I'll do my best to paraphrase in the next couple minutes. Thank you for raising this bill and conducting a public hearing on this critical issue of reducing juvenile crime. Let me first just set up what my community of Newington has experienced with motor vehicle thefts and break-ins. This is something that we've been plagued with for a long time now. The issue with cars being stolen, broken into, damaged. These crimes result in thousands of dollars of damage, a loss of people's personal property, and many residents just living in this constant emotional angst and fear that additional crimes are going to happen. These crimes affect all parts of the community. We have large condo complexes where 100 cars are broken into in a night. This happened recently. And then we have quiet residential streets. Windows are smashed, tires are stolen. A lot of times people do leave their cars unlocked accidentally. But these should not be accidents that then result in someone's personal property being violated. And I know this is a national problem. I know it was decreasing here in Connecticut and getting better until the start of the pandemic in March of last year, when now we've seen a steadily rise. But I do think as legislators and as a state, we have some responsibility to help mitigate these issues. Now, this issue is not just from juveniles, it's also from adults, maybe more often as adults. But I'd like to see what we can do to help prevent these issues and rehabilitate the youth who are arrested for these issues to prevent them from doing it again. I won't have the time today in going into all of the detail. I have met, though, with juvenile justice advocates, community organizations, the judicial branch, and law enforcement. And I believe our state is failing high-risk youth in numerous areas. We need more programming. We need more funding for community programming. We have closed Connecticut Juvenile Training School, made a lot of other changes, but not shifted funding to adequately support youth so that these crimes maybe don't happen in the first place. But when they do happen, I want to make sure that these youth are, one, held properly accountable, but two, and that doesn't necessarily mean punitive. I don't suggest going against raising the age or putting these youth in children in prison, but they do need community services, restorative justice programs, rehabilitative services, and things that are going to help on the ground prevent them from doing so. So just to wrap it up, I think you have some important sections in this bill. One, to hold adults more accountable who are possibly soliciting and coercing youth into committing these crimes. Another section regarding a GPS monitoring device on youth who are repeated offenders, so we can break that cycle, make sure that they're staying home, safe conditions, and not possibly going out and committing more crimes. I've also included in my written testimony, Mr. Chairman, some other suggestions from my conversations with law enforcement, with the juvenile justice departments and advocates, with the judicial branch that I think could be helpful as well.
Thank you.
Thank the committee for this bill again and urge an adoption of some sort of mitigation of these crimes and car thefts. Thank you. Mr.
Thank you, Representative Turco. Are there questions or comments from the committee? If not, Representative, I want to thank you for your work and advocacy on this. I know you and I have spoken many, many times on this issue, and you work to craft some of the ideas and the proposals in this bill, which I'm appreciative of, and I'm also particularly appreciative of your testimony in recognizing that the issue of why juveniles commit crimes is really not solely the purview or cognizance of this committee. Yes, we can increase or decrease penalties, but a lot of this comes down to funding and resources and programming and community intervention solutions and the like, which this committee does not have direct responsibility for, and I appreciate you recognizing that as well, both today and in our conversations on this topic.
Thank you, Mr. Chairman, for all your help.
Next up will be Anthony Gayosto.
Good morning, Chairman and committee members. My name is Anthony Giusto. I am a member of the Connecticut Rink Owners Association, as well as president of Central Connecticut Youth Hockey, one of the larger travel youth hockey programs in the state. And I also coach high school hockey. So I see, and I'm testifying in support of Bill 1088, an act concerning assault of sports officials. And I see how that plays in at all levels, whether it's youth sports all the way up to the high school level. In my 20 plus years involved with youth sports in Connecticut, we've seen a severe shortage of officials, primarily over the last 4 or 5 years. And a lot of the discussions that we have dealing with the referee associations in Connecticut The reasons for referees not sticking with it over time is due to the assault, whether it's verbal, bordering on physical assault. Being involved in youth hockey, we deal with an alarming number of cases, especially over the last, I would say, 4 or 5 years. We've seen a real increase in, again, verbal bordering on physical assault, from parental behavior towards officials, coach behavior towards officials. And a bill like this would just help us as a program administration deter parental behavior and coach behavior, just give us a little bit more backing to deal with it internally. One of the statistics that came up in speaking to the Officials Association is 80% of the youth hockey officials quit before they finish their 3rd year officiating. And most of those reasons is repeated abuse from parents and coaches. We will never be able to develop youth officials into more experienced officials if we're losing officials at that rate year over year. As I said, being involved in youth all the way up to the high school level, we see the behavior and how it affects officials. One of the representatives mentioned before about teenagers refereeing being accosted as well, and we see that on a weekly basis. The Referee Association in the state does a great job with shadowing programs for younger officials, and as soon as these officials are turned over into working games by themselves, they're being yelled at by adults in the stands and by coaches on the benches, and we're just seeing an alarming rate of these officials not come back due to that. So with that, I respectfully submit my testimony and welcome any questions that anybody might have.
Thank you, sir. Representative Gilchrist.
Thank you, Mr. Chair. Thank you, Mr. Giosto, for being here today. I hope I didn't mispronounce your name too bad. In your experience as a coach, can you tell us, again, just your personal experience, what impact the parents threatening, screaming, and the coaches screaming has on your players?
The parents think they're doing justice by yelling and screaming, and the most of the kids are appalled by parents' behavior. As program administration, last thing we want to do is suspend parents from coming to youth sports for 2 weeks at a time, but we do it. And the parents forget that it's a youth sport. The kids are there for their enjoyment. And, we do a survey at the end of the year in our youth program, and we ask the parents several questions. We also ask the kids several questions. And, it's an anonymous survey, but we keep it among ourselves as how we can do things better. And a lot of the responses we get back from the kids is that, the parents don't make it fun for them. This year being a COVID year and not having parents allowed in a lot of the buildings, it was a pleasant surprise at all levels.
That's very telling. Thank you. And your stats were really also compelling that you lose so many, unfortunately. Thank you for being here. Thank you, Mr. Chair.
Thank you. Thank you. Further questions or comments? If not, next up will be Bob Crawford. Thanks for being with us, sir. Mr. Crawford, you're on mute.
Okay, is that better?
Yep, there you go.
Okay, thank you. My name is Bob Crawford. Also part of the newly formed Connecticut Rink Owners Association. Have been involved in this sport for over 50 years. I was fortunate enough to, as a player, become a professional. One of my teams was the Hartford Whalers, and went on from there to own and operate ice rinks in the state, as well as be involved in coaching and mentoring. In saying that, totally concur with the points that Anthony brought up. I also, since reading about this, I really think we need to also look in a couple of different directions where, in my opinion, I think Anthony said it best, when the thing that we noticed right off the bat with the pause and not allowing parents in the games is the stress levels on the kids, the stress level on the officials went down dramatically. And the kids actually played better.
But in saying that, that's not something that is going to be logistical going forward because parents want to see their kids play. But I'm, been thinking about listening to people here today. Part of my thought process is the fact that, instead of just punishing the parent that's the offender before it rises to an assault by asking him to leave a game, maybe different youth leagues and through the state, we can encourage having all the parents from that team leave and let them be the sheriffs on their own teams. Because I call it the rogue parent, and it's usually 5% of the people that come in your building that have the ability to not control their emotions. When they're put in that situation, if a parent group knows that they're all going to be asked to leave the building for the remainder of the game, I think they'll control that parent. And, the last thing that we want is to have an official, and I think every bit as much so the coaches abused, verbally and physically by the spectators. These are all things that I'm just thinking of right now. I heard someone say that earlier that they would like to see this law expanded to when a referee arrives on location, walks in and out of the building, wherever, in our rink, we have referee rooms where they get dressed, some shower. But at the end of the day, extend that, just, actually show where and when this protection is allowed. It's, the other thing is why is this happening in the last 4 or 5 years? Just look at any type of college or pro sports, instant replay. People are now watching their games live on site. There's these video streaming services, so they can see a play. They can see whether or not a goal went in our sport or an offside happened. Well, guess what? You're dealing with human people that are, I always tell people, leave the referees alone. They make as many mistakes as you do. Everybody's human, and you don't want us to point out your mistakes as much as you're willing to point out theirs. So just some thoughts. And like I said, I've been an owner and operator of ice rinks for 25 years now, and 3 locations, Bolton, Simsbury, and Cromwell. Was New England director for 9 years. So I've got some experience specific to our sport. And that's really my testimony.
I think we got a question for you from Representative Fishbein.
Sure.
Thank you, Mr. Chairman. Mr. Crawford, I love our sport. I still play ice hockey, and skating is freedom, and I absolutely adore hockey. And for those of you, 1983, I graduated from high school. I listened to Cap Raider, broadcasting the games, and I think I looked it up today. You got 61 points in 80 games, which is almost 1 point per game, which is an incredible feat. So, my hat's off to you. But it appears that the law that is being proposed here, you would rather have those in attendance police themselves. Am I reading that correctly?
Well, it's all about escalation, right? When you have a situation within a contest, it doesn't happen all at once. There's always an escalation during a game, and referees will almost always warn parents in the crowd before. And my opinion is we do have a no tolerance rule, but in order to get to that point where someone becomes verbally abusive and threatening physical violence, it's a stepped up system. And if there's one thing that I learned this year with the mask mandate and the not allowing parents into indoor sporting activities, is they'll do anything to get in to watch their kid. They will do absolutely anything. They were sneaking in our side doors. We're like, we hired extra people just to make sure that mom and dad weren't looking through a corner of our building somewhere. It's just another thing. I have no tolerance whatsoever for physical abuse, and escalated verbal abuse has no business in our sport. But I'm also asking you to think a little differently. When I say that, add an additional penalty where if a parent is, or encourage an additional penalty for everybody on the team to have to leave a building, not just the offender, because they will make sure that that offender does not do it again. And, am I worried about the instance of one game? Absolutely not. Am I worried about the rogue 5% parent who's a problem at every game? Absolutely. Those are the people that we want to control. And when they're not allowed to watch their child play, and the other parents on the team are not allowed to watch the child play, what they sign at the beginning of the year, the waiver of, the code of conduct, which most parents will sign, 5% will not pay attention to, that will help in this overall escalation of energy, emotion, and, unfortunately, in some cases, physical and verbal abuse.
So what prevents you from a rink operator from, saying to a particular league, because of the way certain individuals are in your league, I'm going to have to hire a police officer to be at my facility during our games and therefore charge that league a higher fee, which I would think would have some, help in that regard.
Yeah, I would have to say if I get to that point, they're not in my rink, because what happens is then the cost associated with having to have police or security make it on an economic charge to the parents that's too much for our demographics where my rinks are. In saying that, some high schools do provide security via police or security people. Others just have their athletic department control the facilities. And again, it's if it escalates to a point where you feel you have to have police at a game, don't have the game.
Okay, well, thank you. Thank you for coming here today, and thank you, Mr. Chairman.
Yeah.
Thank you. Representative Howard?
Thank you, Mr. Chairman. Thank you, Mr. Crawford. One quick question, just for clarification, I don't know if I heard you right. Did you suggest that I have two sons that play multiple sports, that if another parent on the same team is acting out, I should either control it myself or be thrown out from watching my own kid?
I think that would send a pretty strong message. It's a strong solution, but the one thing that you'll find out is, particularly and I'm speaking specifically for our sport, many of the teams that play the sport of ice hockey come from out of state, and many of them come to your location maybe once a year or once every 2 years. So you have no real ability, number one, to know who they are if and when they come back, or to monitor. It's not our job to monitor whether or not they go to a rink in Boston the next day. But my thing is, within a league controlled scrimmage, and where you're actually playing towards some kind of a state title, if you can control that and move all the parents out, I don't think it's going to happen twice. And again, it's pretty drastic, but isn't it also drastic where, you might have a referee feel scared for his own safety within a building? So, it's everybody signs, or for the most part, everybody signs codes of conduct every year.
Sir, I don't mean to cut you off, but I just want to focus us back on the bill that's before us. The bill that's before us doesn't regulate conduct of parents or youth sports. It increases a penalty for a physical assault on a referee. So we've had a couple folks testify on this bill, and we're getting a little afield of what the bill before does.
And again, it's a broad subject. If you ask me specifically about the bill, 100%, whatever you can do to protect officials.
Representative Howard, do you have a follow-up?
No, Mr. Chairman, I'll leave it at that. Thank you, sir.
Okay. All right. Thank you for being with us, Mr. Crawford. Appreciate it. Next up will be Representative Kerry Wood.
Chairman Winfield, Chairman Stastrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. Thank you for having me. My name is Kerry Wood, and I'm the state representative serving Rocky Hill, Weathersfield, and Newington. These communities are centrally located and easily accessible via I-91 and the Berlin Turnpike. This ease and accessibility has caused the district and our neighboring towns to become a target for property and auto thefts. Perpetrators of these crimes can easily flee from police officers, but are also too often simply gone before law enforcement arrives on the scene. Recently, members of the community have been victims of escalated behavior, including carjacking at gunpoint and being fired upon when attempting to stop a car theft. Our communities have stepped up, though. They have spent money on additional police patrols. They have spent money on marketing campaigns to encourage locking doors, removing key fobs from cars, and keeping garage doors closed. Neighborhoods that have been repeatedly targeted have formed neighborhood watch groups, and police departments in the region have formed a task force and are sharing resources to further protect the public. The legislature should play a role in helping to reduce this criminal activity, and I ask that HB 6669 be a starting point. I've read much of the testimony on this bill, and it's clear that there's room for improvement and that this language should be explored for a starting point and also have input from law enforcement, as well as the Criminal Justice Division and Connecticut Justice Alliance. I would additionally like to support SB 1093, specifically the changes to section 6 through 7 regarding consent searches. These changes would encourage more proactive policing, which removes guns and drugs from our neighborhoods. The original intent of this language was to eliminate poorly performed searches and protect civil liberties. I believe that these changes would protect that intent while also allowing better police work. I'm not here as an expert in this subject matter, but simply here to share feedback from my community and to ask for your help. I also want to point out the comments from Chairman Stastrom that this is not just a Judiciary Committee work. This is work from the Children's Committee and Appropriations Committee, and we do need funding for these efforts. Thank you for raising these bills, and I look forward to hearing the discussions. Thank you.
Thank you, Representative. Questions or comments from the committee? If not, I will thank you for your advocacy and for being with us today. Next up will be Deborah Shander.
Good morning. My name is Deborah Shander, Senator Winfield, Representative Stastrom, and distinguished members of the Judiciary Committee. I am your state librarian. I am here to speak about House Bill 6665 concerning the removal of race-based restrictive covenants in land records. While the state library fully supports the important intention behind this bill, we must oppose the procedures outlined in it. We also propose the formation of a working committee, which will allow the many stakeholders impacted by this legislation to develop successful procedures. The state library is responsible for municipal records management, including land recording and the preservation and accessibility of Connecticut's history. We have three concerns about the procedures outlined in this bill. One, from a legal perspective, the procedures appear to be in direct conflict with current state statutes on land recording. Two, from a practical perspective, the state library and the municipalities will be unable to carry out the procedures as currently written. And three, from an archival and historical perspective, the procedures may lead to unanticipated results from what the drafters intended. Let me go into a little more detail about each of those concerns. Legally, the statutes governing land records include the following requirements. One, that they clearly and accurately reproduce the original document. Two, that they are recorded at length and have the force of the original record. And three, that the town clerks attest and seal that they are true copies of the original instrument. The procedures currently outlined in this bill would require the clerk to remove the original recorded document and replace it with an updated version. This procedure would be in direct conflict with the requirement to accurately reproduce the original, and it would make it impossible for the clerk to properly certify them. It could also inadvertently lead to legal issues impacting all land recordings. From a practical perspective, land records are bound together in permanent volumes. Removing a page from a sewn binding and adding a new one would have to be done by a qualified conservation or bindery vendor. Removing volumes from their storage vaults also put them at risk. These services are expensive and would have to be done at significant cost to the towns. This requirement would then prove to be an unfunded mandate. The bill also requires that the original pages be transferred to the state archives. This would require significant resources in the area of software, storage, transfer, and staffing, none of which are currently in place at the state library. There is a clear historical record of discriminatory practices in land recording, but removing these documents just segregates them from the rest and makes it harder for researchers to identify and understand the historical context in which they were created. Removing these records will not remove the negative impact that they have had. As the committee is aware, this is a complicated issue. We can formulate an approach that will work well, but this requires input from many different stakeholders. The State Library welcomes the opportunity to join a working group established by the committee to develop these procedures for Connecticut. Thank you, and I would be happy to answer any questions.
Representative Fishbein?
Thank you, Mr. Chairman. Good afternoon. Well, no, it's afternoon, just today. How many deeds or documents that would fall under this, well, I think it is just deeds, are in the possession of the state library?
Currently, most of them are in possession of the towns themselves. I don't have the exact number, but I could look into it if you would like.
Okay, when you say most of them, are we talking less than 100 is in the possession of the state library?
You know, I don't know the answer to that question. I'm new and I'm still learning some of these details.
Okay, because, you know, and I'm learning too. I learn every day. I was not aware that the state library was in possession of any deeds, quite frankly. So that's news to me. You know, I very supportive of this legislation, and the way I read it is, or the way I read it and envision it is, you know, somebody's doing a title search. They come across this offensive language. They bring it to the attention of the municipality, because it expressly deals with the municipality only. And then certain procedures come into place. So I think during your statement, you talked about resources to find these things. And I don't read it that way. Can you just point me to the portion of legislation that would call for, you know, a task force to, you know, go to every municipality and identify these? Because I did not read that in here.
I apologize if I gave that impression. I don't believe that there was the intention that this would go forward. It would just be, if these are identified, that they would be removed from the records, the storage that they are at with the municipality, and then those individual records are taken then to the state library.
Okay. And based upon the procedure that I see in here, because there's two components to the bill in its entirety, that would happen, you know, once every maybe month at the most. So I'm trying to figure out, you know, you talked about unfunded mandate, which obviously is a flag to most legislators. You know, I don't see the burden unless you have more information for me with regard to that.
I currently don't have the numbers, but I would be happy to look those up for you. I think the concern is that these procedures are not currently in place with the cities or the state library, and would create an additional requirement for everybody to do. And I certainly understand not wanting to make that an unfunded mandate.
Yeah, I mean, I don't, you know, it just, to me, it just seems simple. You know, somebody finds it, they go to the clerk, they say, hey, you know, there's this law, you know, I think you should do something about this in conjunction with the law. The clerk looks at the law, they've probably been trained on it. X, Y, and Z happens. I really don't see a big burden here. But, I thank you for coming here today and giving your perspective. Thank you, Mr. Chairman.
You're welcome.
Thank you, Representative. Further questions or comments from the committee? If not, appreciate being with us.
Thank you.
Next up will be Adam Yagaloff.
Good morning. Thank you. My name is Adam Yagaloff. I'm an attorney at the Center for Children's Advocacy. I'm speaking on behalf of Bill 6667. I'd specifically like to point to the part of the bill on page 43, sections 14 and 15 that make phone calls free for children in Connecticut incarcerated at our prisons. I testified last week, and one of the questions was, well, is there a way to do a bill that's just for minors? This is that bill. I support the larger phone call bill, but this is a break off of that. I heard some of the debate this morning around the other bills, and I think it's a very lively debate, and I appreciate all the sides on it. I especially appreciated hearing from people who represent the districts where some of these thefts are happening with the cars. And the understanding I got, and someone can correct me if I'm wrong, but it sounds like people understand that this is a complicated system and that we're not looking to incarcerate people for extended periods of time or longer than necessary to make sure that when they come out, they are better citizens. And, as I'm thinking about the cases that I have and the reason for this phone call bill. The reason is that when young people go into our prisons, the life is often very chaotic. The school is not in place, not necessarily. Their mental health supports aren't in place. And in general, they just have a lot of free time. And what we see is that free time is one of the worst things that can happen to a young person in the process of committing crimes. But what these bills try to address, this phone call bill specifically, is to say, well, when someone enters a correctional facility in Connecticut, can we start the reentry process right from day one? And can we make sure that when they hit the ground back being released from prison, can they have all the supports in place that they need to avoid the free time, to avoid the things that have caused them to get there in the first place? And we see the phone call issue as an issue of reentry. If you're not able to speak with your family and your loved ones, if you're not able to plan for your reentry, plan for your school, plan for where you're going to live, plan for where you're going to get your mental health care, plan for when you're going to get your medicine, plan for when you're going to get your IDs. When you hit the ground, these situations become very chaotic from day one. And so what we see is this as an opportunity to continue the efforts that Connecticut has made to make our citizens all safer. Crime has gone down in Connecticut over the decades, and one of the reasons we think that's happening is because we've taken a nuanced look at what's happening in our systems and how can we make it better for young people. And we believe this bill does this. I'd also like to say that the commissioner of the DOC has testified twice now. He's testified that he supports this bill. So we would ask that the legislator pass this bill and make phone calls free for all minors in Connecticut. Thank you.
Thank you, sir. Questions or comments from the committee? If not, appreciate being with us.
Thank you.
Next up will be Barbara Fair.
Good afternoon, Senator Winfield and Kissel, Representative Stastrom and Feinstein, and other distinguished members of the Judiciary Committee. My name is Barbara Fair, and I'm a West Haven resident, a mom, a grandmom, and a great-grandma. I'm a member of Stop Solitaire Connecticut and a Connecticut licensed clinical social worker. But today I come here as an individual who has been committed to shaping public policy for decades. I'm accustomed to how quickly 3 minutes slips by, and so I'm not going to spend a lot of time with juvenile justice facts because I'm certain most of you have already heard many of them. I'm going to spend more of my time talking about a system that disproportionately impacts children and adults of color, a system that continues to maintain itself despite all efforts to dismantle it. And I say dismantle as opposed to reform because we've done many decades of reform, but that reform has not changed this system into one that has eradicated racial injustice. So I just want to talk about some of the things that I heard in the meeting this morning. One of them, when I heard Senator Champagne repeatedly say that it's difficult to go to prison in Connecticut, it's a clear indicator that legislators live different lives. If you look at Connecticut state reports in 2019, 69% of young people in corrections are there unsentenced. That indicates that children are being arrested. When we look at Connecticut statistics around racial lines, we see that although Black people make Black youth make 12% of the population in Connecticut, they are 43% of the prison population. When we look at Latinos, who make up 21% of Connecticut population, they make up 40% of the jailed population. And then we look at white children, who make up 61% of Connecticut population, but they only represent 16% in Connecticut prisons. So that makes it pretty clear that for some youth, it may be very hard and difficult, and it may be a lot of arrests before they actually go to prison. But when you look at those stats, that doesn't apply to Black and brown children. Decades of reports have continually showed that racial disparity is persistent in Connecticut jails and prisons. That hasn't changed with all the efforts that we've made and all the laws that we've made. And so it just makes me begin to wonder, why do we continue to do this until we start acknowledging some facts around racial disparity? Statements such as chemical restraints and prolonged isolation are necessary tools within DOC continue to disturb me. And coming up with those worst case scenarios do not justify the abuse, the terror, or the torture that goes on behind bars. Declaration of Human Rights, the Universal Declaration of Human Rights and the United Nations say otherwise. And so for me, in my opinion, racial justice conversations are the most necessary tool that needs to happen in Connecticut and definitely within DOC. And I think if we just recognize and affirm the humanity of all people, that will be our first step in changing the persistent racial disparity that goes on in Connecticut and Connecticut's prisons. We all know what we need to do. Is that we have to have the will to do it and the will to protect all children. Thank you. And I think I forgot to say, but I am testifying in support of HB 6667 and HB 6669. I totally support it.
Thank you, ma'am. Thank you, Mrs. Fair. Questions or comments? If not, we appreciate you being with us today.
Thank you.
Next up, we will hear from Glenn Lungarini.
Yes, good afternoon. Co-chair Senator Winfield, Representative Safstrom, Ranking Member Senator Kissel, and Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Glenn Lungarini. I am the Executive Director of the Connecticut Association of Schools and the Connecticut Interscholastic Athletic Conference. CASI-IAC represents approximately 1,000 public and parochial elementary, middle, and high schools in Connecticut. We support a wide range of activities, both academic and athletic. The CIAC is the governing body for interscholastic athletics. CASI-IAC advocates for the best interest of schools, students, faculty, and administrators, and providing exceptional education-based experiences. I am submitting my testimony and speaking today in support of SB 1088, which enacts the protections for sports officials. Throughout the country, similar legislation has been passed to protect officials as well as volunteer and paid coaches. Over the past few decades, the culture of youth and amateur sports has changed from a venue that provides kids with the values of teamwork and skill sets to fight through adversity and achieve one's goals to a competitive business, one where kids play for championships every weekend and are enticed by the prospect of collegiate championships. Along with this culture shift, the pressure and scrutiny on officials and coaches have led to a nationwide shortage in both professions. There have been too many incidents of officials and coaches being followed to the parking lot after a game or assaulted on the actual field of play in youth and amateur sports. Some of those that you have heard today from previous testimony. The protections provided by SB 1088 are necessary for the safety of our current officials and critical in the recruitment of future officials. CIC also encourages the committee to consider amending the bill to include volunteer and paid coaches for the same rationale that this legislation is necessary for officials. Thank you for allowing me the opportunity to provide this testimony.
Questions or comments for Representative Fishbein?
Thank you, Mr. Chairman. Good afternoon, sir. I expect that you've been here for most of the testimony here today, correct?
Yes, sir.
And, at least my theme or my concern has been the inadequacy, or is there an inadequacy in our current law? And can you give me an incident or instance where a complaint was made to law enforcement and nothing was able to be happened under our current law?
In Connecticut, I haven't seen too much in Connecticut in that realm, but I think largely it's because of a culture where many things are accepted as just part of the game. And where I can point to this and see it as we've researched the necessity for legislation like this for officials and coaches was a case that came out of Pennsylvania, was the Commonwealth of Pennsylvania versus Peter Dukovich. And, this is a case where a parent came out of a stand and physically assaulted an official during the basketball game. And the outcome of that was that the parent was convicted of simple assault, but was acquitted from 3 other charges in that case. And again, largely because the arguments were made and there was a perception that some behavior is acceptable just as parts of a game. So when you look at the assault and harassment of officials and coaches, having legislation that particularly ties to those classes of workers and officials, I think does lend to it the support necessary to provide protections, particularly in the culture that has evolved in sport.
And how, I understand that was not a Connecticut case, but how would this legislation change that situation? In fact, it may even negatively impact it, which I'll get to in a moment, but how would this law change that situation?
The law that we would have here that would place the emphasis on actions or assaults that go against officials would again give more credence or at least more weight behind these charges being forward. I think our officials would certainly feel that they have more recourse and legal recourse than maybe they currently do. I've seen it as a player, as a coach. I've seen it as well, and in my experiences through sports. And as I said, I think oftentimes the culture is, this was part of the game, but it's not, and in fact, it's not part of the game. So I think being more specific with it and having the legislation specifically for these classes is an important step in providing the appropriate protections.
So the legislation before us is specifically addressed to while the official is being an official. It says, while such other person is performing his or her duties as a sports official. So that would be on the field activity. So if a player slides into third base and is called out and they get up and they punch the referee or the umpire or the umpire then. Are you saying that our current law does not address that as I think it's a felony, but I'm just trying to get to the need for this particular law.
Right. So, I think in the case that you're describing, again, with the definition that would be provided by this law, I think does raise the standard and makes players, coaches more aware and more responsible for the actions that they have on the field. But when we consider the duties and operations of the official, it actually extends beyond the conclusion to the game to the point where the officials leave the facility. And it carries to that point in that officials in cases where ejections were issued, if there were technical fouls in basketball, any type of, red cards, things like that in soccer. There are appeal processes that exist where coaches can speak with the officials about that process, about that card or that technical foul that after the game has concluded. And that's where that appeal process or due process, if you will, for a kid who's been ejected for a game actually takes place. So they're still serving in that capacity. And, and again, as has been shared here, where you may have aggressive actions to officials, either as they're in the facility, exiting facility, or going to a parking lot after. Again, this would apply, I believe, in those cases based on the way it's written, because they're still serving in their capacity.
Okay, so a teacher who's assaulted in the classroom, that is held to a different standard than a sports official. The sports official is carved out here with a higher. So public policy says that it's okay to punch the teacher, but not the sports official. That's what I take away.
No, I mean, as a principal for a number of years and a longtime educator, again, I do think that as a teacher, that when there's behaviors like that in classrooms, it is addressed significantly. I think the difference is more aggressive behavior tends to be viewed or perceived as acceptable when you factor in the emotion of sport and the physical contact that often comes with sport. So at times, a clear delineation through law helps significantly with managing those expectations and those behaviors.
Okay, but a gym teacher who's, coaching intramural basketball is essentially in the same role as the referee that this law deals with. So why do we treat the two differently?
Well, again, I think that depends on the role that intramural class is being taken. Again, my background happens to be in health and physical education. So, when I'm teaching a class on basketball or teaching something in an education curriculum, again, my focus is on the lifelong benefits of that. It's not necessarily on a competitive game. It's, kids are reminded, and when you set up that environment in a classroom, it's done for the benefit of physical activity and sport. It's not done with the intent of finding, who is going to be the state champion or who is going to be the AAU champion at the end of that class, the end of the weekend. So the focus in the classroom, I think, is much different than what the focus and purpose is when you're on the field competing for a state championship or a private club AAU championship.
That's a different scenario, but I understand your position. I mean, when I went to high school, we played floor hockey in the gymnasium after school. That was refereed by a teacher. That individual would be held to the assault of that individual, the intimidation, the threatening activity of that individual would be held differently under this law. So I thank you for your perspective, and thank you, Mr. Chairman.
Okay. Thank you, Representative Gilchrist.
Thank you, Mr. Chair. Thank you, Mr. Lugarini, for being here today. I could see how, if we were to pass this law and it was then posted like at the Little League field or sent out through the communication regarding flag football, and these are the sports I am kind of involved in right now, that it would at least set the tone for parents, when they go to the game. I'm wondering, do you have any information on the states that have passed this law? Have any of those states reported back having seen a reduction in negative behaviors towards referees? Yeah, it's a great question, Representative Gilchrist. I believe there's 24 states right now that have
enacted the and legislation specific to officials. Most of that can be found through the National Association of State Officials, and NASO is the publication that some of that information can be found. So I've gone to that organization, and I've seen the language for the states that have enacted it, but I haven't seen any research done on what the impact of reduction is. The only other information I've seen with those is cases that have been brought forward under that statute, but not necessarily any correlation to reduction.
Okay, thank you. If you do find anything, I'd love to see it. My other question has to do with your recommendation to amend the bill to include coaches. Do you have any similar data that you presented on there being less volunteers or less individuals who want to be referees? Are you seeing similar information about less folks wanting to be coaches as a result of the intense behaviors of parents?
In my professional opinion, they're correlated very closely. Again, as a former athletic director and high school principal in 3 different schools, finding coaches was one of the most difficult tasks that we had, and coaches leaving their profession because of I would say more verbal abuse than physical, but again the culture and the change of it, moving away from education-based and, and the feeling that this is the opportunity for my kid to earn a scholarship, particularly at the high school level, without understanding, maybe that, and we have 70,000 kids in Connecticut that play interscholastic sports. Only 6% of those play at the college level. Only 2 to 3% of those actually earn scholarship money. And, so when we try to maintain that education base, we see a significant stress on coaches and coaches exiting the profession just because of the verbal abuse and expectation that comes along with it in this day and age and culture.
Well, again, I thank you for being here and what you do. My dad was a PE health teacher, and sports were incredibly important to me growing up. So I want my children to be able to continue enjoying sports without the harassment in the stands. So thank you. Thank you, Mr. Chair.
Thank you, Representative. Representative Callahan.
Thank you, Senator Winfield. And your questions were very good, Representative Gilchrist. It's clear that you have had a family member you're involved in the sports. So, sir, I appreciate you coming in today. Having been a high school and youth coach at many different sports and a high school official in football, done many state championship games. I'm interested in this legislation, and also, for instance, as a coach, when you're recognized in the community, if it were a negative connotation assigned with you, whether you were coaching that day or in a different part of the year, if you're recognized as a coach those days, for instance, in the off season, and someone goes after you because of your position, it seems like that this is something that you would want to cover that as well.
Absolutely. I would certainly agree with that, Representative Callahan. And, my experiences as well. I've served as an official. My father was a football official for nearly 30 years in the state of Connecticut as well. And similar experiences, as you said. I mean, there's times I could recall as a kid, walking through the store and comments being made to my father following a Thanksgiving football game. And so yes, absolutely. I mean, those things happen, and you want to be protected because, again, it's I think that just the society and the culture has changed where there is a concern what 20 years ago, 25 years ago, maybe that wouldn't be perceived as much as a credible threat, but today it very well could be.
Well, thank you for your testimony, because I can recall driving home with my crew from games, stopping for pizza somewhere, and being verbally attacked in a restaurant because they didn't like a call. So yeah, I guess if you're a card carrying official, you're a card carrying official, and same thing as a coach. So I appreciate your perspective today, and I thank you for coming in, and thank you, Senator Winfield, for the time.
Thank you very much, Representative Callahan. Any comments or question from members of the committee? Comment or question? I do not see any. I want to thank you very much for joining us and offering us your testimony today. Have a great afternoon.
Thank you, sir.
Next, we have Kathy Flaherty. Is Kathy Flaherty ready to go?
Thank you, Senator Winfield. Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project. We provide legal representation in civil legal matters to people who are eligible for mental health services from the Department of Mental Health and Addiction Services. I'm here today to testify on two bills, Senate Bill 1084 and Senate Bill 1092, in favor of both, but with the suggestion that you consider adding some language to 1084 to make it clear that the demographic data must include disability, including breaking down the kinds of disability, and don't limit this discussion to just DCF and DOC. Please include DMIS and DDS in that. People who have disabilities deserve to be parents, and they should get the support and services they need to be parents. And DCF needs to stop acting from a perspective of predictive neglect, thinking that people with disabilities are incapable of being parents. I thank you for your time. I know you have a long agenda. Happy to answer any questions if anybody has them, but if they don't, I'm also happy to leave.
Thank you, Kathy. Comment or question from members of the committee? Comment or question? I do not see any. I want to thank you for joining us yet again. Enjoy the rest of the afternoon.
Thank you.
Next, we have TJ Elgin. Is TJ Elgin ready to go? TJ Elgin. Evelise Carrera.
I'm here. I didn't expect to be called so soon. I usually get called later in the day, so
it's a good
move this around. I get the day to myself now, so I'm kind of excited. I know last time, Senator Winfield, I think we were on the Zoom at 8 p.m. or so. So is my screen freezing? Or can you guys hear me?
We can hear you. I think the senator might.
You know what? I think Senator Winfield's struggling. He's having some internet
Me and
issues.
Senator Winfield were on the Zoom, so
So
God knows
go ahead, ma'am.
okay, perfect. Thank you. To start my 3 minutes, I've heard a lot of fear mongering, and we have yet to discuss the fact that Connecticut has been proven to pull Black and Latino drivers over at higher rates in Connecticut, cannot be trusted to act on their own, given just the data collected and proven facts. As a taxpayer-funded entity, police must be legislated, and just like any career funded by politicians, should answer to the people. Police in Connecticut are already woefully undertrained, with training that averages about 22 weeks, and yet hairdressers on average train about 36. The attacks on civilian review boards will help these undertrained officers continue to place themselves in deadly situations and shoot their way out when they make mistakes without consequences. Crime rose last year in all 50 states, whether they increased police funding or have defunded the police. But before that rise, when crime was still dropping, police shootings on the populace were already on an upward trend. The temporary crisis caused by the pandemic should not cause us to legislate on when it is acceptable to kill people based on insured property that can be replaced. We are in a pandemic that has destroyed the economy, and scrap metals just happen to be something that will bring income to a broke person. We had to wait a really long time for our stimuluses, so that's what happens. These dog whistles and white fear as the dog whistles and white fear continue, we will continue to embolden police, and that has not been proven to reduce crime. Police haven't placed themselves in dangerous situations, such as jumping in front of cars in Wethersfield or almost shooting a fellow police officer in the shooting death of Shamar Ogman in Hartford this past December. With police deaths at record lows, even when you include COVID deaths, loggers and dentists are still dying at twice the rate of police, but they do not have unions or qualified immunity. I was personally approached over the summer by a Meriden police officer.
Ma'am, I gotta jump in real quick. What bill are you testifying on?
The
And,
police accountability bill.
okay, all right, go ahead.
Okay. A police officer from Meriden approached me over the summer and told me he would no longer be able to give breaks to drunk drivers to allow them to call family and pick up their vehicles due to the body cameras. But I, being the victim of a drunk driver, need to know why I don't deserve the protection that I paid for. I need to know why police need to turn off their cameras if they're just doing their job. I need to know why they would not want to protect themselves from false allegations. And if they're not breaking the law, would it be reasonable to assume that they have nothing to hide? We have this false fear that good police leaving to the pressures of increased responsibilities is a crisis, and yet we're not thankful that these people that cannot handle high pressure situations with increased accountability are leaving to do something else. As we point the fingers to bad parenting, mental health, and a million other factors as a distraction on to not act or legislate their behavior, I've personally witnessed as a court employee, Hartford police slamming a childhood friend on the sidewalk and him landing on community court the next day.
We're well past the 3 minutes. I need you to.
Oh, I'm sorry. I'll wrap it up now. The sob stories of a few good apples does not outweigh a system built on the policies created by slave catchers and union busters from Pinkertons.
Thank you.
Does anyone have any questions?
Thank you. Are there questions or comments from the committee? If not, thanks for being with us.
All right. Thank you very much for letting me speak.
Christopher Dukes will be next.
Good morning, sir. I'm not sure if you can hear me. I know you can't see me, but I had no control over this video as far as I know.
That's okay. We can hear you.
Excellent. So good morning, all folks. Today, my name is Christopher Dukes. I'm a Hartford resident. I will be speaking on bill number, oh, wait a minute. There it is. Someone gave me the ability to do it. I believe I just lost it.
Yep, we can see you, sir.
Excellent. So bill number 1093, and specifically points the police accountability bill here, and specifically to provisions 1 and 5. Provision 1, that being the any objection concerning the enforcement of subpoenas by a civilian review board. I am personally a victim of what will probably be known as one of Connecticut's ugliest stains when it comes to the police brutality from the administrative point of view, whereas having an effective civilian police review board would have prevented, well, actually, you shouldn't even get to that point, but the ability for officers to escape culpability for crimes committed against citizens where evidence has been planted is something that's available if we don't have this subpoena power. My understanding is that the same restrictions apply to investigators within internal affairs in various departments, specifically the Hartford Police Department. They also do not have subpoena power. They are also restricted from doing an exhaustive review of collection of evidence, or the exhaustive collection of evidence and a review because of the lack of ability to have subpoena power to get what they need. Had such provisions been available, the matter that I'm talking about, well, not just my own matter, could have been prevented. So just to give you an example, and some of you may know of my situation, I was falsely accused of a domestic violence situation back in 2018. It's now coming upon 3 years. This case number was 18-11312. The case was completely dismissed by state prosecutors who unfortunately misled the public and misrepresented, or actually misled all of you in terms of the reasons why. I actually did provide them with more than 3,000 pieces of evidence confirming my innocence, and my case was completely dismissed. However, when it comes to civilian review boards, this matter is still pending because when I filed my report this past September 1st to be exact, 2020 with the Hartford Police Department, it's case number 20-050. That case is still pending now. We're well beyond the 60 days of the investigation. It's because the investigatory entities are limited in their ability to do their job. Since then, someone who would benefit from me being silenced ambushed me in my driveway and fired 3 bullets into my vehicle. That case is under investigation. It's 21-1650 with the Hartford Police Department, and that case is still pending, which is not acceptable. Then I also filed.
Sir, we're well past the 3 minutes. I just need you to summarize.
Yes. So my last remark regarding the ability to have the transparency that even the Chief of Police Association would like by having these cameras not being turned off. We need to make sure that's taken care of. For example, Stephen Barrier lost his life to Stanford Police. And had those cameras been running the way they were intended, we would have the transparency and the accountability to understand what took place. Thank you all for your time. I'm open to any questions by any of the representatives who really take their oath serious regarding defending and upholding the Constitution of this state, because there have been severe violations happening.
Thank you, sir.
Thank you.
Are there questions or comments from the committee? If not, we want to thank you for being with us today and sharing your perspective. Next up will be Barry Mono, followed by Andrew Feinstein. Mr. Mono, go ahead.
Do you have me?
Yep, go ahead, sir.
Well, good morning or almost good afternoon. I'm Barry Mano. I'm the founder and president of the National Association of Sports Officials, a 501c3 not-for-profit association headquartered in Racine, Wisconsin. NASO is 40 years old. It has 27,000 dues-paying members at all levels of sport, from youth to rec to club to high school, college. Should report out that the referee last night, Bert Smith, that you saw collapse during the Gonzaga game, is actually one of our members. Bert's doing okay. We've come together today to talk about SB 1088, proposed legislation to deal with the assaulting of sports officials. Question is, why are we considering this? Why is this being considered? 22 other states have enacted this type of legislation so far. And NASO has been involved in most of those states in helping get that passed. There's a severe shortage of sports officials nationwide, like nothing we've ever experienced. And this was pre-pandemic. Now that we've experienced the pandemic, we see that registration of sports officials at all levels, don't worry about major college and pro, they don't count. At all the other levels, pandemic has caused a 30% decrease in people registering to be sports officials. Now, even pre-pandemic, one of the key reasons why there has been a shortage of warm bodies, as I like to put it, has to do with the bad behavior of fans and players. That's been a key factor why officials start, and after less than 3 years, 70 to 75% of them quit being a sports official. And it comes out clearly through our survey that we did just a couple, 3 years ago, where we got 17,000 responses, 9 million data points. And that survey reported this: 64% of those responding had to remove a spectator from a contest. 57% had to step in and break up a fight or a skirmish during the game. 47% of the officials felt unsafe. When you just consider female officials, that number now exceeds 52%. Feeling unsafe in the conditions, and 13% had been physically assaulted during or after a game. So that's why we're here considering assault legislation. A big aspect of this has to do with the PR value of making a defined class. You know, in many states, they have defined classes. As well, you know, you have teachers, you have public transit drivers, you have police, firefighters, as a protected defined class. It sends a message to the general citizenry that we think this class is very important to the cultural undertaking that we do as a society. Certainly sports has become critically important in our culture. Strange for me to say, maybe it's gotten too important, but there it is. It's that important. And we as sports officials make sure that the game is played by the rules while emphasizing fairness and safety. That's our job. That's what we care about. So we're looking forward to having this type of legislation enacted to give us an extra measure of protection. Thank you.
Thank you, sir. Worst part of my job is having a referee the time here, but
I saw you coming, so
you did a good job of getting there. Representative Gilchrist.
Thank you, Mr. Chair. Thank you, Mr. Mano, for being here today. I asked this of the previous speaker who spoke on this bill, but since you have a national perspective, I'm wondering if you have any feedback from the states that have passed this legislation. Have they seen a change in behavior at sporting events and or an increase in the number of folks willing to serve as reps?
That's an important question. We don't have the analytics. You know, it simply isn't there. What's going on in a general matter is people always ask me this: are there more assaults going on? And the answer is yes. There's two things happening. There are definitely more assaults. We get reports of physical assaults every single week of the year here in our offices. There's more of it going on than ever. And number two, importantly, it's now being reported. You heard somebody earlier say back in the day might have been assaulted but never reported it, because where were you going to report it? Back then, kill the umpire was sort of the, order of the day, if you will, even though those just words. Today, NASO is here. Today, NASO provides assault protection insurance for every one of its 27,000 members. I never thought about that when I started this association in 1980, that we would need that as a benefit. So there's more assaults going on, absolutely, and more of them are being reported. But to answer your question, we don't have the hard analytics on the back end of this yet.
Thank you. I understand that. Having done campus sexual assault work, we always say just because there's more reports doesn't mean more sexual assaults are taking place. It's just we've done a better job at making it where people can report. Thank you.
You bet.
Sir, you mentioned a number of other states who have looked at kind of this type of legislation. The legislation before us proposes a C felony, which is punishable by up to 10 years in prison under Connecticut law. I'm wondering how that penalty compares with the legislation that's passed in other states, whether 10 years is on the high end or par for the course or on the low end with respect to the legislation that's passed in other states.
That would be on the high end.
Okay. All right. What do most states, what's the penalty in most states? Do you know?
Well, it raises it off a simple misdemeanor. And as you know, in different jurisdictions, it becomes something different from a class 1 to a class 2, or it could even be a felony. Generally looking at it, you can get up to a year, some places up to 2 years. There's community service involved. We're not trying to incarcerate somebody for a long period of time. We're trying to send a message that this is not acceptable in our society. It'd be like if you're in a court of law and you saw somebody jump over the bench and slug the judge. Hopefully it would be abhorrent to you. We as a society would say, no, that is simply not acceptable, even though we don't like what the judge was rendering. That's our situation. You don't like what we're rendering. You don't like the call we made. We're sorry about that. There it is. But we need to provide protection because sports, certainly at the youth and rec level, has become so doggone important to us that it needs to be learning for the kids. It needs to be an extension of the classroom.
So I'm trying to get a comparison of this legislation versus nationally. So I think you said there was about half the states have enacted this type of legislation, 24? 22. Okay. And of those 22, is it your testimony that the majority of those states impose a penalty of up to a year in prison or up to 2 years in prison?
Right. And I think what would be good, it's when you have time, if you went to naso.org, we have a whole legislative section there, and those things are listed. So you could actually go through the 22 states and see, in fact, what the penalties are in those states.
Okay. So if we were to amend this bill to provide a Class A misdemeanor, which is punishable by up to a year in prison, is that something that would be more in line with where other states are on this, do you believe?
I think that's a good observation. Yes, sir.
Okay. Thank you.
Mm-hmm.
Further questions or comments from the committee? If not, I appreciate you being with us.
You bet. Thank you.
Next up would be Andrew Feinstein.
I'm here. Thank you very much, Mr. Chairman. Chairman Winfield, Chairman Stafford, ranking members Kissel and Fishbein, my own Representative Howard, and members of the committee. Special Education Equity for Kids in Connecticut is a statewide organization of parents, providers, attorneys, and advocates seeking high-quality education and civil rights for students with disabilities. I'm here today to speak in favor of Section 11 of HB 6667. SEEK is opposed to all forms of exclusionary discipline, out-of-school suspensions, expulsions, school-based arrests for anything other than major felonies. Such exclusionary discipline is not educationally sound. It prevents the student from learning any academics. It's not behaviorally sound. There's absolutely no evidence showing that excluded students learn their lesson or mend their misbehavior. And it's not sound school management. It shows misbehaving students that the school is powerless to deal with them, and all too often they learn that the juvenile justice system is also impotent. Exclusionary discipline tells the alienated student, the student who feels like he or she doesn't belong, that he or she in fact does not belong. It provides no punishment for the student, but exacts a heavy toll on the parent or guardian. It identifies the aberrant behavior and usually makes it worse. Exclusionary discipline has only one thing going for it: it's cheap. But it's also tremendously discriminatory in application, both racially and against students with disabilities. In my extended testimony, I have some data on that, and I can provide tremendous amount of additional data on that. Now, there are undoubtedly students who, because of their behavior, cannot remain in the regular classroom. For the safety and learning of other students, for their own safety, and often for the safety of the teachers, these students do need to be removed from the classroom. What they need is a therapeutic setting with challenging academics, strong therapeutic intervention, physical activity, and mentoring. Certainly, they need to be evaluated for special education because serious classroom behavior is the very definition of an emotional dysregulation. They need to be placed in a therapeutic setting with goals and objectives, both academic and behavioral. As soon as they start meeting their behavioral goals, they need to be reintegrated into the classroom. The current one-year time limit for expulsion is irrational and punitive. More than that, it is an embossed invitation to drop out. It is the welcome mat for the school to prison pipeline. Now, the therapeutic setting is not a radical idea. Virtually all expelled students need to be provided with public education under current law, and current Department of Education guidance provides a broad template for the type of therapeutic setting needed. Now, Section 11 of HB 6667 sets up a working group to plan for the elimination of out-of-school suspension and expulsion for all students. Currently, it's not an option for students in grade 2 and below, except for that horrible unwarranted exception, which is being corrected by Section 10 of this bill. SEEK would be proud to serve on such a working group. It's time for us to I'm done. It's time for us to stop telling behaviorally challenged students that they are unwanted, shunned, exiled. It's time for us to tell them that we love them, that we want to help them, that they belong, that we want them to be part of society. Section 11 of HB 6667 starts that process. Thank you.
Thank you. Representative Howard.
Hey, Mr. Chairman, Mr. Feinstein, I just want to welcome you. Thank you. Thank you for doing the work that you do. I'm not sure if you were on earlier for my dialogue with Sarah Egan from the Advocacy Center, sort of teased a bit of an idea there. If you could just reach out through the website to my office, we'll set up a time and get together. I'd be happy to work with you on that.
I'd love to do that. I'd love to meet you, sir.
Sure. Thank you, Mr. Chairman.
Thank you. Further questions or comments? If not, I appreciate being with us today, sir.
Thank you very much, sir. Appreciate it.
Next up will be Christina Quaranta.
Good morning. Hi. Good morning. Or good afternoon. Good afternoon, Chairman Winfield and Staffstrom, distinguished members of the Judiciary Committee. My name is Christina Quaranta, and I'm the Executive Director of the Connecticut Justice Alliance. We're a statewide youth adult partnership working to end the criminalization of youth. We do this through organizing, advocacy, public policy tools, I'm here this afternoon to testify in support of House Bill 6667, an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee, and in opposition to pieces of House Bill 6669, an act concerning juveniles and motor vehicle theft, investigations of certain pending juvenile matters, and reporting requests to detain arrested juveniles. For House Bill 667, we strongly believe in raising the minimum age of arrest from 7 years old to 12 years old, free phone calls for incarcerated youth. We believe in banning the use of chemical agents on young people. We believe that pretrial folks should not be housed in the Department of Corrections, even when charged as adults. Instead, they should be held inside of the judicial branch facilities. We also believe in alternatives to arrest and true diversion. We strongly urge the Department of Corrections to move towards a place where they are able to hold young people in their spaces. We also strongly believe that a young person and other community members must be appointed to the JJPOC table and that the juvenile transfer laws should be amended. We also feel that the purview of the JJPOC should be expanded to cover the under 21 population instead of just through 17. And we believe in expanding and creating a new pre-arrest juvenile diversion model and feel that misdemeanors should be decriminalized and dealt with appropriately. A lot of my other colleagues before me and they're coming after me are going to talk to you more about the JJPOC bill. So I'm going to use the rest of my time this morning to talk about House Bill 6669. I have extensive data on this car theft bill. I'm here in opposition today to many pieces of it, largely due to the punitive nature of it. The Alliance and other advocacy organizations, youth, families, communities have repeatedly asked for investment in programs and services. And I heard Representative Turco ask for the same this morning that will help young people to be their best selves. However, the legislature and other folks continue to respond to this act with little funding and solutions that are not only deficit-based, but are mostly rooted in incarceration, punishment, and further disenfranchisement of Black and Brown community members, especially young people. This is an error in thinking. At the conclusion of my testimony that I submitted written, you'll find cost-effective solutions for car thefts. Like clockwork, when the weather starts to turn cold, you see headlines in newspapers, folks are posting in Facebook groups talking about upticks in car thefts, and people will ask, what are we doing with these kids? So Connecticut's been having this conversation since 2018, even before that, about car thefts and how to effectively work with them and stop them. We do have the answers. I believe that because of where the thefts or the break-ins are currently taking place, solutions that would actually improve public safety and allow for young people to be rehabilitated are being ignored, with much attention being placed on incarceration, surveillance, punishment, and harm. In summary, CTJ strongly opposes pretrial GPS monitoring. We really feel like Connecticut should be expanding programming and services and not surveillance. I feel like the bill completely misses the point and the opportunity to invest in young people, families, and communities. We don't need more surveillance, we need the services, and it's time to really meaningfully invest in youth, families, and communities, and we call for investment and not incarceration. Thank you. Happy to answer any questions or share data as needed.
Thank you. Questions from the committee? Christina, I want to ask, I've looked at this data and I know you and I have talked about this issue on and off, and the data in Connecticut is pretty clear that actually 2019 had one of the lowest rates of car thefts in recorded Connecticut history, right? Mm-hmm. It was literally the lowest rate we've seen in decades. I think it's undisputable that the data shows an uptick in 2020, particularly after March of 2020, and we all know that corresponds to really the start of the pandemic. So if not this legislation, how would you propose that the legislature, not even specifically this committee per se, but how would you suggest that the legislature respond to what is, I think, justifiable concern by residents, folks in the community about, an uptick in car thefts over the last year or so?
Sure, I appreciate the question. And I think I want to say that with respect to victims of car thefts or car break-ins, research shows nationally in other states, even some efforts here in Connecticut, incarcerating young folks is not going to be the answer, or adults too. You can't arrest our way out of the problem here. We really need to be, and we have the data we can share with you in terms of what programming might look like and what it looks like in other places where car thefts have been dramatically reduced and where they were even dealing with more severe problems such as carjackings, things like that, right? And I heard Rep. Wood talk a little bit about that earlier. So if not incarceration or GPS monitoring, things that I feel like are Band-Aids on a larger problem, right? Because a young person or an adult is not going to be incarcerated forever. They're not going to have that ankle bracelet on for forever. The answer is figuring out the root of the problem and addressing that. And you're right, it doesn't only lie in the hands of this specific committee, but in the hands of others. We talked earlier about children's appropriations, et cetera. It's a conversation that we all have to have together. And we have started and have been having with the judicial branch about what can we do to expand services for high-risk kids so that they have a place to go and somewhere to be that's actually rehabilitated, that's going to change behavior, because otherwise we'll be having this conversation again next session.
Representative Doucette.
Thank you, Mr. Chair, and thank you, Christina. Looking at your testimony here, you mentioned Public Act 19110, which, as we started hearing more of this concern about car thefts from the police and from the community, referred back to that. And of course, as you mentioned in your testimony, it created a program that suspended proceedings and for up to 6 months, and had all sorts of services, was intended to have all sorts of services connected with that. But you note as of December 2020, approximately 60 kids had participated in the program, and good outcomes for those 60, but it seems like a low number. And I recognize that, with the pandemic, a lot of programming probably has been suspended. So the question is, what can we do to increase participation in that program? Or you also mentioned, I see some other programs from other states, I guess. What will we need to do to implement those? And again, to increase participation overall to really put this into motion?
Sure, thank you for your question. So in terms of that program that was passed back in 2019, and they just started right around the same time the pandemic began in 2020, this is a program run by the judicial branch, and it falls under their LYNC, LYNC programming, right? It is a smaller number of young people. And now that specific program intakes low to medium risk folks. So if for some reason on their risk assessment, you test out as a higher risk youth, you would not be able to go into that program. So there have been conversations with myself, Office of the Child Advocate, other advocacy organizations to talk with and plan with judicial to say, if this specific motor vehicle theft program is successful, which it has been, it has good numbers. We have gotten even newer numbers. It's on our fact sheet here. I should have put those in. Apologies. We should really open up and figure out how to make it so high-risk youth can enroll, right? And then, so we have been talking about that and making that a possibility, and what funding for that would look like, because they need the dollars for staffing and for time and for all of those things. And then in terms of what works nationally and some of the examples we have in here, and then I think I linked an event that I was a part of last week in terms of car thefts, and we had a woman, Laurel Smith Bacon, come from Restorative Response Baltimore and talk about what they're doing there and how they really decreased their car thefts. So we're trying to do interviews with folks in other states to figure out what programming have you implemented, for how much, so what's the cost, and how can we replicate that here in Connecticut, and who would do it? So that looks like conversations and meetings with different credible messaging program, different programs that are based in the community instead of based inside of a prison, and really trying to close the loop and figure out, okay, who can contract with judicial or whoever's going to hold that contract so that young people can get into this programming, because it doesn't exist as it should at the moment, which we all recognize is an issue.
Exactly.
Yeah.
Exactly. I appreciate that. So I would just say, keep pushing on that and keep us updated as to what we can do to make those programs more robust and more successful.
Sure. And I'd be happy if you would like to talk offline more about this and see how we can partner to make that happen. That would be great.
Sure, sure.
Okay.
Thank you. Thank you, Mr.
Sure.
Chair.
Thank you. Further questions or comments from the committee? If not,
Mr. Chair?
Oh, I'm sorry, Senator Winfield.
Yeah, I'm going to try to be able to get my question out. My internet's killing me today. That's why my camera's off. Good afternoon, Christina. Just a question about what we now know in terms of data. So it's my understanding that the data demonstrates that that the way in which people think crime is increased in this area is not necessarily the case, that there's a shifting of where these types of crimes are happening that's a factor here. And I wonder if you, since your organization deals with the data, if you could talk about what impact that has on this whole conversation and our approach to solving the issues that are here.
Thank you, Senator Winfield. Happy to talk about that. And I should point everyone in the direction, it's referenced in my testimony. Senator Winfield's referencing the data that Ken Barone from IMRP over at Central presented to the JJPOC in March. He did a whole presentation, car thefts. He's got all the data and the maps. So what it looks like, I just pulled it up here, is that from 2010 to 2019, car thefts have moved up the I-91 and I-95 corridor. So basically, in sort of like simple, quick terms, car thefts have moved from bigger cities, majority Black and brown residents, now up the I-95 corridor, I-91 corridor to smaller cities and towns, where you'll see that most of the population are folks that identify as white, right? So the question here is, when in 2010, I'm looking at the map on my other screen, when car thefts were concentrated in Milford, in New Haven, in Bridgeport, in Stamford, perhaps there wasn't as loud of a drumbeat of what can we do to incarcerate young people and, you know, kind of roll back all the progress we've made. Now that car thefts have moved up and we're more in the center of the state, we're now hitting Rocky Hill, Wethersfield, Newington, Bristol, Avon. Lots of folks are saying, wait a minute, this wasn't happening here before. There has to be an uptick, which isn't true. It's just transitioned in location. But there seems to be more of a push by citizens, police, certain legislators to say, well, now we have to do something because now it's in these communities and folks feel unsafe, right? So it's just a piece of, for us, that we talk about, and I appreciate the question, when you bring up racial justice and you talk about justice by geography, I think that means too for victims as well, you know, victims of car thefts, and, you know, where it's happening, where it was happening in 2010 as opposed to now, and kind of looking at that with a, okay, well, I wonder why certain policy asks or pushes weren't being made then.
Thank you.
Mm-hmm.
Thank you. Representative Callahan.
Thank you, Mr. Chairman. Thank you for coming in today. I will say I was a victim of 2 car thefts 2 years ago, and part of the reason maybe this is expanding into other areas is because once our neighborhood, 70 cars got hit in one weekend, we banded together to do something about it. So then I think people move on to other areas. So these 16, 17-year-olds were using a device that reads my fob from inside my house. So as our neighborhoods are being hit, we are taking action to try and prevent it from happening again. So that's one of the reasons that I think they're moving on. And I have a 30-year background in probation and criminal justice as well. And that's what I was seeing too.
Sure, and you broke up a little bit. So just a summary of, you feel like you all banded together.
I'm sorry.
Oh, that's okay.
I don't know if it's the weather today, but
Don't worry.
Yeah, I think as communities are getting hit, they're taking action. I know our community put in a series of digital cameras, and we caught the 3 kids who stole my cars and hit all 70 cars in the neighborhood. And I think that word gets out in the community, and that's the car theft community, to stay away from those areas, and they move on. They move on to greener pastures, so to speak. So That's just my input and from what I saw in a real life incident.
Okay, thank you for sharing that. Appreciate that.
Thank you. Thank you both. And certainly a good PSA from Representative Callahan. Lock your cars and keep those key fobs secure and out of the car. And in those, I think you actually make the little things you can leave them in and block those jamming devices, right, Representative?
You know, they actually, what it was, Representative Stastrom, is that it's a device that can pick up the signal from your key fob from inside your house. I hung my keys by the door, so it was close enough where they could get the signal.
Yeah, gotcha. All righty. Well, thank you both for being with us and for sharing.
Thank you.
Next up will be Ronnie Henderson Smith.
Hello. Dear Chair Senator Winfield, Representative Stratford, and members of the Judiciary Committee. I'm Ronnie Henderson, and I am a Justice Advisor with the Connecticut Justice Alliance. The CTJA is a statewide youth adult partnership working to end the criminalization of youth using advocacy, organization, and policy tools. The alliance includes justice staff, justice advisors, steering committee members, which include lawyers, researchers, clinicians, and social workers who work across areas such as mental behavioral health, family advocacy, substance abuse, youth services, LGBTQ issues, legal representation, education, community, and residential services, and public policy reforms. I'm writing this testimony to communicate my strong support for HB 6667, an act concerning the recommendation of Juvenile Justice Policy and Oversight Committee, specifically for the transfer of kids 18 and under pretrial from the Department of Corrections care to the care of judicial branches. Excuse me. While I do support this bill, I believe it should include post-trial kids as well. I do not believe kids should be in prison, and I believe there should be alternative solutions to get youth who may be struggling the proper support they need. The Department of Correction works with adult offenders and is a very institutionalized establishment. Correction works with adult offenders. Forcing young people, or anyone for that matter, to become institutionalized takes away their chances for success or a better future. The Department of Correction doesn't actually help or rehabilitate anyone. It doesn't get to the root cause of behavior or help young people understand that their circumstances do not define them. And that's what we are. That's what we need to address, the root causes. Being born into or a part of family dynamics that are out of your control has lasting effects on youth people, resulting in some acting behaviors. Young people need proper guidance and support, not prison or incarceration. We need to invest in spaces where they can channel their energy into something positive and shape their minds to do great things instead of putting them in places that teach them skills to only become menace to society or react. And I believe that the judicial branch is more equipped to do exactly this.
Excuse me, sir.
Yes.
Your time is elapsed, so if you could please summarize the remainder of your testimony quickly.
All right, no problem. I basically just believe that there are alternatives to sending youth to prison as opposed to redirecting just their energy and everything as opposed to sending them to prison, basically. There's other outputs. There's other ways. I grew up in an era where, we had poetry slams and things like that to redirect our energy and things like that, as opposed to sending us to detention centers and things like that. So if there were more things in place like that, that would help. Thank you. I'm Ronnie.
Thank you, sir. Are there questions or comments from the committee? Seeing none, thank you very much. Excuse me. Thank you very much, sir, for your testimony here with us today. Next is Aaron Howard, followed by Alaric Fox.
Good afternoon, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. My name is Erin Howard. I'm a student at UConn Law, and I'm here today on behalf of the Center for Children's Advocacy. The Center is a nonprofit organization devoted to ensuring the legal rights of low-income children in Connecticut. Our attorneys represent children in a variety of matters, including child welfare cases in the juvenile court, where termination of parental rights is often a central issue. We submit this testimony in support of Senate Bill 1084, a bill that would require the collection of demographic data relating to incarcerated parents who experience a termination of their parental rights. As you may be aware, the Adoption and Safe Family Act, more commonly referred to as AFSFA, was federally enacted in 1997. This shifted the goal of child welfare policy away from waiting for parents to rehabilitate and regain custody towards ensuring timely permanency for children. By design, the Act almost always requires states to move for termination of parental rights when a child has been in foster care for 15 of the last 22 months. This has resulted in a significant increase in the severing of legal ties, sometimes making children legal orphans where there is not an adoptive home ready for them. And this has long been acknowledged by professionals in the field as discriminatory in practice, given the disproportionate impact that both the prison system and the child welfare system have on low-income families and families of color. In the 2 decades since the Act's passage, the number of children with an incarcerated parent has increased by approximately 80%, and rates of termination of parental rights have likewise substantially increased. Yale Law School, in conjunction with Connecticut Voices for Children, recently released a report that examined the consequences of the Act for incarcerated parents in our state and found that Connecticut children with incarcerated parents are at a greater risk of having their legal ties severed than children whose parents are not in prison. Extensive research shows that maintaining familial bonds can promote children's healthy development. Teachers, medical professionals, therapists, and DCF alike can all attest that certainly we at the center see in our work every day that these bonds are important. We represent numerous children in DCF custody whose only biological connections are to imprisoned parents and who significantly benefit from the weekly conversations they have with them, especially when their other parent may have disappeared from their lives due to drug use or mental health issues. It goes without saying that actively preserving familial relationships can reduce lifelong psychological trauma to all involved. Additionally, it can reduce recidivism and increase the likelihood that a child will have at least one lifelong connection in his or her life. Similar movements for reform have succeeded in liberalizing AFSFA guidelines in New York and Washington. These states now allow parents to be judged individually by the roles they play in their child's lives rather than the lengths of their sentences. Connecticut should take similar action in order to keep families together and address the systemic disparity, which it can start to do by collecting data relevant to incarcerated parents. For these reasons, the Center strongly supports the passage of Bill 1084. Thank you.
Thank you, Ms. Howard. Are there questions or comments from the committee? Questions or comments from the committee? Seeing none, thank you very much for your testimony today. Next is Alaric Fox, followed by Cindy Prizio.
Good afternoon, ladies and gentlemen, and thank you for the opportunity to join you. I am Chief Alaric Fox of the Enfield Police Department. I have had the opportunity to serve the town of Enfield as police chief for the past 3 years. This is my 38th year in the law enforcement field. I have had previous career stops as a Willimantic police officer, an FBI agent, an attorney, and with the Connecticut State Police, from which I retired in 2018 as the State Police Colonel and Deputy Commissioner of the Department of Emergency Services and Public Protection. I join you this morning to offer my support for Sections 6 and 7 of Raised Bill 1093, an act concerning civilian police review boards, security guards, body-worn recording equipment, and searches by police. I have submitted written testimony in this regard, and I would invite you to review this material at your leisure. I would take the liberty, however, of drawing your attention to the high points of my submission. During the last legislative term, Connecticut General Statutes 5433B and 5433O were modified to effectively eliminate the vast majority of what we traditionally refer to as police consent searches. Please know at the outset that I and the substantial number of police chiefs that I have spoken to share the discomfort that some have expressed that the mere asking for consent to search has been exercised in a haphazard or inappropriate manner. What is before you is a fair resolution of the competing interests in this area. The search warrant exception represents a valuable tool in our ability to ferret out criminal offenses that harm your residents, that denigrate your community, and that challenge my coworkers. To this end, sections 6 and 7 of Raised Bill 1093 seek to modify the consent to search exception, but with significant safeguards in place, namely the satisfaction of a reasonable suspicion threshold before consent to search can even be asked for, a written reporting requirement on any such encounter, and of course, any such interaction will now be recorded on a body-worn camera. All of this even preceding the subsequent judicial motion to suppress, which allows a degree of certainty that any consent to search that was obtained in a legally sound manner. It's my hope and belief that these sections represent an appropriate compromise that balances out the sometimes competing interests of individual liberty with the obligation to ensure the public safety, and that as such, you consider these aspects of this legislation favorably. Thank you.
Thank you, Chief. Questions or comments from the committee? Are there questions or comments from the committee? If Representative Doucette.
Thank you, Mr. Chair. I was slow to get my hand up there. Hi, Chief Fox. Thank you for your testimony today.
Thank you, sir.
Quick question. Do you have data either from your own department or from your experience, or is it elsewhere, about how often or how many consent searches were conducted over any period of time in the state of Connecticut? My conversations over the last year, especially with chiefs and officers, is that it's not frequently used, and I suppose it can vary from department to department. But do we have good data on how often or how many consent searches are conducted in any given year?
I could certainly compile it, as I suspect other chiefs could compile it for their individual departments. I think that the data in total is contained within the CCSU work. If the consent search request flows from a motor vehicle stop, a consent search request for an individual on the street would not be compiled, would not be realized in that reporting mechanism. It would require a hand count or at least a computer analysis to generate that portion of the data.
Okay, that makes sense. Okay, so I'll look for that. Be interesting to see. And can you explain as well, you touched on the search warrant exceptions, how those come into play under current law, and what your proposal would be to amend this legislation on that?
Yes, sir. So in training of police officers and in constitutional practice, the threshold position and sort of the default rule, if you will, is that any searching or seizing requires a search warrant. This is constitutional law 101, 4th, 5th, and 6th Amendment type material. Having said that, there are a number of recognized search warrant exceptions that have been developed judicially that have existed for decades, for centuries, that predate the formation of this country as a country in terms of our broader system of jurisprudence. And at the risk of it getting overly wonky, we refer to these as Carroll car searches. There are Terry pat-down searches. There are exigent circumstances searches. There are probably, depending on who's writing the list, 10, 11, 12 search warrant exceptions. One of those exceptions, and a rather robust one, is the consent to search exception, which recognizes the ability of an individual to say, I agree that a government agent can pat me down, can search me, can check my car, can check my pockets, subject to the government satisfying that search was obtained in a knowing, intelligent, and voluntary fashion, and a pretrial motion to suppress held by a judge in any subsequent criminal case. We went from the robust consent to search exception prior to last year to a rather limited consent to search, a highly limited consent to search exception as a result of the police accountability bill. And please know, as I referenced, we understand the concerns and the consternation that was driving that. Having said that, what you have before you now is the consent search in a modified form. It would allow for law enforcement to ask an individual for consent to search, but it couldn't be done, and it wouldn't be done in any sort of a haphazard fashion. It could only even be asked for upon the satisfaction of what we refer to legally as a reasonable and articulable suspicion standard. That is what is contained and built into section 6 and 7.
That's helpful. I appreciate it. So I guess the last question would be, is it your contention, and again, maybe this is delving too deep into and getting wonky as you say, but is it your contention that either current law is not in keeping with, Fourth Amendment, jurisprudence across the country, or Supreme Court, or what have you, and or that this bill would be more consistent with other states and with the Fourth Amendment?
Frankly, I believe that the majority rule, if we were to canvass the nation at large, is rather the unfettered consent to search, with an understanding that at this point, that is not where the state wants to go. You would be adopting a rather hybrid rule that's somewhere between a minority, a handful of states that prohibit consent searches in total, and the majority of states that allow the police to ask for consent. So you would strike a stance that is this hybrid. It would still be on the very restrictive side in terms of the ability of law enforcement to engage in this behavior when compared to our brother and sister states.
Okay, but that's sort of where we are now, though. In other words, as you would say, more restrictive, but it's not as if we completely eliminated or out of line with the Fourth Amendment by under current law, right?
Sure. The Fourth Amendment would set a minimum of rights. The way that I describe it to both police officers and to college students that I instruct is the Fourth Amendment sets a floor, it doesn't set a ceiling. So states, of course, are free to come along, as I'm sure all of you know, or many of you know, at least in terms of Fourth Amendment law. States are free to come along and set the threshold, as Connecticut has done in many areas, at a level that's different than the federal minimal level of constitutional protections. So I wouldn't say that we're not inconsistent with the federal law, but we are more restrictive in terms of what we currently have. And you'd still be more restrictive in terms of the language. You'd just be less restrictive than what we currently are, if that's not spinning it too many times on you.
No, that makes sense, and that's helpful. I appreciate your testimony and your answers. Thank you, Mr. Chair.
Chief, just before I turn to my other colleagues, just on that point, by way of follow-up, what is currently on the books in Connecticut after last summer's police accountability bill, the consent search provision from last year's accountability bill, is it your understanding that that language as is still more permissive for police officers than some of our surrounding states, and most particularly Rhode Island? Do you have knowledge on that?
I don't. The only state that I know of with certainty that is at where we are at right now, I believe Washington State is consistent with the position that we have here. I'm not in a position, unfortunately, and I apologize, but I'm not in a position to do a state by state. If the implication is that this is where Rhode Island is, I wouldn't be in a position to dispute that, sir. No.
Okay, understood. Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Chief. Long time. Haven't seen you in a while, but
good afternoon, sir.
How you doing? Just centering on this discussion, when you reference haphazard, do you mean what you mean by that? And I don't want to put words in your mouth, so to speak, is disparate or subjective on the officer as to whether or not they're going to ask for a consent search, was the process prior to the current law?
That has certainly been the concern that's been expressed, and there is some data to support that. It's not It's not every year, it's not an amalgam of data, but certainly there has been some data that expresses that concern. I can tell you that haphazard or disparate or discriminatory is not behavior that I have ever engaged in, and not behavior, and I say this, forgive my passion, but that's not behavior that I've ever engaged in, nor behavior that I have ever seen engaged in my state police career, and certainly would never be tolerated, and I haven't seen it in my Enfield career. But it's difficult to argue with the data, some of the more recent data that we're all familiar with. And that's why I think what is before you is an effort to reconcile these two interests that I'm referring to. Yes, sir.
Yeah, and the disparate application opens that up to possible discriminatory practice.
That is the concern that has been expressed. Again, I am very pleased that I can look at this with rose-colored glasses and tell you that I haven't seen that. But certainly the data that's been generated out of the CCSU work is a cause for very significant concern. And I think that's what brings us, I appreciate that question, because I think that's what brings us to this discussion right here. God bless you folks, because you've got these competing interests that you have to satisfy. How do you take action that assists the public in having the safety and security that we know they want in every community, at the same time ensuring that law enforcement procedures are consistent legally and morally with what we very appropriately demand of public servants? How do we get there? What is before you is a way to get there, much more restrictive than the majority of our states, but it would restrict consent searches to that reasonable suspicion standard.
I appreciate that, and I'm just trying to clarify your representation to us. The current law is, through your investigation, experience, review, the minority law across the country. Is that what you're telling us?
Yes, sir, it is. I have the great pleasure of teaching nationally, training police officers on a national level. And in speaking to officers, the default position, again, I can't give you hard data. I haven't surveyed the states. But the default position anecdotally in my interaction with police officers is the unbridled consent to search, where Connecticut previously was, where we're not trying to go with this legislation, is clearly the default rule within our nation.
Yeah, if we were to create two bookends, that's one bookend is the current law. And then we have this unfettered right to ask for a consent search, which is the other bookend, which is where we were. Is that fair to say?
It is, sir, yes.
And this legislation brings us somewhere in the middle area. Is that fair to say?
I think it's fair to say the middle, perhaps leaning a little bit more toward the restrictive side in terms of the number of states. I think you're still comfortably, presuming that's where you want to be. I think you're still comfortably with that group of states on the far bookend.
And
bookend closest to the bookend closest to the camera, if that's helpful in terms of how you used your hands.
Sure. And under the under the present standard, probable cause, would there be required that a report be done if the officer says I had probable cause and therefore asked for a consent search?
I can envision no situation where a car is getting searched and a report is not being done. So I'm very comfortable responding to that question in the affirmative, both under the practice of any department that I'm familiar with. Additionally, because the officer is going to need to document what their probable cause is to justify their behavior. So I'm very comfortable answering that in the affirmative.
Okay, although it isn't required in the language.
Correct. And actually, to that degree, you could look at the proposal that's before you as actually instituting formally instituting another step to ensure the propriety through the documentation on the part of the officer.
But if you could explain what you mean, I mean, for the purpose of the public hearing, what that means, what portion of this language gives that additional assurances when a consent search happens under this new language, should it become law?
Sure, I'd be happy to. So the current language requires that the consent to search be that a consent search only be executed, or it describes it in the negative, that a consent search will not be executed absent probable cause. So it sets a legal threshold, but it does not go on to include the reporting mandate, even if I think it fair to say that a report would be generated as a matter of course in any such situation. That mandate is not contained within the current law. So in the proposal, what you're effectively doing is you're altering the standard from probable cause to reasonable suspicion. And that's what I urge you, I ask you to consider, but the proposed language formally includes the reporting requirement. So it's almost as if you're altering in one direction on one issue, the legal standard, but you're altering in the other direction, the reporting mandate within the new language.
Well, I thank you for that. And I, the concern, whether a report gets done or not under the current language, you do have the opportunity, I guess, for discriminatory practice under the current language. If you're not being required to articulate that probable cause, therefore initiating the consent search under the current language. So yeah, I agree. This is an additional protection for civil rights of our people. And I thank you for coming here to testify. Thank you, Mr. Chairman.
Thank you, sir.
Thank you. Representative O'Day.
Thank you very much, Mr. Chair and Chief. Good to see you. It's been a number of years. I think the last time was we saw each other was when I was at Post, or it used to be the MPTC. But I just pulled over. I'm on the side of the road because I wanted to thank you for your years of service with not only the state police, but also to the good citizens of Enfield. And I want to thank you for your testimony. I'm looking forward to working with you to try and get this legislation through. So thank you very much. Thank you, Mr. Chair, and appreciate the time.
It's my honor to do so. I appreciate your kind words.
Senator Winfield.
Hopefully the internet works long enough to get the question out. Chief, are you representing that in all of these searches that we're talking about, whether it's under the system that existed before the Police Accountability Bill or the system after the Police Accountability Bill, that you are saying that the searches have reports attached to them? Is that what you're saying?
The way I would describe it is this: while the report requirement is not contained within the language that is the current law, I can envision no situation in my experience in any of my law enforcement jobs where an officer could or would engage, no one that I know, no department that I have ever worked for, that would engage in a search of a person's car, whether it found evidence or didn't find evidence, and they wouldn't write a report about it. I think that is the default position. I would be shocked, astonished, and very troubled if a report wasn't written. It's not formally captured in the current law, but I do think it's likely the norm.
And the reason I ask is not only my experience, but we've had person after person over the years about searches that there are no reports attached to. And I guess I was wondering if that was just your personal, you were representing that a fact. Because I'm not with you, but I've seen with my own eyes things that indicate that is not a fact. And so let me make sure I understand your position on the consent searches. So why do we need to move off the position we have in the current law, again, if you will?
Because in a general sense, I suppose that question takes us back to what you see the function of law enforcement to be. When I instruct in this area, and at the risk of, again, being wonky or even philosophical, law enforcement serves a role for us as a society, and that is ensuring safety and ensuring a degree of public order. When we eliminate a search warrant exception, you are eliminating or at least lessening the ability of law enforcement to catch the drugs, to catch the guns, to catch the folks that would harm your constituents, denigrate your community. There's a tension in this area, and I actually referenced this in my letter, and I was in my written testimony, and I was pleased with how this came out. We see instances time and time again, very genuinely, where folks are upset at how they're treated at the hands of law enforcement. That's a very significant concern. But we also see instances where we have bloodshed and violence and narcotics that pollute our community. Our children are tempted to go down the wrong road. And we ask any number of organizations, including law enforcement, to address that problem. Your task, God bless you, is to reconcile those competing interests. And I would offer to you that the elimination of the consent search exception, or at least the substantial lessening of the consent search exception, has taken away that tool that has lessened the ability of law enforcement to address that protection of life, protection of safety concern. All the guns, all the drugs, all the wanted people, all the bad things that society asks you to ask us to ferret out and deal with, that's curtailed without this exception.
And I guess I understand your point about what you are tasked with doing, but you're right. There's a balancing we have to do. The constitutional rights, and you and I think both would agree, whether our experience is the same or not, that asking someone, documenting it, all of those things, there are differences in power, and we were taking into account when we did the bill, those differences in power and how they play out in different communities. And do you believe, I mean, you can take this to a crazy extent, which I don't think we should.
I'm sorry, sir, I think I lost you.
I think we lost Senator Winfield again. Representative Howard, why don't you go while we try to reconnect Senator Winfield?
Thank you, Mr. Chairman. Good afternoon, Chief. Thanks so much for being here.
Thank you, sir.
I just want to ask a couple of questions, maybe provide some clarity on this report issue. As it was previously, and I
Representative Howard, you know what? I think we have Senator Winfield back, so I'm going to let him finish his thought before you get going, if you don't mind.
Nope, happy to yield to the co-chair.
Just go ahead, because I'm probably going to drop again, so it's fine.
All right, go ahead, Representative Howard.
Thank you, sir. So, Chief, I certainly agree with you that oftentimes, you know, good police officers doing a good job doing a search, whether or not it yields any evidence or contraband, should be doing reports. But would it be fair to say, Chief, that previously, before 20-1, if an officer asked for consent and the person told them no, that the officer probably wouldn't do a report on that? Is that a fair statement?
I would agree with that. I mean, absent the underlying event, of course, being something that prompted a report. Agreed.
So under this new legislation, we can really truly capture, correct me if I'm wrong, but as you read it, we can truly capture who's asking for consent when, whether or not it's granted or not.
That's a fair point, because that's a fair point. Thank you. To the extent that the consent is given, my stance was and is that the report would likely have been written before. Now it's going to be mandated. To the extent that consent is asked for, the officer believes they're at reasonable suspicion, but it isn't given, the new reporting mandate would kick in. That's an interesting assessment, and yes, it appears to be correct.
Thank you for that, Chief. So I think that's an important thing that we're recognizing here, is what we're doing is we're telling officers in this new legislation, if you're going to ask for consent in the interest of doing your job to protect the public, you need to tell us why you did that, and it better be a good reason. Is that a fair statement?
Yeah, now that, I mean, we're and I appreciate the opportunity to parse it out, because yes, whether or not the consent is granted, complete the police report.
So I think,
yes.
Thank you, Chief. Sorry. So I think that's an important thing. And one other point that I want to make out, because and I agree with you, and I certainly agree with my friend Senator Winfield in that we have to strike a balance, right? And that's a line that police officers walk every day, to try to protect people's rights, but protect the public at the same time from those who do them harm. And there's a very thin line, as you well know. But would you agree? You had an impressive career, certainly, Did you ever work in narcotics, Chief?
I have, yes, sir.
So just when you worked in narcotics, did you did you work confidential informants and do controlled buys?
Yes, this was at one point during my FBI experience, my FBI agent time, yes.
So for my colleagues, when tell me if this is accurate. When you can conduct a controlled buy of a narcotics dealer, you have a confidential informant who meets up with you. That confidential informant is knowingly meeting up with you to do a controlled buy. You search them and their person with consent from that person on their car and then they get kept under surveillance to the target, through the target, and back to a prearranged meeting spot. Therefore, you can then testify in court, if necessary, that your confidential informant didn't have any narcotics on them prior to going to the target, and therefore you know the narcotics came from the target, and that consent search of that CI is necessary in the investigation. Is that true?
It would be indispensable to making such a case.
Okay, thank you. So, and then also in the course of your career, we use DNA in police work often now, and oftentimes at burglaries and things of that nature, we need to get consent from victims and sometimes witnesses for swabs of their own buccal swabs or DNA, their inner cheeks, which is in effect a search based on their consent for exemplary purposes. Is that correct?
It is correct.
And would you agree with me that the language as it sits, not the proposed language, but the language as it sits in 20-1 is makes those searches in effect illegal?
I believe that it does. We have, that was one of the areas of discussion very early on, the elimination of individuals as a potential party to a crime. Under the current language, unless we're at the probable cause standard, we're not even asking.
Well, let me say this to you, Chief. I am grateful that someone with your law enforcement background, your position, your education is able to stand publicly and say, hey, I hear the concerns, I understand the concerns, and I share the concerns. We can achieve the goal to abolish those concerns and make sure we have all the safeguards necessary to stop the activity that those who are concerned about, but at the same time, enable our police officers to do the good and noble work that they've been doing. So Chief, I thank you so much for coming here and articulating that so well. Thank you, Mr. Chairman.
Thank you, sir.
Representative Fishbein.
Thank you, Mr. Chairman. Chief, I wanted to ask you about, I don't know, I'm sure you did take a look, but there's another bill on the agenda, and that's 6669.
Pertaining to youth offenders and treatment that they need.
Yes, sir. And the juvenile motor vehicle theft aspect. You see that? Have you, did you have a chance to review that in preparation for today?
So I have to acknowledge that I am not familiar with it in detail. I can tell you in my limited exposure to it, we see this legislation as a potential benefit, a potential solution to the increases in motor vehicle thefts, and agree with the increase in penalties for adults who use juveniles to conduct illegal matters.
Yeah, so there's a particular portion of the bill that I wanted to ask you about. And, you know, currently under present law, when a juvenile, I'm sorry, my video was off. It's not very nice. When a juvenile is arrested for stealing a motor vehicle, and the officer believes that the individual should be detained, that they can apply to the court for such detention. Are you familiar with that?
I am, sir, yes. We refer to them as orders of detention or taken to custody orders. The phrases are sort of used interchangeably.
Sure. And Section 5 addresses the collection of data with regard to, you know, how many times that's applied for, how many times it's denied, reasons for denial, those kinds of things. Have you had experience, as your many honorable years in law enforcement, with officers, you know, whether under your command or you, applying for one of these detention orders and it being denied by the court?
I have not had substantial experience myself. Those changes occurred after I had been in supervisory positions, but even in that capacity, I have had, forgive the word, subordinates that have been tasked to do that. And when we have brought cases to the court, assuming that we had probable cause for the original underlying offense and one of the statutory criteria, because there are specific statutory criteria before the judge can remand that individual to the detention center, assuming that one of those is met, and we would not have advanced that order unless we felt it was warranted. We have enjoyed success. It's a tough word to use, but our applications have been by and large successful.
Okay, thank you. I'm glad to hear that those tools, at least in your experience, are being used. So thank you, and thank you, Mr. Chairman.
Thank you. Further questions or comments from the committee for Chief Fox? If not, we will let the chief get back to work. Thanks for being with us, Chief.
Thank you, ladies and gentlemen.
Next up will be Cindy Prizio.
Okay, can you see me or hear me?
We can. You're good to go.
Oh, good. Okay, thank you. Thank you. Good afternoon. My name is Cindy Prizio. I am with One Standard of Justice, or OSJ, a statewide civil rights advocacy organization working with men and women arrested or convicted of sexual offense. OSJ vehemently opposes HB 6670, adding a mandatory minimum sentence of 30 days for risk of injury of a child. People who will be affected by this bill could in fact be family members. However, there's no purpose under any circumstance to disrupt a life for 30 incarcerated days. It could mean the loss of income and or permanent employment, chaos within the family, the loss of housing. The child who was harmed may be harmed more. We want to keep people out of prison rather than possibly starting the cycle of incarceration. Instead, OSJ recommends a restorative process be utilized that involves education, treatment, social services, with an eye on keeping the family unit intact. A restorative process would include many stakeholders, including community, for a better outcome. Victim-centered restorative processes is on the rise nationally for all offenses, which provides real accountability and reparation by the person who is harmed. Prison's not accountability. Without accountability, there cannot be changed behavior. Besides restorative practices, we should be focusing on prevention rather than post-incident crime and punishment. Mandatory minimums can be harsh and not accurately reflect the situation. They target our Black and Brown communities disproportionately, allowing mitigating information to be excluded and judges' discretion removed entirely, creating unjust outcomes. We've heard overwhelming testimony last week at the public hearing on ending solitary confinement. It should have opened our eyes to the violent environment sustained by the Connecticut DOC and the lack of rehabilitation or corrections in our state. What doesn't kill you makes you stronger, not in my narrative. In addition, OSJ enthusiastically supports the work of the JJPOC and Bill 6667 with the following comment. Connecticut children and youth should have all the protections of the juvenile court. We support ending automatic transfers for all B felonies and would like to see it go further. Sexual assault too is a B felony. Data shows a low reoffense rate of 2% for young people who sexually offend, and that these sexual misconduct behaviors are transitory. With or without intervention, they will age out of them. Sex assault too with a younger actor of 13 or older, but under the age of 16, and the older actor with 3 or more years difference, it's not rape. Yes, it could be in some situations, but more likely.
Ms. Prizio, I need you to wrap up.
Oh, thank you, Representative Staffstrom. I just wanted to say that sex assault too with a younger actor of 13, but under the age of 16, and the older actor with 3 or more years difference is not rape. More likely, it's an angry dad with an overzealous prosecutor. More likely, more often, it's first or second love. Nuances are allowed in juvenile court. And that I'll wrap up right there. Thank you, Representative Staffstrom.
Thank you, Ms. Prizio. Questions or comments from the committee? Questions or comments from the committee? Seeing none. Thanks as always for being with us.
Thank you so much. Have a great day.
Olivia Rinks.
Thank you. Olivia Rinkus from North Sunnyton, Connecticut. Thank you to the members of the Judiciary Committee for the opportunity to testify. I'm testifying today on several bills. The first I will be testifying in favor of is SB 1093, an act concerning civilian police review boards, security guards, body-worn recording equipment, and searches by police. Now that HB 6462 has been passed and rolled back the start date of the Police Accountability Bill, it is more imperative than ever for communities to be able to hold officers who commit violence against citizens accountable. Especially important is the ban on no-knock warrants, as it is the constitutional right of citizens to be informed of searches of their person or property. I would suggest that lines 6 through 8 in subsection A3 regarding the appointment versus election of board members of civilian review boards be changed to election only by members of the community that the board members will be serving. I am also testifying in opposition to HB 6669, an act concerning juveniles and motor vehicle theft, investigations of certain juvenile matters, and reporting of arrests to detain arrested juveniles. Harsher penalties only perpetuate the recidivism rate. A particular issue for me is section 3, which allows invasive searches by the police into the marital status and financial history of the family. The pretext of these searches is a concern for the welfare of the child in question is unrealistic, considering that the point of this bill is to create harsher penalties and label this person with a criminal history for the rest of their life. Am I also able to ask a question of the committee on an item of the agenda?
I mean, rhetorically, I suppose you could, but
Clarification question.
you can ask. I'm not sure you're going to get a response, but you can ask.
Okay, thank you. Regarding HR 366, a resolution proposing a constitutional amendment to remove a prohibition against construing the Constitution or statute to create a basis for a criminal conviction to be vacated or appealed if a victim is not afforded his or her rights in court. Whose appeal would be affected by that?
It's the criminal defendants, I believe.
Thank you. Thank you for the opportunity to testify.
Thank you. Questions or comments from the committee? Seeing none, appreciate you being with us today, ma'am. Next up will be John Egan, followed by Danielle Cooper. I do not believe John Egan is with us. Is Danielle Cooper here?
Can you hear me now?
Yes, we can. Go ahead, ma'am.
Thank you. Dear members of the Judiciary Committee, my name is Dr. Danielle Tolson Cooper. I'm a resident of New Haven. I currently work at the University of New Haven in West Haven, and at the university, I'm an associate professor of criminal justice, as well as the director of research for the Tao Youth Justice Institute. My most relevant areas of expertise include juvenile justice and delinquency prevention, police-citizen relations and authority dynamics, and policies impacting individuals convicted of sexual offenses. I'm also a certified prevention professional in Connecticut and in Florida. I'm here to express my full support for House Bill 6667, but I've also chosen some specific sections of the bill to affirmatively speak toward. I'm in support of Section 1, which shifts the definition of a child and raises the floor of the juvenile jurisdiction from 7 years of age to 12. The opportunity to deal with this small number of youth at an early age is essential to public safety, as well as crime prevention, and allows for early access to the behavioral health system that may be needed for these youth and their families. This should be the most agreeable group that we can offer more services to, as they are few in number, commonly low-level offenders, and offer the greatest potential for reform efforts. Secondly, I'm in support of Section 2, which expands the purpose of the Juvenile Justice Policy Oversight Committee to collect data through age 21 instead of just for minors. This section also formalizes the participation of youth voice and parent voice as voting members of the JJPOC. This increases the inclusivity of the JJPOC and the impact of its work. Their participation is essential in asking and answering robust questions about the future treatment and outcomes for justice-involved youth and young adults, and complementary to the examination of data relevant to addressing those questions. Last but not least, I am in support of Section 12, which calls for the end of automatic transfer for certain offenses, including some that are felony B. I'm here to point out that this bill gives the courts a greater ability to hold these youth accountable, not less. The potential to transfer still exists, but is no longer automatic. Now the ability to discern where youth are best served is more fully available to the court. The goal should be to properly serve all justice-involved youth, but especially in ways that prevent their repetitive entry into the justice system. In hearing the concerns about victimizations and victims' rights, I also acknowledge that failure to prevent exposure to traumatic events, which increases the likelihood of involvement, leads to youth trauma and victimization as well, and that often predates youth offending. It is the duty of all adults to consider the well-being of youth and specifically give consideration to the long-term and short-term implications of justice involvement, but especially incarceration in the adult system for youth. Youth who commit heinous offenses have been shown to have propensity to contribute to society at later times. Furthermore, even youth who commit sexual offenses, and adults too, have an incredibly low rate of reoffending, as has been stated. This challenges us to identify what are the proper ways to hold them accountable while honoring victims' rights, but without throwing them away simply because of the reaction to the type of crime that they have committed, especially when they are unlikely to reoffend, much lower than most other offenses. In conclusion, I thank you so much for your time. I'm here in full support of House Bill 667 as a citizen of this state, but also as a criminologist who works in the area of youth and young adults. Thank you.
Thank you, Professor. Questions or comments from the committee? Questions or comments? If not, appreciate being with us and sharing your expertise on this. Next up will be Paul Chaplinsky.
Hi, good afternoon. Sound check, you can hear me okay?
Yep, go ahead.
Okay, thank you, Mr. Chair, Connecticut senators and representatives and other committee members. I want to thank you for your time on the hearing and also thank you for your service to our state. I also want to just state that I'm from the Southington Town Council, and I'm going to talk about HB 6667 and 6669. And I also have with me listening in representing Southington, our chairwoman, Victoria Triano, who's joining me on the call. I wanted to start by saying that I do support some of the proposed legislation in the two bills, specifically increasing penalties for adults who help and promote juveniles committing crimes. Also, the elements for facing charges on the regular criminal docket, expanding ability for judges to order and detain and use GPS monitoring. Categorizing serious juvenile repeat offenders. And I wanted to share with you that I'm not only here as a Southington Town Councilor, but I also am here as a victim. I experienced and my family experienced a pretty traumatizing event last year when we had somebody enter our home and our garage and steal some of our properties and also one of our vehicles. So I know firsthand, what it feels like to have this happen. And, as a victim, I also wanted to say that we have to be careful and stop victim shaming and telling people that they have to lock their cars and that's the only way to stop this. We, all of us as residents of Connecticut and the United States, we should be afforded the right to not have people come on our properties and take our things. And so, and our laws should be strong enough to dissuade that. So I'm here to stand up for the people of Southington, not just the 44,000 people of Southington, but also we have 5,000 neighborhood watch people who are coordinating efforts with our police department to patrol the town of Southington on their personal time, which they shouldn't have to do. We should have stronger legislation that makes people think 2 and 3 times before they commit a crime. This is not an I-84 or I-91 or a northern southern Connecticut issue. This is a Connecticut issue. And in some parts of the country, it's an issue as well. I realize that there's been a recent uptick recently, but there are people crying out for help. As an example, Branford Police Chief in November 2020. People are emboldened because they know that there are no consequences. The chief also said that we're creating a society with our legislation where there are no repercussions because you won't get in trouble. The police chief of Clinton said the same thing. We're arresting multiple people time and time again, and they know that they're going to get off. There's no accountability. Waterbury police chief said last year that it's completely out of controls and the laws are too lenient. There was a gaggle of police chiefs and other law enforcement officials who attended the Public Safety and Security Committee, March 2019, saying, law enforcement, the headline read, law enforcement officials, packed the meeting because of wave of auto thefts, and they were supporting a bill that got shot down. So my ask for you is please work together. Just, there are people advocating for preventative measures and for, measures to help some of the juveniles. I support it. We all will invest in that. Let's do that. But please also let's work on strengthening the accountability for those who are repeat offenders. And thank you, Mr. Chair.
Representative Veach, a question?
Through you, Mr. Chair, I just wanted to thank Paul for coming and speaking today on behalf of Southington residents. We certainly appreciate everything that you do. I don't see Vicky, but hello to Vicky as well. I'm sure she's within earshot, and we appreciate you coming out, like I said. Thank you.
Thank you so much.
Sir, you mentioned there was an uptick, I believe, in car thefts in Southington. Do you know how many there were in 2018 versus how many there were in 2019 versus how many there were in 2020? Do you have those stats by chance?
I didn't write the data down. I think 2018, as you indicated earlier in the meeting, Mr. Chair, we did see a downward trend. We know in 2019 we were low. 2020 was obviously higher, like most towns. We're at 225% year over year, along with many other towns who are triple-digit increases as well. So, but I will say, to answer that question as well, we know that people in authority positions have been asking for 5 or more years to revisit the juvenile justice reform laws that have occurred with raise the age in around 2009, and it's good legislation. It was bipartisan. That's great. We want to just build on that, and we want to take a look at where we are today, and we're asking you to strengthen some of the other repeat offender issues.
Will you agree with me, though, that during the roughly 5 years since we passed juvenile justice reform, that there has been up until the start of the pandemic, there was a steady downward trend in car thefts, well, at least statewide. I don't know about Southington, but at least statewide, there has been a steady downward trend since we undertook juvenile justice reform.
I had seen the raise the age legislation. I think it was 2009, and then enacted in, I want to say, somewhere around 11 or 12. And I will say that we have seen a kind of a flatlining recently. So we had some initial gains after that, and now we've kind of reached a steady state to where I would say that if you exclude COVID, we're not getting any better. So now is a good time to look at what we can do to maybe bring that trend down even further.
Sure. Okay, and then I guess on that point, I guess I don't disagree with much you said, other than that. I guess I'm struggling with how it is victim shaming by asking someone to lock their car when we hear from law enforcement, we hear from criminal justice experts, we hear from everybody that we could prevent over 90% of car thefts if folks locked their car.
Yeah, agree. And Mr. Chair, thank you for bringing that up. Certainly, my comment is really aimed at, we should not be saying that we don't need new legislation and that people should just lock their cars, because nobody should be allowed to touch our property. And in fact, I shouldn't have to be told by the government to tell me to lock my property up. Nobody should touch my property. I should be able to go to sleep at night with my car on the road in front of my house or in my driveway or in my garage. And people don't have a right to come on my property and take that. I should not have to lock my door. I agree with you. That's definitely something that we should all be smart enough to lock our cars. However, it's not an excuse for us to not address the systemic issues that we have around the juvenile justice system and holding repeat offenders accountable.
Well, I don't want to argue with you, but I don't think it's an excuse. I think what it is, as you just talked about, if you want to continue the downward trend of car thefts we've seen in Connecticut over the last decade up until the start of the pandemic, when we are a state that is actually at or near, we have one of the lowest rates of car thefts of any state in the country, that if you want to continue to make progress, it seems to me that one of the quickest ways to make progress towards reducing car thefts further in the state is to get folks to lock their cars.
And Mr. Chair, you're right. There's been a lot of great content pushed from the local police departments on awareness and things like that, and we do appreciate that. I recognize that that's clearly something that we should all be doing.
I appreciate that. Representative Callahan, before I go to Representative Beach for the second time.
Thank you, Mr. Chairman, and thank you, if you don't mind me calling you Paul,
please,
rather than try your last name. I appreciate you coming in. And as I mentioned earlier, I was also a victim of car theft, and I couldn't agree more that certainly there was one night that I forgot to lock a car, but the perpetrators had to come deep into my property to break into the car. And while I agree we should all be vigilant and lock our cars, our property is our sanctuary, and they have no right to step foot on our property. And I thank you for coming in.
Thank you, sir.
Representative Beach.
Through you, Mr. Chair, again, I just want to mirror what Rep. Callahan just said, and Paul as well. It's your property. You should be entitled to do what you want to do on your property. And if you forget to lock your cars that night, you shouldn't be fearful that your car won't be there in the morning. There needs to be accountability, and there is no accountability. And we have seen an uptick in both Berlin and Southington as well. It's an issue that needs to be addressed. Again, thank you for coming out and speaking today. To you, Mr. Chair.
Thank you. Seeing no further questions, thanks, sir. Appreciate you being with us, and thanks for your service to your town. Next up will be Marissa Helm. Marissa Helm. David Ware.
Can you hear me?
We can. Yep. Okay. So we've got Ms. Helm.
Yeah, this is Marisa Holmes. Sorry about that.
Okay. Go ahead, ma'am. Your video's off. I don't know if you want to. There you go.
Okay. There we go. Can you see me and hear me? Okay.
We'll get to Mr.
Sorry
Ware.
about that.
Go ahead.
Doing a couple screens here. Good afternoon. My name is Marisa Holm. I'm an attorney with the Center for Children's Advocacy. I represent primarily youth and young adults in the juvenile justice system concerning their education. I'm here today to testify in support of the JPOC bill, Bill 6667. Our office was integrally involved in the development of this bill. Our executive directors on the executive committee of the JPOC, and between myself and other staff, we have representation on many of the work groups. I have submitted written testimony which focused on a couple, even though we support the bill in its entirety, I'm here to focus on a couple provisions of the bill in particular, and can direct you also to my written testimony. My colleague, Catherine Myers, also submitted testimony on the suspension component of the bill. First, I'd like to draw your attention to Section 13 of the bill, which is the component of the bill that will facilitate automatic record erasure for juveniles. This is a crucial provision that had no opposition in the JPOC and will create parity between the juvenile and the adult systems. Currently, youthful offenders in the adult system have automatic erasure of their records at the age of 21, but there's no such provision for youth in the juvenile system. Even though juvenile records are confidential, they have many negative collateral consequences. Information that's not erased is regularly available to law enforcement and public agencies and often comes back to harm young people in this way. Section 13 will ensure that youth have their record erased automatically without the current petition process, which is quite frankly rarely accessed by the youth that we work with. So we would support this provision of the bill and encourage the committee to pass it. I'd like to also draw the committee's attention to sections 3 through 10 of this bill, which come out of the Education Committee and which I was involved in helping to draft. There's a number of meaningful and important protections and safeguards for young people who are being educated by the juvenile justice system in these sections. They're crucial to ensure that the state is providing these young people with appropriate access to an education. These are the young people that I represent day in, day out. These are all young people of color. And I don't say this lightly. The way that our system is currently set up is disgraceful. It's set up to fail these youth. There's no one entity overseeing their education. There's no legal obligation for districts to collaborate around their education and transferring between systems. There's no one ensuring that they're on a high school graduation track. There's no one exploring diploma options and ensuring that credit access and credit transfer is happening. These sections of the bill crafted by the Education Committee are an important first step in putting these protections into place. Sections 3 and 4 in particular create a system for oversight and monitoring where DCF will be taking a leadership role with an implementation team of important stakeholders in the system. And this will involve making sure that there's communication between districts around youth who are in the system, making sure that credits are being transferred appropriately and that these students aren't falling in between the cracks. There will also be reporting and transparency.
Ma'am, we're past the 3-minute mark.
Okay, thank you. So there's a bunch of different reporting requirements that will come out of these provisions. So CCA would urge the committee to pass the JPOC bill, in particular these sections. And I would like to also draw the committee's attention to some suggested amendments to the education sections of the bill that are in my testimony, and offer to assist in helping with language if that would be useful.
Thank you. Representative Porter.
Thank you, Mr. Chair. And Marissa, I just wanted to thank you for your testimony today and for all the work you've done in making sure that we get this bill to this point in the process. So thank you. And I look forward to working with you in the future to advance all these causes. Thank you, Mr. Chair.
Thank you, Representative Porter. Thank you for leading all the charge with this at the committee level.
You're welcome. Thank you, Mr. Chair.
Sure. Thank you both. Seeing no further questions, thanks for being with us, Ms. Helm.
Thank you very much.
Next up will be David Ware.
Hello, can you hear me?
We can. Go ahead, sir.
Okay, my name is Dave Ware, and I grew up in Manchester in the 1950s and 60s, and I currently live in West Hartford. And I'm here speaking in support of HB 6665 concerning the removal of restrictive covenants based on race. I'm a lawyer, and I recently earned a Master of Laws, or LLM, degree in Human Rights and Social Justice at the UConn School of Law. My interest in this topic was sparked by a conversation I had in the fall of 2019 with my then 94-year-old father, who still lives in Manchester. When doing some family history work, he had come across a disturbing provision in the chain of title for the house that he has owned since 1950. The provision, dating from 1942, stated as follows, quote, "No person of any race other than the white race shall use or occupy any building or any lot, except that this covenant shall not prevent occupancy by domestic servants of a different race domiciled with an owner or a tenant." My father and I were shocked to find this blatantly racist language residing in the official land records of the town and within a formal and legally sufficient deed of conveyance. It was a timely topic for my LLM studies, so I began conducting research on the history, existence, prevalence, and legality of covenants like this. I found that in Manchester alone, there are 248 properties that have in their chains of title racially restrictive covenants like the one I just cited. In 1948, the US Supreme Court ruled that enforcement of such covenants would violate the Equal Protection Clause. But in so ruling, the court did not invalidate or strike from the land records the covenants themselves. Therefore, these covenants just sit there as disturbing reminders of the many decades during which formal, explicit, and officially recordable segregation was the policy and the law of the land. Within the land records themselves, there is nothing that refutes, denounces, or extinguishes these provisions. Fortunately, HB 6665 provides an opportunity to address this anomaly, to let the land records officially reflect that these old tools of racial segregation are unacceptable. The bill establishes a procedure for reaching back into the land records to remove these offensive covenants, while at the same time preserving the history of their existence so that we never forget. I would urge you to vote in favor of HB 6665, and thank you for listening.
Thank you, sir. Question from Representative.
Thank you, Mr. Chair, and thank you, David. Hello, and it's nice to see you and meet you in person. I did have an opportunity to review your paper, which I see you submitted as part of your testimony today, and I read it with great interest, both as a representative and a lifetime resident of Manchester and a local yokel and history buff, and also as a real estate attorney, having the opportunity to search the land records and review lots of title searches. And you know, when I first saw one of these, like you, I was, you know, I was floored, having heard about them in law school and having heard about the fact that they were essentially invalidated. But to see one on you know, on a property that you know and is a tangible thing is quite jarring. So I appreciate your work on this and bringing the concept forward. I do note that in your paper, which again is the committee can see you submitted as testimony, you suggested sort of a different solution than what the language of this bill actually puts into place. And that sort of revolves around the ability to record an affidavit on the land records under 4712A. Could you go into that a little bit more for the committee? And the reason I think it's important to make that distinction is because we heard earlier, I caught a little bit of the testimony from the state librarian who talked about the impracticality of physically removing land records or redacting land records and what that would involve. And I think your solution does not necessarily require that. Is that correct?
Yes, that's correct. And I guess I would say I think there are several different ways that this issue could be approached. The one that I set out in my paper does in fact involve the signing of an affidavit to file in the land records, and which is a procedure that's currently allowed for. It's cumbersome, like a lot of approaches on this subject tend to be, just because of the sort of the sanctity of land records, the nature of land records themselves. But the other thing about that, what I initially kind of invented as a way to in my paper as a way of approaching these things, it also only has limited applicability, it seems to me. That is to say that there are only certain people who have owned their properties for very long, uninterrupted long periods of time who could take advantage of the process that I laid out in my paper. And so I was pleased to see that the committee raised this bill, and that the committee had thought, and in drafting the raised bill, had thought of a different way to approach it. I do recognize that as drafted, the bill would require the state librarian to become involved, and I did listen to her testimony earlier. I guess my reaction to that is that we've lived under a system forever, essentially, that has allowed these kinds of things to have been recorded in the first place and to remain uncharged even today. And so it seems to me that if the bill as drafted represents an additional burden, it doesn't strike me as a particularly heavy one, although I will confess that I don't know a lot about the mechanics of the way the town clerks handle things in the land record offices. Yes, as I said, there are several different ways, it seems to me, to approach this topic, the present draft being one of them. And I also noted that the librarian, the state librarian, raised the idea of forming a working group. I don't know if that's something that is commonly done in the General Assembly, but I guess I would say that if you were to do something like that, I'd be happy to join in and work on that working group.
Yeah, that would be great. Yeah, no, I think what you've identified in the paper with the affidavit process is a good start to this, and that what's outlined in the bill is not necessarily mandatory. That is the whole process of as the state librarian alluded to, of trying to redact or remove documents. I think the town clerks could, in addition to having the affidavit filed, which in the case, in Manchester, you mentioned there's 248 properties, but I think there were only 2 or 3 subdivisions. So it would only be, 2 or 3 documents that would actually have to be sort of amended, as it were, by the filing of that affidavit. In addition to that, the town clerks could probably notate those documents as well, or within the indices, sort of link them to the affidavit to show that they were invalidated. So again, I think we could accomplish this by eliminating that part of the bill which talks about that whole process that the state librarian mentioned. So again, I appreciate you bringing this forward. I think it's a great concept, and we'll continue to work on it with the committee, and appreciate your bringing it forward. Thank you.
Thank you.
Further questions or comments from the committee? If not, Attorney Ware, appreciate you being with us.
Thank you.
Next up will be Stacy Yarborough.
Thank you. Good afternoon, Chairman Strawstrom and all the distinguished members of the Judiciary Committee. My name is Stacy Yarborough, and I appear before you in my capacity as the town clerk and the tax collector for the town of North Haven, further as a member of the Connecticut Town Clerks Association Legislative and Elections Committee, and as well as a licensed attorney in the state of Connecticut. So thank you for affording me the opportunity to submit this testimony for HB 6665, an act concerning the removal of restrictive covenants based on race and elimination of the race designation on marriage licenses. There are 2 sections to this bill, and to lead off, I will say that as for section 2, the marriage license aspect, CTCA is in full support of section 2, removing the race designation from all future marriage licenses issued by the town clerk. With regard to section 1, while the CTCA applauds the effort and intent of HB 6665 regarding race-based discriminatory restrictive covenants, we do have some strong concerns as relates to the procedure to cure these types of restrictive covenants, which are on the land records. Having just heard the testimony of Attorney Ware and some of the comments by Representative Doucette, I am along the same lines going to represent that the CTCA believes that these restrictive covenants definitely are a blight on the history and the land records of each town in the United States and where else, but to redact or to actually remove the original document is our concern. And we've laid out in the testimony provided a different alternative as compared to the affidavit suggested by Attorney Ware. We too have provided some alternatives as to how this could be effectuated. I won't go into the law because that's been submitted to you already, specifically Shelley versus Kramer as relates to the striking as illegal of these restrictive housing covenants. I will just state the CTCA has these strong concerns as to how the bill is currently written. We would like to form a working group if possible and have all the interested parties sit down and discuss moving forward with this bill. We do look forward to working with the committee to find a solution. And what we would like to note is that there are many different ways that it can be resolved. We would just think that a working group is the best solution before moving forward. And we thank you very much for your time. If you have any questions, feel free.
Questions or comments from the committee? Looks like Representative Doucette does.
Thank you, Mr. Chair. And thank you, Stacy, for your testimony. No, just real quick, I just want to thank you for submitting that that written testimony and those suggestions. And as my conversation with David Ware, I think this is not insurmountable, that this is something that we could accomplish in a less burdensome way for your office. So just wanted to say that I appreciate that, and I appreciate you coming forward with a suggestion. Thank you.
Well, thank you very much, and I appreciate your time. Any other questions? Feel free to ask. I have a bunch of information before me I'd love to share, but I don't want to take up too much of your time.
Senator Winfield does. Senator Winfield.
Thank you.
All right, we're going to try this internet thing again. Good afternoon. Hi. I just want to make sure, are your suggestions in your testimony,
Yes,
your
sir.
written testimony?
Yes,
They
sir.
are?
Yes,
Okay.
sir.
Okay. That's good.
I can spell it out. I have it before me if you'd like, but yes, sir, it is in my testimony as a representative of the CTCA.
How long would it take you to spell it out?
Oh, just quickly, I have it right here before me.
Okay, sure. Go ahead, please.
Okay, so the better solution would be to prevent the document with the old objectable restrictive covenants from being further recorded. So in other words, what we would want to see done is that there would be a type of mandatory requirement that the grantee's attorney review and modify the objectionable restrictive covenant with the consent, of course, of the grantor's attorney for the property sale to go forward, that the mutual agreement have all the restrictive and offensive language stricken by way of an inclusion of a clause with language designated specifically for the removal of the same, so as to protect the chain of title and all the problems and worries that we have that are in my testimony. As an example, Section X has been deleted due to its offensive nature as an unenforceable pursuant to Connecticut General Statute section, whatever that would be. For further reference, please see volume and page numbers. That is just a recommendation that we thought might be a useful tool in moving forward with this particular bill.
Okay, got it. And we'll definitely take a look at it. Thank you very much.
Absolutely. Thank you.
Representative Fishbein.
Thank you, Mr. Chairman. Hi, Stacy. How are you?
Hi.
Great to see you again.
You too.
Just trying to figure out, it appears that your written testimony, and I'm looking at it on the screen, deals with prospective application. So a deed that's presently on the land records for the town of North Haven that has this offensive language would not be affected by your proposal. Is that fair to say?
That is correct. It would not be removed or redacted.
Okay, so I would certainly hope, because I have to, in all candor, when this bill came across my desk, I was appalled at this has ever happened in our state. Okay, my ignorance. But I would expect that it's not happening today, right?
No, it's illegal.
Yeah.
The problem is that it's a restrictive covenant that runs with the land, and attorneys who are when they're making the sale and preparing the documentation, they just have been continuing on with the same repetitive cut and paste language, which we would look to change with or some type of remedy. We've made a suggestion, yet we are open to sitting down with everyone involved and coming up with something, perhaps the affidavit that Attorney Ware just mentioned. But yes, we would like to move forward and make it so that that language cannot travel into the future.
But that would be only in the case where, usually from deed to deed, when you do a title search, you're doing another closing, you are mirroring the Schedule A, the description of the property, right? That's what you're talking about.
Well, no, the actual language could be moving forward in time as well.
Okay, I know that when I've drafted deeds, the only thing that I've mirrored is the schedule A. So you're saying.
But you would have to include any type of blight upon the land or anything that, as I said, as a restrictive covenant is enforceable. It's contractually enforceable, and it's effective in perpetuity unless there's an actual time limit within it. So most of these race-based covenants, despicable, clearly, they are a contractual part that cannot be removed. I mean, they've traveled from owner to owner throughout time. They have run with the land, as everyone knows from property law. So, in my time period as an attorney, I saw them on the land record. I will be honest with you, I've been town clerk and tax collector for 12 years. I haven't seen one here in that time. My records go back to 1786. I'm going to assure you that they are there. I just haven't had one pop up that I've been involved in, had anyone want to do anything to remove them. I think this law would be great. I just think it needs to be done correctly.
Okay, okay, I understand the distinction now. So
yes, sir.
Now you have an old deed from, we'll say the
1800s.
We'll say the 1930s, because you're not going to run title back to the 1800s, right? You go back 60 years for the most part.
Let's say the 60s, because 60s was when it was really big.
That's
but
right.
Yes, sir.
Yeah, so we're back in the 1960s as far as our title search. You would have that deed stay, and then how would, under your scenario, the new lawyer, never been to your town before, how would they have noticed not to carry over that language?
This law.
Okay, well, I understand this law. Is there a red flag put on the deed? How do I know, based upon your language, that this old deed from the 1960s that I just found in the book, that's got the offensive language on it, how do I know not to carry that? Yeah, not to carry it over.
Well, you're going to be on notice because it's going to be the law. As an experienced real estate attorney, you should be reviewing the documentation and doing a complete title search. So you should have that information. It's going to be, let's just say that it was the option that we've provided in the testimony that I've provided. It would be the grantee's attorney, along with in concert with the grantor's attorney, to make sure that these documents have been reviewed, that if the offensive language is addressed moving forward.
Okay.
I don't think it's too much to ask that the attorneys preparing a land transaction actually review the documentation that they're going to be recording. In fact, it should be clearly a requirement of doing land record law, anything to do with property law, anything that you're going to be bringing into my office for me to record. I'm hoping that it's been reviewed, and I would certainly hope that any type of derogatory and disgusting race-based or any other offensive language is being addressed. But at this point, there has been no way to do so. This law looks for a way to do that, and we applaud that. Just we are looking for a more appropriate way so that everyone can have a seat at the table, and all of the issues that we are concerned about as town clerks, along with the state librarian who was on earlier, along with Attorney Ware. There are quite a few other people who provided some written testimony. I mean, there are quite a few groups and people interested in this, and I think we all have the best interest of removing this discriminatory language. It's just how to do so moving forward.
No, I agree, and that's why I'm looking at your proposal, and I'm just trying to digest what the proposal would have. So, grantor, grantee attorneys, grantor being the one selling, grantee being the one receiving. Grantee goes and does the title search for their client. Want to see what encumbrances are there. They find the offensive language. They should know under the law that they are not supposed to carry that language over.
Assuming this is the law right now. This is not the law currently.
Understood. I'm looking at your proposal and trying to go through your scenario to see if this is a better way of doing this, because
yes, sir.
I'm I'm in support of the process that the underlying bill contemplates to strike the language from the record, not obliterate the fact that these bad things happened, have it go to the library, that kind of stuff. But what I'm hearing from you is the land records as they exist, that bad language would still exist. And it's incumbent upon the attorneys to make sure that that language is not carried over if the parties are even represented by counsel, quite frankly, because you can do a land transaction without a lawyer.
This is true.
Yeah. So if the public policy is to get rid of these things, I don't know how we would hold, the regular person to that standard also. But I thank you for the discussion. I understand your perspective. So thank you, Mr. Chairman.
Thank you.
Yeah, on that point, for both of you, I guess the other scenario that doesn't come up here is you assume there's a grantee. You assume there's a grantor, in the picture still, right? If I've been living in a house for 15 years and there's something on the deed and I just decide it just bothers me, I want it off there. How do you address that scenario under your proposal? There's not a land transfer. I own the house. I've been living there for 15 years.
I think it would be doable. A good attorney would be able to take care of that. I would say quit claim it, and then you could add this sub clause within it. I don't think it would be insurmountable. I really don't. And I think I do have a concern that Representative Fishman just brought up about perhaps no attorneys involved, but you're still held to the same standard in a land transaction as a non-attorney as if you were as an attorney. So you don't get special treatment, of course, because of the fact that you didn't hire an attorney to draft your deed. You still have to be able to do it the right way and follow the law. If this is the law, we would expect you as the drafter and as the grantee to be consistent and to be to review prior deeds and look backwards at what's going on and make sure you've had a title search. There are some hiccups here. I understand that. Absolutely. But we want to all just be able to sit down, and we really believe that to preserve historical information and not destroy the land records. And as an important point, and I'll just say this one last time, and I don't want to delay or keep this going on for too long. If as of right now that someone comes in and redacts that land record that's currently on file, I will not be able to certify that land record any further. because it is no longer the original. It has been changed, and that could lead to legal ramifications down the way for land transactions in and of themselves. If having to go to court, I could not certify a land record because it will have been changed, and that will be in direct contravention of the current status of land record law.
Representative Fishbein, your follow-up.
Thank you, Mr. Chairman. Stacy, just on that point, when you're certifying a document in the land record, I thought it was you're certifying that that is the document as it presently exists, as you are the official keeper of that document.
Correct. So if you make a change to that, I can't certify that anymore.
Well, but if we make a change to it by way of this legislation, then this body has authorized the official change of a previously official document for the purposes of public policy. And I would think you would be able to certify it because that is the official deed in your possession.
I think it'll take a lot more than that. I think we'd have to make some changes to the public, the library, the state library law, the laws that relate to land record recording, all the laws that relate to how I accept and file and move forward with land record documents. I just don't see it be as it's clear cut as you might suggest, respectfully speaking. That's why I think that there are hiccups and things that we need to discuss before moving forward with redacting documentation. Original documentation that once filed is forever.
Thank you.
Representative Doucette, briefly.
Yeah, real quick. I'm happy to work on this some more offline, but a couple of points. One, these restrictions, in my experience, usually appear in a separate document, a declaration of restrictions, which is an encumbrance, not part of the Schedule A, not part of the property description, but is actually an encumbrance that appears on title. So when you get your title search back, it runs with the land, obviously, and is an encumbrance until it's somehow extinguished. Now, to my earlier discussion with Mr. Ware, you could record an affidavit or something. You know, this legislation also contemplates a separate form that could be filed on the land records that effectively extinguishes that part of the covenant. In the same way that you may have the experience, I have it all the time, where you have a mortgage, it doesn't get properly released on the land records. You can effectively release that mortgage by the filing of that affidavit, and then that essentially clears it from title. So the physical document would not need to necessarily be removed, but that covenant would be sort of officially removed from the title. So I think that would be the distinction, and that would be an easier solution that wouldn't require, like we said, you know, the redaction. And then also I suspect that the town clerk might have a way to perhaps notate it on the indices, or, you know, that document which effectively removes the covenant would be part of the title and would be part of the index of the land records attached to that piece of property. So that in effect, you know, sort of nullifies the restriction. So I think it can be done, in other words, without having to physically remove or redact documents.
And I think that that's a great point. As you had noted with the affidavit idea brought forward by Attorney Ware in his prior testimony, not a bad idea at all, and will be perhaps more effective than what we have suggested. We are open to suggestions, absolutely, to protect the land records, but to extinguish this deplorable information from moving forward in history.
All right. In that vein, I'm going to keep us moving just because yeah, I knew we still have some folks to testify, but it sounds to me like between yourself, Ms. Yazbek, Attorney Ware, sounds like Representative Doucette, and if he's willing, Representative Fishbein, that you all need to get together quickly, because I do believe it's certainly my intention to move this bill out of committee next week. So because we can't drag our heels on this. So I suggest you all get together and speak later today or tomorrow, and hopefully come up with something so that we can get a bill out of committee next week. All right.
Thank you so much for your time. Have a lovely day.
Yep, sounds good. And Representative Doucette, sorry to voluntold you to head that up, but we'll look for your report back. All right. Next up will be Cindy Barone, followed by Ala Uchumare. Is Cindy Barone with us? I do not believe so. So we will move on to Ala Uchumare.
Thank you so much. Thank you so much for being here today. I'm here to testify originally for two bills, HB 6669 and 6667, but due to the amazing folks who've come to testify again for 6665, I also would like to stand in support for all three bills, considering that they are very deeply tied, although it looks very different. I think, and we all know, that it is definitely time for us to change the way that we criminalize young folks. Currently, children as young as 7 are being arrested. We know due to the testimony today that's come through various entities that the numbers are mollifying when you look and see who and why these young folks are being arrested. So I'm here and standing in support and solidarity and asking that this bill also be revised to explicitly decriminalize the emotional unwellness of young people due to poverty, due to this current pandemic that we are in, and due to the existing policies, racist policies of Connecticut and schools and almost every institution that we have here in Connecticut, as well as 6669, which would decriminalize and begin to provide us a way to look at things like car theft, which in some communities are considered a rite of passage and do not directly connect to young folks losing their lives. And in Black and Brown communities, we see that same rite of passage being criminalized. And although we don't want anyone stealing folks' property, we know that the loss of property does not directly correlate to folks losing their lives. So I'm not gonna take much more time from you today. We've been here on this call for a long time already. I am definitely open for questions if anyone wants to understand how I see the criminalization of young people on the ground. I work directly with young people and various entities here in Connecticut, and directly see the way that young folks being criminalized does not even begin to approach the pre-existing lived experiences of those young folks that directly correlate to their emotional unwellness and how that shows up in schools and society. And so thank you so much for the creation of this bill, and I encourage folks to dig deeper and really provide actionable ways for the decriminalization of young bodies and young folks. Thank you.
Thank you, ma'am. Questions or comments from the committee? If not, I appreciate you being with us today and for sticking on the call this long. Next up will be Quentin Rohr, who I don't believe is with us. Fernicia Smith.
Yes, hi, sorry, I'm here.
Okay, go ahead, ma'am.
Dear Chair, Senator Winfield and Representative Stafstrom and the members of the Judiciary Committee, my name is Fernicia Smith and I'm a Justice Advisor at the Connecticut Justice Alliance, also known as CTJA, and I'm writing this testimony to communicate my strong support for HB 6667, the JPOC bill. Specifically today, I'll be speaking about raising the minimum age of arrest. This issue is one that is long overdue, and it is quite shameful that it's something our society has to push for, as it is already not common practice internationally. In fact, it has been determined by the United Nations that the minimum age for court involvement should be at least 12 years old. As a child, our brains are not fully developed yet, making children incompetent to process what happens during trial, the rights that they have, or the legal ramifications that the arrest will have on them. To make matters worse, research shows that once someone enters the juvenile legal system, the chances of them re-entering the system or continuing through as adults increases. Majority of the arrests made on children are for misdemeanors and minor offenses that many times could have been handled without an arrest because, again, they are children and do not have the same ability to decipher right from wrong as adults with full functioning brains do. A simple childhood mistake could lead to an arrest that will forever loop that child into a vicious cycle of offenses that leads to them being incarcerated later on down the line. In addition to this, it's no secret that our legal system tends to target ethnic minorities more than their white counterparts. Research shows that 57% of kids under 12 arrested were children of color. The reasoning behind this is closely intertwined with the pre-existing injustices that exist within their communities, such as less resources to help families in need and less programs for children to avoid antisocial behaviors in the first place. So what we begin to find is that by keeping the minimum age of arrest at such a low number, there is even more opportunity for the system to get an early start on criminalizing youth primarily from Black and Brown communities. Think about how you would feel if it were your communities being set up for failure, with your sons, daughters, nieces, nephews, or even friends being targeted and swept into the system before they're old enough to understand what is going on. I urge this committee to vote in favor of HB 6667. Thank you for your time.
Thank you, ma'am, and thank you for your testimony. Representative Porter.
Thank you, Mr. Chair. Phoenicia, I just wanted to say hello and thank you for being with us today. Thank you for the work that you do as a youth advisor. The people closest to the problems, the closest to the solutions. And I just want you to know how much your lived experience and input is valued in this bill. And thank you for the work that you've done to help us get this bill before the committee. Great job.
Thank you.
You're welcome. Thank you, Mr. Chair.
Thank you both. Michael McDonough, I do not believe is with us. So Stephen McElhaney.
Can you hear me and see me?
We can. Go ahead, sir.
Thank you. Yes, my name is Stephen McElhaney. I'm an attorney in private practice in the state, and I have been for over 45 years. In those 45 years, I've had innumerable civil cases, trials, and opportunities to deal with judges over the question of what was the proverbial legislative intent. And so I come to you today just about some language on Bill 1093. That is the bill that is addressing police officers. So in addition to having been involved in the courts for all those years, I am now representing, in full disclosure, quite a number of the Connecticut police unions, and come to it with that perspective. So looking at two sections of that act, again, having to do with language. The first I'd like to address is section 1C1, which your explanation, you have a summary of what the bill is about. That is the section that you indicate provides explicit language for objection to and enforcement of a subpoena issued by a civilian review board. So it's within the civilian review board statute. My concern is over the language of that proposed bill. It breaks out, the part I'd like to focus on, it breaks out objections or motions to quash, we call them, for either the individual appearing before the board or documents appearing before the board. As to a person appearing before the board, the problem I have is the language is very restrictive. We in Superior Court have been dealing with motions to quash for decades. The judges have a great deal of body of law, appellate and court-wise on this, but the wording of this act is quite restrictive in regard to what judges do when judging whether or not a subpoena should be quashed. For example, on the subpoena of a person, It can be quashed only according to this language if the subpoena is both unreasonable and oppressive. So if it's oppressive, that's not enough. It has to be unreasonable and oppressive. That seems awfully restrictive. When it comes to documents, the materials can be suppressed if they are irrelevant, but nothing else. And if you'll notice, since, and this is the way judges interpret statutes, if they're looking at what the standard is for a person, it's unreasonable and oppressive, which means that if it's an oppressive subpoena of documents, that's not enough. And we all know that subpoenas can sometimes be fishing expeditions and throw out a broad net of oppressive information that is being requested. But that objection can't be raised because it's only if it's irrelevant. So we know that again, the Superior Court has been dealing with this issue for decades. They have standards, annoyance, embarrassment, oppression, undue burden, expense.
Sir, I hate to break it to you, but we're already at the 3 minutes. So I know you had a second point. So if you could just get to that.
All right, the second point, I'm sorry, is body worn cameras. I know it's well intended. Section 2F2 is giving to officers the ability to see a video before it goes public, but the section doesn't have anything in there about notice to the office that the request has been made. The officer can't possibly get a chance to see the video unless the officer is first notified the request has been made.
So let me ask you this. So is it your testimony that we would be better off without these two sections?
Oh, no, absolutely no. Well, what I would suggest for the first is you just refer to the Superior Court rules. A motion to quash can be made under Superior Court rules.
Okay.
And as to the second, all I would suggest is no, that I think it's a well-intentioned statute. It's intended to help officers, the second section about the body worn cameras. So I appreciate that. On the other hand, it just seems to be missing the piece that in order for the officer to exercise the right to see it first, the officer has to know that the request has been made.
All right. Yeah, I guess my perspective on certainly the first section of this is of course you can move to quash a subpoena. I think the existing underlying statute is clear enough, but and I think this just complicates it. But I get what you're saying. If you're going to do belt and suspenders, then the belt and suspenders should be repeat what's already in the practice book, I guess.
Or cite the practice book. But believe me, I've seen judges look at language like this and the legislature, oh, they didn't mean that. They only meant a reasonable and oppressive period.
Well, the problem with citing the practice book is, of course, the practice book could change, and then unless the legislature goes back in to change it after the practice book rules change. That's why we don't generally do that.
Yeah, we in labor relations deal with that problem all the time, and we say as currently configured.
Yeah. Okay. Seems to me the clearest way is to take it out, but I understand your perspective on it. Questions or comments from the committee? Seeing none, appreciate you being with us.
Yep.
Next up would be Dan Scavone.
Thank you. Can everyone hear me?
Yep, go ahead, sir.
Good afternoon, Senator Winfield, Representative Safstrom, and distinguished members of the Judiciary Committee. My name is Dan Scavone. I'm the CIAC Director of the Officials Association, and I'm also a 32-year former basketball official in Connecticut. So in my job and my role as in the CIAC with the Officials Association, we work with 50 local officiating boards across the state. And my testimony today is in support of SB 1088, Act of an Assault on game officials. So working with 50 boards, my primary role is in recruitment and retention of officials and helping those boards maintain memberships to be able to service our member schools. I can give you some data. We conducted a statewide survey in 2018 with all those local boards. And one of the things we found from that survey was 80% of our newer officials, years 1 to 3, do not make it to year 4. That's an astounding figure. And the primary reason is verbal and potentially physical abuse from spectators and other folks associated with the game. When you look at the 50 boards, 22 boards have lost members over the last 3 years. So they're showing decreases in new members. 21 boards have stayed the same. So predominantly there's only a handful of boards that have actually increased memberships. That's a startling figure, because I'm really worried that in time, we're not going to have enough officials to service our member schools, and it will also trickle down into other sports, youth sports, recreational sports at that level as well. Even at the collegiate level, we're looking at shortages at the Division II and III levels. I understand emotions are part of sports, and the saying is that sports will bring out the best in people, but it also brings out the worst in people in terms of certain behaviors. I know previous testimonies, I've been on all day. Some of my colleagues have talked about extending this bill to officials arriving at the game site as well as making it to their cars. I think that's key. I know my colleague, our executive director, Glenn Lingarini, talked about an appeals process. We do have a due process appeals process within our ejection policy that allows a coach or an athletic director to respectfully talk to an official at the conclusion of the game in their dressing area. From that point to the point where they get to their cars is a concern. I think the goal of this bill is to serve as a deterrent. It would send a strong message. It's been talked about in terms of the public notices that will go up along with this bill. I think when spectators are aware that legislation like this exists, I think it will increase sportsmanship across the board. And I also would like to see this legislation extend to coaches. I know previous testimonies talked about that.
So we're past the 3 minutes. I got a couple of questions for you. But let me start with Representative Fishbein.
Thank you, Mr. Chairman. Hi, Dan. How are you?
Good. How are you?
Good. I don't know. Have you been here all day listening to us go back and forth about this?
On and off all day. Yes, I have.
So, my sort of thing about this is, are the laws that we presently have, are they good enough? And you said that as a result of this law, that signs would go up, right?
Well, when I say public notice, I think in various ways, I think the information would go out to the public.
Okay, so
I think it was a Representative Gilchrist before that talked about possibly some signage earlier in the day.
Okay, and that might be, but my point is, what stops your municipality or whatever, it could be a private place, from putting up a sign presently that says assault of a sports official is a crime? Do not do that, because it is a crime. Like assault of someone is a crime. Threatening someone presently is a crime. So, you can put up a sign now without having us to pass anything, right?
That's true, but I that's a very good point. But I also think when we talk about the recruitment and retention of officials, I think the common knowledge that they are potentially when you talk about sport and the emotions of sport, that they are a specific target possibly. I think knowing that, having that comfort level that there is legislation to support them as a working class, I think that would help with more individuals going into the avocation of officiating and possibly staying with it a little bit longer. So I think it's more or less a helpful tool in terms of recruitment and retention of officials, to have them in that separated category in the sports field.
Okay, I understand your perspective. Thank you. Thank you, Mr. Chairman.
Dan, how long have you been with the CIAC?
This is my third year. Prior to that, I was a long-time athletic director. I've coached, and like I've said, I've officiated basketball for 32 plus years.
Okay. How many, in your career, how many times have you seen an official actually assaulted, not just threatened verbally, but physically assaulted?
In person, none, not in person, zero. I've seen videos of officials being assaulted.
See, because I guess that, I kind of, this may come as a shock to folks, but I tend to agree with Representative Fishbein on that I'm wondering if this is a bill kind of in search of a problem that, or maybe not that, but are we attacking this the wrong way? Because it sounds like to me that the instances of actual physical assault on an official are exceptionally rare, and there are laws in the books. That really the issue is out of control parents who are yelling, screaming, threatening, doing other things. And I don't know if it's criminal penalties or otherwise, but it seems to me that it's that what we need to be doing is stopping the behavior that could escalate up to something that would get to the level of an assault. No?
Yeah, and I think that's a good point. I think a heightened awareness. I think legislation like this would heighten the awareness. I'm not looking. I'm hoping that if this legislation goes through, I'm hoping that nobody is convicted of this type of criminal activity. Again, I'm looking at it as being a deterrent, heightening the awareness. I have seen, even myself on the basketball floor, I've had a parent enter the floor and approach me. Now, I'm not, I don't know what was going to happen at that point. We've had police escorts to a highway, so making it to the car was a difficult task. It only takes one extension of a verbal abuse to a physical abuse that could severely injure somebody or even do fatal harm. So again,
I don't disagree with you.
I think the laws on the books, and I imagine there's times where officials have been assaulted and might not have pressed charges at some point after some type of mediation. But I look at this legislation as being heightened awareness, a deterrent, hopefully to increase sportsmanship, positive sportsmanship across the board, and to hopefully give comfort levels to officials thinking about potential officials, candidates coming into this profession, that they have an added degree of support with legislation.
All right, thank you. Further questions or comments from the committee? Seeing none, appreciate you sticking it out with us.
Thank you very much.
Next up will be Erica Bromley.
Hi, good afternoon. Senator Winfield, Representative Staffstrom, members of the committee. My name is Erica Bromley, and I'm the Juvenile Justice Liaison for the Connecticut Youth Services Association. I'm here today to discuss HB 6667, recommendations of the Juvenile Justice Policy and Oversight Committee. I'm currently a member of the JJPOC, as well as a co-chair of its diversion committee, where some of these recommendations came from. There are a few sections of the bill I'd like to focus on. The first is Section 1 that raises the minimum age of jurisdiction from age 7 to age 12 by redefining the definition of a child. This change is a necessary one and one that follows the international standard. We know that young children should not be involved with the juvenile justice system and are much better served in their community. The diversion work group created an implementation plan to handle the under 12 population engaging in at-risk behavior. This plan identifies the community-based diversion system as the pathway for services for these children, along with the use of mobile crisis services and other necessary behavioral health interventions. The second is Section 21. This section looks to best utilize diversion while creating a specific pathway for those who engage in low-level misdemeanor behaviors. In February of 2021, the JJPOC approved a recommendation that had a two-tiered approach. The first tier was aimed at the lowest level misdemeanor offenses and are typically infractions. These included things like creating a public disturbance, simple trespass, and others. In those approved JJPOC recommendations, Tier 1 offenses would be decriminalized and would become non-arrestable offenses. The second tier addresses other common low-level misdemeanors, such as disorderly conduct, breach of peace, larceny in the 5th and 6th, and others. These would require a mandatory pre-arrest diversion to a juvenile review board or other diversion program for first and second time offenses. This option not only spares a youth from being arrested, but also aims to alleviate any discretion that would lead to different youth being handled differently. What I would like to point out, however, is that the language in this bill, lines 1582 to 1591, the language does not mirror the recommendations approved by the JJPOC. The language in this bill has both Tier 1 and Tier 2 as being diverted pre-arrest. Tier 1 offenses should be decriminalized altogether, meaning there would be no opportunity for arrest. Changing this language back to the approved JJPOC language is requested. With several of the changes in this bill, more work will be placed on the Youth Service Bureau system and on the JRB diversion process. The capacity to handle this influx of cases continues to be an issue absent any additional funding. Funds for the community-based diversion system and for the JRBs must be a priority if the state wants to continue to prioritize diversion and community-based services for youth. In my full testimony, additional background on the components of this testimony are further described. And before I conclude, I would also like to mention my specific support for sections 10 and 11 regarding banning the use of suspension and expulsion for grades pre-K through 12. This is an important step in reducing the school to prison pipeline, as well as moving from a framework of punishment into one of restoration. In closing, I'm in support of House Bill 6667 with the suggested changes to match the approved recommendations of the JJPOC. Thank you for your time, and I'm happy to answer any questions.
Thank you, Ms. Bromley. Is there a comment or question from members of the committee? Representative Porter.
Thank you, Mr. Chair, and thank you, Erica, for your testimony today and for the work that you continue to do with JPOC. I wanted you to just go back to your request to add back in the original language, lines 1582 to 1591. And can you just speak to why it is a critical component, right? The decriminalization process instead of what is being recommended in this language before us today.
Right. The reason behind this is that there were two tiers that were created, Tier 1 and Tier 2 offenses for the purposes of this recommendation. The first in Tier 1 was looking at infractions, and those are behaviors that are usually done by kids who will outgrow their behavior, are very low level. They have low or no risk in terms of if you were to send them to court. We know that over-programming of youth is also not helpful and is detrimental. And so involving kids with these low-level offenses in court really doesn't make sense, both on the fiscal side as well as on the developmental side, when we know that these behaviors are very, very low level and are often nuisance behaviors that youth will grow out of. There is also some language in the recommendations about the ability to make a referral to a youth service bureau for those youth if there are deemed, specific issues that may need to be handled that an officer or somebody responding thinks would be appropriate. So there is still a way of connecting them with community-based services. It's just not through the court.
Thank you for that response. And when you talk about low-level offenses and nuisance offenses, not necessarily what we would deem criminal. I often make the argument that we have criminalized childhood behavior. So can you just speak to what some of those give us some examples of what these low-level offenses are that these kids are actually being taken to court for? Because we know once you touch the system, it is very likely that you will continue to touch the system until you touch the adult prison system.
Right. I think two of the common ones that tend to come up are creating a public disturbance and simple trespass. So those tend to be, I think, when there's a nuisance behavior by a young person, that often those are just sort of arbitrary infractions that are given just because, opposed to just allowing the youth to go. So essentially, if somebody was being loud and obnoxious, then somebody might be able to come in and arrest somebody for creating a public disturbance or something like that. And what we know is that it's very disproportionate as well. So I think one of the key components of doing this is that this allows for less discretion. So whereas one youth might get arrested for it in one community who is Black or brown, that is likely not to happen in another community with someone who is not a minority. So I think this also has a lot to do with making sure there's less discretion, so all of our kids are handled the same, and it's not just the decision of how somebody feels on that day, opposed to what's the right thing to do.
All right, thank you for that, Eric. And again, I thank you for your testimony and your time today. Thank you, Mr. You're welcome.
Thank you, Representative Porter. Comment or question from members of the committee? Comment or question? I don't see any, Ms. Bromley. Thank you very much for your work and thank you for joining us.
Thanks.
Have a great afternoon. Next, we have Isaiah Ramos. Mr. Ramos, are you ready to go?
Chairman Streff, Strathstrom and Winfield ranking members.
Mr. Ramos, you're pretty low. You may want to speak up or move the mic closer to you.
I apologize. Is this better?
Much better.
Thank you, sir. Chairman Strathstrom and Winfield ranking members Kissel and Fishbein and esteemed members of the Judiciary Committee. Thank you for this opportunity to testify today in regards to HB 6667. My name is Isaiah Ramos, and my sister Liza Ramos was tragically killed on June 19, 2020. Her life was tragically taken from her, and as a result, my nephew Joshua was left without a mother at the age of 16. My sister was a wonderful woman and mom. What happened was my sister was getting a ride from an acquaintance of hers, and what I'm sure she didn't know was a stolen car. The suspect driving the stolen car was driving recklessly when he struck a pole, killing my sister instantly. The driver survived the crash, and when people rushed to the scene to help by calling the ambulance and police, the suspect's exact words were, "No, don't call the police, the car is stolen." And then he proceeded to leave the scene, and he also left my sister in critical condition where her life would ultimately end. While the suspect was not a juvenile at the time of this incident, I know that 6667 originates in part due to the increased number of stolen vehicles around the state. I know there are those that dismiss this as a minor offense, but I'm here today to remind the members of this committee that the motor vehicle larceny is not a victimless crime, and the reckless behavior can lead to tragic consequences, as it has for my family. Judicial consequences in our system should serve as a deterrent to others. When you consider this bill and the severity of the consequences related to these type of offenses, please think of my sister, my nephew, and our family. Please enact laws that will truly deter someone else, no matter their age, from stealing a car and driving it with the same reckless disregard exhibited by stealing cars in the first place. Please don't let another family share our experience. Thank you for your time and your service to the people of Connecticut.
Thank you, Mr. Ramos. Is there a comment or question from members of the committee? Representative Howard.
More of a comment, Mr. Chairman. Thank you for the time. Isaiah, I'm so proud of you that you came here and did that today. As you know, I'm a brother myself, and I know the bond that you had with your sister. And oftentimes, you know, in our judicial system, and sometimes even in this committee, we hear a lot of testimony, and we lose track of the victims that are associated with different types of offenses. So I'm so grateful that you had the courage to come here today and address this committee in this forum, and I think you did a great job. Thanks, Bob. Thank you, Mr. Chairman.
Thank you, Representative Howard. Representative Beach.
Thank you, Mr. Chairman. I just want to reiterate what Rep. Howard just said. Thank you for coming forward, Mr. Ramos. And I really am so sorry for your loss. Terrible, should never happen. Thank you.
Thank you very much, Representative Beach. Is there a comment or question from members of the committee? Comment or question? I do not see any further comments or questions, Mr. Ramos. Thank you very much for joining us to offer your testimony. It's important, and I hope you can enjoy the rest of your day. Next on my list, I have Kate Howard Bender, Eileen Keys, and Lauren Ruth. Kate Howard Bender, Eileen Keys. I thought I saw her name. Lauren Ruth. I think I see Ms. Keys pop up. Are
Hi.
you there?
Yes, hi, sorry. I wasn't connected when you were first calling me, but now it just popped up. Thank you.
You have your 3 minutes. You may begin.
Thank you. Good afternoon, honorable members of the Judiciary Committee. My name is Aileen Keys, and I manage the Connecticut Children with Incarcerated Parents Initiative. I'm here to testify in support of Senate Bill 1084 and in opposition to House Bill 6670, but I will reserve my remarks to Senate Bill 1084. To provide some background, in 1997, Congress passed the Adoption and Safe Families Act, which mandated that state child welfare agencies begin termination of parental rights in cases of children who have been in foster care for 15 of the previous 22 months. The intent was to prevent children from being in temporary foster placements for several years and to increase adoption outcomes. Despite the stated intent, the law may actually contribute to the permanent severance of parent-child relationships against the best interests of the child. With the average length of incarceration in a state facility being 34 months, the provision can be triggered by parental incarceration alone and has resulted in disparate negative impacts on children with incarcerated parents. Even when the parent has an active role in the child's life, incarcerated parents still find their rights being disproportionately terminated. Most shockingly, in an analysis of 3 million child welfare cases nationwide over a 10-year period, to identify the ramifications of ASFA on families with an incarcerated parent, mothers and fathers who have a child placed in foster care because they are incarcerated, and those parents have not been accused, much less substantiated, allegations of child abuse, neglect, endangerment, or even drug or alcohol use, were more likely to have their rights terminated as parents than parents who physically or sexually abuse their children. Tens of thousands of kids were placed in foster care solely because their parent was incarcerated, and for about 5,000 of those kids, or 1 in 8, their parents' rights were permanently terminated. Even when the parent attempts to remain engaged in services designed to support reunification and to demonstrate existing relationships, he or she may not necessarily be able to do so due to the restrictions associated with incarceration. I won't read the entire thing, but I will state that in recognition of the great harms that this unintended consequence imposes, more than 10 other states have passed legislation to address the ramifications of ASFA. However, Connecticut has not. Collecting the data that is proposed in this bill will allow Connecticut to see whether parental incarceration is having a disparate impact on termination of parental rights in this state. One request that I would like the committee to consider is adding the collection of data on the number of parents who had TPR filed, who served a term of imprisonment during their child's time under child welfare involvement, even if the parent is released at the time of the petition to file to terminate. There are parents who are released at the time of the petition being filed where incarceration was still a factor during the child's involvement with DCF, and we want to capture those cases as well, since incarceration really does limit a parent's ability to participate actively in the reunification plan designed by DCF and approved by the courts. And I will really leave my remarks there. I'd be happy to take any questions. Thank you.
Thank you, Ms. Keys. Is there comment or question from members of the committee? Comment or question? I do not see any. Thank you very much for joining us again, and hope you have a enjoyable rest of the day.
Thank you.
Lauren Ruth, you have your 3 minutes.
Good afternoon, Senator Winfield, Representative Staffstrom, Representative Fishbein, and esteemed members of the Judiciary Committee. My name is Lauren Ruth, and I'm testifying today on behalf of Connecticut Voices for Children, a research-based child advocacy organization working to ensure that someday Connecticut is a thriving and equitable state where all children achieve their full potential. Connecticut Voices for Children supports Senate Bill 1084, an act concerning the collection of certain data pertaining to parents who have had their parental rights terminated, and House Bill 6667, an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee. The first piece of legislation requires that the Department of Children and Families and the Department of Corrections report data pertaining to incarcerated parents and their children. The second is a sweeping piece of legislation that builds upon over 6 years of collaborative work done by the Juvenile Justice Policy and Oversight Committee work group members across the state. For the purposes of this testimony, I'll focus on Section 1, but our written testimony also discusses Section 2, 13, and 14, and we support the viewpoints expressed by our partners at the Connecticut Justice Alliance, the Center for Children's Advocacy, and the Office of the Child Advocate. Regarding Senate Bill 1084, the Federal Adoption and Safe Families Act of 1997, called ASFA, provides incentives for states to legally terminate the rights of parents when their children have spent 15 of the past 22 months in foster care. This piece of legislation ended up creating a 250% increase in the termination of parental rights nationwide for incarcerated parents, and has resulted in tens of thousands of parents across the country losing their parental rights. Severing parental rights due to a parent's incarceration may inflict lasting psychological harm to both parents and children, and it can compromise public safety, as maintaining family ties while parents are in prison reduces their likelihood of returning to prison after release. It also costs the state more money through children's extended time spent in foster care. States are able to modify how they implement ASFA by creating exceptions to the 15 out of 22 months rule, but unfortunately it's challenging to quantify the impact of ASFA on TPR in Connecticut due to a lack of data. The Department of Children and Families reports on TPR cases as part of the Child and Family Service review process, but that data does not connect with the Department of Corrections data to understand the reasons for moving TPR cases forward. Therefore, to understand the scope of this problem in Connecticut and guide future solutions, we're in strong support of this bill mandating the reporting of data related to TPR while parents are incarcerated. Regarding House Bill 6667, Section 1 effectively raises the age at which a child can become involved in the criminal legal system from 7 to 12, a change we strongly support. In fact, in 2019, the United Nations urged members to increase the minimum age of criminal responsibility to at least 14, which is a recommendation Connecticut Voices for Children strongly supports. There's a strong case to be made that young children do not meet the definition of competency to stand trial. In order for a person to be competent to stand trial, they must be able to understand the criminal charges against them, understand the implications of being a defendant in a case, understand the adversarial nature of the proceedings, understand the role of the, yes.
Your time has elapsed. If you could summarize, thank you.
Sure. So basically in Connecticut, an 11-year-old may not be able to read Diary of a Wimpy Kid, but currently can stand trial. It's clear from the data that Sarah Egan reviewed that removing children under the age of 12 from the criminal justice system is unlikely to increase public safety risk. It's developmentally and legally appropriate. And in data we reviewed within our written testimony, it's also likely to help reduce longstanding racial injustices. And I'm happy to answer any questions members have.
Thank you very much. Is there a comment or question from members of the committee? Comment or question? I do not see any. I want to thank you for joining us again to offer your testimony, and hope you enjoy the rest of your afternoon.
Thank you so much, Senator.
Next, we have William Roberts and Kelly, and then Kelly Orts. Mr. Roberts.
Hello, how are you doing? I'm sorry, I had to unmute myself. Good afternoon, senators and other esteemed members of the Judiciary Committee. I am here regarding HB 6669. Hold on a sec. Can you see me?
We can.
All right, I'm here regarding HB 6669. I looked at the long list of bills, and unfortunately, I don't have a lot of time to go through all of them. So I decided that this would be my focus right now. Regarding, I can only speak for what's happening here in Hartford regarding the juvenile matters as far as stolen vehicles. As I'm going through the bill, my concern is mostly on the fact that I see basically nothing but harsher punishments for juveniles. I also see what concerns me is that possibly a breach of privacy issues when it comes down to a juvenile is supposedly arrested, and the arresting officer wants to request information that goes beyond the scope of the criminal case from the parents. As far as like medical records, as far as like marriage certificates, bank accounts, stuff like that. Basically, I'm deeply concerned about that because this bill was not crafted appropriately. It was basically seemed like it was crafted to purposely attack the Black and brown community, and most likely the class of poor people, especially in inner cities. yes, we supposedly have a spike of juveniles stealing cars, but that spike for the statistics is only because of what's happening after the coronavirus. Another thing too is that there is no addressing as far as addressing the point where why are we even at this point? What has been done to prevent this even before we decide to automatically start going after juveniles, giving them more time, giving their parents more time. Like I've seen this cycle so many times. I'm 40 years old. I've seen this cycle so many times whenever the news media comes out with something, whether it's robberies, whether it's home invasion, the first knee jerk that everybody's response is let's just punish. We're now at this time right now where we're supposed to be reviewing these older laws and questioning why did we give so much time back in the 90s and early 2000s, yet this law is basically trying to punish people even further. Supposedly the police unions wanted to give the police stations more time, 8 months for more training, but here again, they're asking to create harsher laws and penalties for people, which does not make any sense. You can't ask for more training while simultaneously making it harder for people to fix or resolve this problem. I just see that this is a train wreck coming, and I deeply oppose it. I deeply oppose the privacy issues that
Mr.
we're not.
Roberts.
Yeah.
Your time is elapsed. If you would summarize.
I strongly oppose this bill. It makes absolutely no sense. It was poorly crafted, and it looks like it was aimed at certain cities. And before we can even step further about even addressing this, we need to start finding more solutions first. There was no steps in that. All right.
Thank you very much.
Yep, no
is
problem.
there comment or question for Mr. Robert? Comment or question for Mr. Robert? I don't see any. I want to thank you for joining us and taking your time to prepare yourself for this bill. I hope you enjoy the rest of your afternoon.
You too.
Is Kelly Orts in and available?
Hi, Senator Winfield. Yes, I am.
Yes, you have your 3 minutes.
Thank you for taking the time to hear my testimony today. My name is Kelly Orts, and I'm a staff member at the Tau Youth Justice Institute at the University of New Haven. House Bill number 6667, raised from the Juvenile Justice Policy and Oversight Committee, provides many new opportunities for Connecticut to become a leader in justice reform, including decriminalizing lower offenses and banning the use of chemical agents on youth. However, Connecticut is falling behind when it comes to the lower age of our justice system, which is why I'm going to focus my testimony today on the bill's proposal to raise the minimum age of juvenile jurisdiction from 7 years old to 12 years old. 7 is a very low minimum age compared to national and international trends. We as a state are already behind, as 18 other states have a minimum age that is higher than ours. Internationally, the United Nations Convention on the Rights of the Child declares that any criminal prosecution of a child under the age of 12 is unacceptable. In Connecticut, most children under the age of 12 are referred to juvenile court for misdemeanors. They are identified as low or no risk and ultimately get dismissed and referred back to community programming. Formally processing a child that puts them at risk for lifelong ramifications, including significant trauma and future criminal activity. This can be avoided by setting a developmentally appropriate minimum age and using the community-based diversion system as the primary response for delinquent behavior of any child under 12. Research shows that mental capacity, neurological development, and competency of a child is significantly less developed than an adult. An increased minimum age would acknowledge the scientific differences in cognitive maturity of young children, especially compared to their teenage counterparts. An increase in the minimum age of juvenile jurisdiction is long overdue in Connecticut, and if we want to remain a leader in juvenile justice reform, we need to amend this outdated legislation to become aligned with research and best practices from around the world. Thank you for your time and your consideration.
Thank you. Comment or questions from members of the committee? Comment or question, Representative Porter.
Thank you, Mr. Chair, and thank you, Kelly, for your testimony today, and for all the work that you do with us on the JPOC committee. You mentioned that we are behind the 8 ball on this, and that several states actually have ages that are higher than ours. Can you tell me what is the tier that? What's the highest age? Is it 12,
There are a few states that had their minimum age set at 12. Currently, Connecticut is 7, and we are among the lowest compared to other states.
Thank you. I appreciate that. I have to admit that I was quite shocked when I found out that in the state of Connecticut, we actually arrest and take kids 7 years old to court. I'll leave it there. Thank you again for all your work. Thank you for taking the time to be with us today. And thank you, Mr. Chair.
Thank you, Representative Porter. Comment or question from members of the committee? Comment or question? I don't see any. So I just want to thank you as well, Kelly, for the work that you do on the JJPOC, helping us to keep moving forward. Thank you for taking your time today, and I hope you enjoy the rest of the afternoon.
Thank you.
Next, we have Yarivet Velasquez, followed by Amber Blangus. Is Ms. Velasquez in and ready to testify?
Hello, I'm ready.
Okay,
Hi,
I can't. There you are. Go ahead,
Hi.
proceed.
My name is Yarivet Velasquez. I am 17 years old and I am a youth in the Center for Children's Advocacy. I will be talking about why is it important to expunge youth criminal records. Once they turn 18, if they don't reoffend up to that point, the government, I believe that the government's main point should be to make sure that these people are set up for success after their punishment, not to lead them to reoffend. Over 50% of my high school male classmates have at one point been arrested, and I'm talking about an age group of 14 to 18. Most of them start looking for jobs and start looking into colleges in their junior year, but having a bad criminal record can jeopardize that. So a small mistake they made at 14, 15, or 16 years old can have an extremely negative effect on their future. A job is going to prioritize a person with a clean record over someone with a criminal record. This then leads these teens to go out and hustle for money in a way that will lead them to go back to getting arrested. In order to keep this from happening, then the government has to take this bill into deep consideration. I do understand that they made choices that weren't the best and they don't have to be rewarded, but it is unfair for one mistake to affect their entire adulthood. They are kids, or at least that's how we're treated 99% of the time. But at the minute we make a mistake, they're fast to charge them with criminals charges as if they were adults. Let's keep in mind that the legal age to get charged with a criminal offense in Connecticut today, it starts at only 7 years old. So let's think about that for a second. A 7-year-old can be charged with a crime that he might not even understand, and he will carry that until he dies because he might not even know the proper process to be able to fight off the charge and get it expunged. I'm not even talking about felonies or sex crimes. I'm not talking about high qualified cases. I'm talking about minimum charges, mistakes that they made because they were just kids. Are they not worth another shot? Shouldn't the whole point of prison and holding people accountable so that they could learn from their mistakes? Why continue to punish them even after they paid their debt to society? What is the point of rehabilitation if they don't see a reason to change once their case ends? And I'll end it with that. Thank you for your time.
Thank you very much. Comment or question from members of the committee? Comment or question, Representative Fishbein?
Thank you, Mr. Chairman. Hi, Yarivet. How you doing? Thank you for, you're muted, but that's okay. How
are you?
Good. Thank you for coming here today. How old are you?
I am 17.
Okay. And have you been through the juvenile justice process? Like, have you been arrested for something and, you know, that kind of stuff?
I thankfully have not. I know a lot of people have family members who have at a young age. So that's why I'm speaking up on it right now.
Okay. And have you had the opportunity to go to court and to see, you know, with a family member or something like that, how the process actually works?
Yeah.
Okay.
And
what
I
court
study a lot of cases and stuff.
Okay. What court did you go to?
I usually went to the one in Puerto Rico, and I watch cases here. So I'm talking because in PR, they, as soon as they turn 18 and they haven't reoffended, their cases get expunged, they get erased from their records. So once I came here to Connecticut and I found out that's not the case here, and they have to go through another process. Many of us teens don't really understand, and many don't have the resources to be able to know that. So it really affected me, it really like messed my mind up, because many of them are going to get stuck with that crime record because they don't know the proper process. And the minimum age to get arrested right now is 7 years old. So a 7-year-old do not know the process to get that expunged, to get that erased from their record. So that's why I'm here today.
Okay, so who told you that the juvenile cases don't get expunged?
I was told, found out that they do get expunged if you go to court and you go to a whole process, and then it's up to the court's decision to do it or not.
Okay, and did they tell you about that process? Do you know,
Yeah,
do you
they told
actually
me
have, do you actually have to go to court?
I mean, you have to talk to somebody and start the whole process before that. I'm a teenager. I have a lot of friends who I talked to about that, who have been arrested for minor stuff. And when we talk, I say, oh, I found out that you can actually start the process to do that. And they tell me that they didn't know that, and they were not told that, and they don't even know the process. So
Okay, if I was to tell you that you don't have to go to court to get that expunged, would that be of solace to you? Would that be of comfort to you?
yeah.
Okay, because I have had that occasion where I just filed something with the court, the juvenile court, and I got something in the mail saying it's off of the person's record. So I think that's a good thing, right? That's something that you're looking for here, right?
Mm-hmm.
So I just, I thank you for coming here today to testify and to share your feelings on this bill. So thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from members of the committee? Comment or question? I don't see any. Ms. Velasquez, I want to thank you for joining us today. Not many 17-year-olds are thinking about joining the Judiciary Committee to provide testimony. And certainly even people older than yourself are nervous in doing so. And you did a fantastic job. And I also want to thank you for the perspective, because while there are processes that are in place that people can avail themselves of, this is about the knowledge that you have and or your community has. And when that knowledge isn't present, the justice system looks wholly different for certain communities. Again, thank you very much. I hope you enjoy the rest of your afternoon. Next, we'll hear from, thank you. Next, we'll hear from Amber Velanquez, followed by Kim McLean. Ms. Velanquez, are you in?
I'm here, yes.
Good afternoon. You have your 3 minutes.
Good afternoon to Senator Winfield, Representative Staffstrom, Vice Chairs Kisser and Blumenthal, Ranking Member Senator Kissel, Representative Fishbein. My name is Amber Velanquez, and I'm a resident of Sherman, Connecticut. I'm also the mother of 4 children. I'm also the executive director of the Restorative Action Alliance, which is a regional advocacy group made up of anti-carceral crime survivors, individuals who've been impacted by the criminal legal system, and restorative justice advocates and practitioners. I'm here today to express opposition to House Bill 6670, an act concerning a mandatory minimum sentence for injury or risk of injury to a child. At the Restorative Action Alliance, we firmly believe that all people, particularly children, should have the opportunity to be safe and remain connected to their families. This bill is absolutely counterproductive to this goal, in that it's often a parent or someone close to a child who's accused of or commits harm against them. A carceral approach to harm does not represent true accountability and often harms the child further. Our members from all walks of life have also seen the destruction that even a short time of parental incarceration can have on a child and a family. Incarceration of any time period can cause someone to lose their job, home, or even their parental rights. When this is a person that a child or a family depends on, it destabilizes the family unit, creating much greater harm. It has also become clear that the establishment of mandatory minimum sentencing has had unintended consequences of sending more people to prison in this country than any other nation in the world. So equally as unfortunate, we have found that persons imprisoned due to laws are disproportionately people of color and the poor. In a time where we're really recognizing that racism is a public health crisis, we need to be much more mindful of the consequences of laws that really are not written and fail to meet the purpose for which they were created. And we must never perpetuate a system that undermines equality. So we believe that removing the court's discretion in any case is simply a denial of justice. And we encourage this committee to look to restorative practices and oppose any mandatory minimum sentence that comes across your desk. We also want to say that we enthusiastically support the work of the JJPOC and HB 6667, and we oppose House Bill 6669, which represents a knee-jerk reaction to a perceived uptick, which is simply a shift, not an uptick. I'll summarize. Thank you.
Thank you.
Of crime. Because this bill has a foundation in the criminal legal system, surveillance and control, and we encourage the committee to look at root problems and provide support to young people rather than a criminal legal system approach. Thank you, and I'm happy to take questions.
Thank you very much. Comment or question from members of the committee? Comment or question? I do not see any. I want to thank you very much for your continued work and for joining us here today. I hope you can enjoy the rest of your afternoon.
Thank you so much.
Next, we have Kim McLean, followed by Ann Smith. Kim McLean.
Thank you. Good afternoon, Chairman Senator Winfield and Representative Staffstrom and members of the Judiciary Committee. My name is Kim McLean, and I serve as the Executive Director of the Community Associations Institute Connecticut chapter, and I have submitted my written testimony in support of HB 6665. There are currently over 5,000 common interest communities in the state of Connecticut with approximately 950,000 residents. These remarks are intended to articulate the impact this bill will have on those communities and the owners that have invested in them. CAI Connecticut applauds the Judiciary Committee for establishing a procedure which allows homeowners a simplified process for removing restricted covenants from their property deeds. We request, however, that this bill be amended for community association boards to also have a simplified process to remove antiquated and unenforceable discriminatory restrictions contained in covenants without a vote of the owners. Typically, associations have difficulty amending governing documents because often the required amendment process requires a vote of the majority, a supermajority of 67% of the homeowners for an amendment to be adopted, and the process which a board must follow to amend documents is an added and unnecessary expense to the homeowners. Currently, 10 states have passed a simplified process for association boards to remove these discriminatory covenants, and in 2021, 9 states have legislation introducing and considering enacting these processes into law. CAI Connecticut encourages that HB 666 include the ability for associations in Connecticut to do the same. To assist the committee, I have attached a recommended amendment to HB 666 that is considered model language that our organization has used throughout the country. We support the complementary legislation that would mandate the removal of discriminatory restrictions upon receipt of an individual owner's petition to the governing board of a community association or court to remove discriminatory restrictions. CAI Connecticut advocates for all communities to take immediate steps to remove discriminatory covenants and continue to promote racial equity. By amending HB 6665 to create a simplified process for association boards to amend their covenants, more associations will be able to write past wrongs. Thank you very much for your time and attention.
Thank you very much, Ms. McLean. And thank you for your testimony. You answered my question with the model legislation. Is there a comment or question from members of the committee? Comment or question? I do not see any, so I want to thank you very much for joining us this afternoon and offering your testimony. Next, we have Ann Smith. Ann Smith will be followed by Gemini Rory Smith and Patricia LaRossi.
Good afternoon, Senator Winfield, Representative Stastrom, and members of the Judiciary Committee. I am Ann Smith, Executive Director of AFCAMP Advocacy for Children. We are a parent-driven nonprofit celebrating 20 years of empowering families and engaging systems to improve children's lives. I'm here today to testify in support of House Bill 6667, an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee. AFCAMP continues to advocate for needed reforms in Connecticut's juvenile justice, education, and children's mental health systems. Although these are separate systems, there is interplay between the impacts that they have on children and families. Many of those impacts produce disparate outcomes for children of color and children with special needs. HB 6667 reflects recommendations of the Juvenile Justice Policy Oversight Committee, JJPOC, that begin to address some of those interrelated and inequitable outcomes, particularly those with the education and juvenile justice systems. AFCAMP is supportive of the overall goals of those recommendations that flow from the work of various JJPOC work groups. I will focus here on certain bill proposals stemming from the Education Work Group and the Community Expertise Work Group. AFCAMP participated on the JJPOC Education Work Group and has been integral to the development of a Parent and Community Expertise Work Group. This last work group was an effort to bring to the decision-making process around design and implementation of services the perspective of individuals receiving those services from those systems or impacted by the juvenile justice and education systems. To fully accomplish that goal, Section 2 of HB 667 would provide for the appointment of 2 parent representatives and 2 youth representatives as voting members of the JJPOC. I would encourage that funding also be included to support stipends for transportation, childcare, and active participation on the JJPOC. With regard to the interplay between the juvenile justice and education systems, Section 3, 4, and 5 would create an implementation team within the Department of Children and Families and require development of an operational plan for oversight of the education of any child who resides in a juvenile justice facility and any child incarcerated in an adult facility. Transition specialists would facilitate connection to education, including special education services.
Ms. Smith.
For students, I will wrap up.
Thank
For
you.
students entering and exiting justice system custody. AFCAMP is involved with a number of boards and committees addressing the juvenile justice, education, and mental health systems in Connecticut. HB 667 takes steps towards mitigating some of the adverse outcomes resulting from gaps in coordination and integration of services within those systems, especially those outcomes that impact students of color and students with disabilities who end up in the juvenile justice system. We support HB 6667 and are committed to working with systems and the legislature towards improving children's lives. I'm available for any questions.
Thank you
Thank
very
you for
much.
the opportunity to provide testimony.
Thank you. Comment or questions from members of the committee? Comment or questions? I do not see any, but I would like to thank you. I know the continued work that you are doing. It is important, and you provide a voice in many respects with the work we do, but particularly now with the JJPOC. So thank you very much for that work, and I hope you enjoy the rest of your afternoon.
Thank you, sir. Thank you.
Next, we have Gemini Rory Smith, followed by Patricia LaRossi. Is Gemini Rory Smith in? Ready to go?
Hi, can you hear me?
I can hear you. You have your
Thank
3
you.
minutes.
Huh? Okay, I'm sorry about that. All right. Dear Chairs
And
Winfield
just for your information, your camera is off if you turn it on, but you may continue.
I'm sorry about that. Oh, you know what? As I'm reading my testimony, unfortunately, my camera gonna go on.
It's fine. It's fine. It's fine.
Sorry about that. All right. So, dear Chairs Winfield and Storm, and members of the Judiciary Committee, my name is Gemini Rory, and I am a Justice Advisor with the Connecticut Justice Alliance. The CTJA is a statewide youth adult partnership working to end the criminalization of youth using advocacy, organizing, and policy tools. I'm here to communicate my strong support for HB 6667, especially banning the use of chemical agents in the Department of Corrections. When tear gas was invented, it was initially developed as a chemical weapon for military use. Now it's being used in our prison systems for a diffuse tactic. It can cause blurred vision, burning in excuse me. Yeah, burning in the nose and mouth. Sorry about that. For people who have respiratory conditions, it can be life-threatening, causing them to have an asthma attack. Chemical agents are used primarily for fights. I believe there can be better diffusion and de-escalation tactics, more services to keep order in the prison, especially when we are dealing with our youth. Between February 11th, 2019 and November 6th, 2019, there were 18 young men subjected to chemical agents alone. Prisons is rehabilitating people and preparing them to integrate back into society, but using the same chemical agents that were once used to frontline a war at the same time, I don't believe is able to rehabilitate individuals. Sincerely, Gemini Rory, Justice Advisor.
Thank you very much for offering your testimony. Is there a comment or question from members of the committee? Comment or question? I do not see any. I want to thank you very much for joining us this afternoon and offering your testimony. Thank you. Have a great afternoon. I see that Tara Lynn has joined us, so we'll next hear from Tara Lynn and then Patricia LaRossi. Is Tara Lynn ready to go?
Yes. Can you hear me?
You may begin. Yes, I can hear you. You may begin.
Senator Weinfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. My name is Tara Flynn, and I am from Naugatuck. I am an advisory board member and a co-chair of the Advocacy Committee with Jane Donna Moore, also out of Naugatuck. I appreciate you taking the time to listen to why I support the passage of HR 366 and hope you do the same. This is simply another step in the right direction of protecting victims' rights. Passing HR 366 would ensure that survivors are not re-victimized by the criminal justice process. Providing a victim their due rights should not interfere with the criminal conviction. I feel like this is not passed. It may make a victim give a second thought to reporting the rights violation. Sorry, is there background?
I don't believe so. Keep going.
Okay. This is once again silencing the victim. I feel like if this is not passed, it may make a victim give a second thought to reporting a rights violation out of fear it could affect their perpetrator's sentence. This is once again silencing the victim. In addition, it would just be an excuse for a suspect to appeal if the victim's rights were violated. How does that make sense? When all of a sudden did a perpetrator care about the victim's rights? It seems like only when there's a positive outcome for them is when they do, which is convenient. I am here pleading with you to continue moving in the right direction for survivors. I, like far too many others, am a survivor of childhood sexual abuse. The man whose children I babysat for as a young teen assaulted me multiple times. He was a serial offender who went on to assault others and was ultimately sentenced to just 5 years for his crimes. I wish I could tell you that I was afforded any rights during the criminal process, but I was just 16 years old with little for a support system during the most traumatic time of my life. I do not remember having much say in anything, but I do know this. If there was a way for me to go back and submit a rights violation, but that meant it could possibly vacate my perpetrator sentence, I wouldn't. Violated, confused, afraid, embarrassed, ashamed, and alone are just some of the feelings a survivor of sexual crimes have. Constantly fighting to keep victims' rights current and enforced is extremely triggering, but so important because if we do not, who will? It can be so frustrating to come here as a survivor, begging and pleading with legislators to do just what's right for the victims and our rights. I completely understand that perpetrators have constitutional rights too. We all should. However, I 100% agree with Senator Champagne's sentiments about victims' rights seeming to be second class. We have been victimized enough by our perpetrators and the crimes that we have survived. Why must we add to it? I did not ask to be a victim, and honestly tried everything that I was taught not to. Nevertheless, we all know that some things just can't be prevented. So here we are trying to make right of so much that has gone wrong. I understand that no one on the committee
Ms.
could
Flynn?
have been there to fight for my rights when I was being held down and raped as a child. But that doesn't mean that we cannot work towards my rights being upheld now and also preventing future
Ms. Flynn?
victims' rights. In conclusion, I once again ask you to please vote to support HR 366 and continue fighting for what is right. Thank you.
Thank you very much, Ms. Flynn. Is there comment or question from members of the committee? Comment or question? Representative Gilchrist.
I'm sorry, what was that?
Thank you, Mr. Chair. I have a comment, Ms. Flynn. Thank you so much for being here and sharing what you went through to advocate on behalf of others. And I'm sorry that you did experience that. Thank you again for being here.
Thank you.
Thank you,
Thank
Mr.
you,
Chair.
Representative Gilchrist. Is there comment or question from other members of the committee? Comment or question? I do not see any. I would just like to align myself with Representative Gilchrist and thank you very much for sharing what I know to be a difficult testimony, and we appreciate you for it and hope you can enjoy the rest of your day.
Thank you.
Next, we have Patricia Larossi. Is Patricia Larossi in and ready to testify?
Yes, thank you so much.
Thank you. You have your 3 minutes.
Thank you. Thank you, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. My name is Patricia Irachi, and I currently reside in Meriden, Connecticut. I'm an advisory board member and co-chair for the Advocacy Committee for Jane Doe No More out of Naugatuck, Connecticut. And I also hold a master's in mental health and clinical counseling and in speaking in support of the HGR number 366. I am a survivor of sexual assault and understand that providing a victim with their due right should not interfere with a criminal conviction. However, we need to maintain and improve the rights of the victims as it pertains to the court proceedings. A victim without the right or opportunity to effective communication with the prosecutor or input regarding a plea can leave a victim feeling as if the system failed them and perpetuates the trauma cycle that they are in because of the crime that was committed against them. Victims experience a varying amount of mental health challenges in conjunction with the physical trauma, and it is important to ensure that their rights are not violated and that if they are, there are still resources available for them to seek justice. Jane Doe No More is an established not-for-profit organization that works to empower survivors of sexual assault. And more often than not, when speaking with individuals who are survivors, who did not report, or for those who did report and experienced any violation of their rights, the reason they chose not to pursue further help is because of the frustration that they have already felt with the lack of enforcement of their own rights. We have a need to repair and continue to empower the confidence of victims and the rights that they should have in the judicial process. HJR 366 is a step that we need to enforce the necessary rights of the victim by eliminating any restrictive barriers for them. While there is more work needed, HJR 366 is the beginning, and I, as well as all of the survivors across the state and part of Jane Doe No More, are urging for your support of this bill. So thank you so much for your time and consideration.
Ms. Irachi, thank you for your time. Is there comment or question? And let me apologize for messing your name up. I thought there was a lowercase L. Is there a comment or question from members of the committee? Is there comment or question? I do not see any. I want to thank you very much for joining us and offering your testimony. It is important to the committee, and I appreciate you and hope you enjoy the rest of your afternoon.
Thank you. You as well.
Thank you. Madam Administrator, I believe that puts me at the end of my list. Am I correct? Is there anyone left to testify?
You are correct. There is no one left waiting in the waiting room to testify.
Okay, well, that brings us towards the end of this hearing. I want to just remind committee members that while we will not be having a hearing or a committee meeting on Friday, we will be in next week, likely every day. So it's going to be a long week. Prepare. If you have time to rest. Yes, Representative O'Day.
I was just going to say, for those of you practicing religion, Easter is your holiday for you. Happy Easter, everybody.
Yes, absolutely. Happy Easter to those who are practicing. I would also ask before we conclude, Representative Staffstrom or Representative Fishbein, if they have any parting words.
Enjoy the weekend. We will see you next week.
Representative Fishbein, anything? Okay. Well, it seems like we're at a conclusion to this hearing, and we will see you next week a lot. Have a great weekend. Happy Easter.
Thank you.